Please be seated. The Supreme Court chamber is now in session, and this is our third day, that is the 18th August 2021. There is a replacement of a greffier from Mr. Khieu to Mr. Pon Thun. And greffier, could you please report the presence of the parties?
We have the National Co-Prosecutor, Chair Leng. We have the International Co-Prosecutor, Brenda J. Hollis. For the co-lawyers, for Mr. Khieu Samphan, we have Kon Sam-un and Onta Gise. For this, and we have the accused present today, Mr. Khieu Samphan. For the civil party lead co-lawyers, we have Pinch An and Megan Hurst. We have participation of 5 civil parties, Mr. Vatbun, Madame Mokpala, Madame Penson, Madame Bun Sam-un, and Madame Batlum. Mr. President.
I would like now to invite the co-rapporteurs to read the co-rapporteurs' report for the session on a ground of appeals relating to Khieu Samphan's individual criminal responsibility. Thank you.
Good morning, everyone. This is the report prepared jointly by Judge Som Saravut and me, Judge Clark. The trial chamber found the accused responsible for the crimes previously outlined under 2 modes of liability: joint criminal enterprise, or JCE as it's known, and aiding and abetting the crime against humanity of murder outside joint criminal enterprise. First, he was convicted under individual criminal responsibility through his participation in the common purpose and sharing the same criminal intent of a joint criminal enterprise. These convictions were for crimes perpetrated in the course of the implementation of the 5 policies of the Communist Party of Kampuchea throughout the democratic Kampuchea regime. These policies were: 1, the movement of population from urban to rural areas and within rural areas; 2, the establishment and operation of cooperatives and work sites; 3, the establishment and operation of security centers and execution sites; 4, the targeting of specific groups, namely the Cham, Vietnamese, Buddhists, and former Khmer Republic soldiers; 5, the regulation of marriage. The accused's individual criminal responsibility for the crimes as a member of the joint criminal enterprise was on the basis that he shared the direct, discriminatory, and specific intent of other members of the joint criminal enterprise. The trial chamber found that by the 17th of April 1975 and continuing until at least the 6th of January 1979, the accused, as a senior leader in the hierarchy of the Communist Party of Kampuchea, shared with other senior leaders of the joint criminal enterprise a common purpose to implement a rapid socialist revolution in Cambodia through a great leap forward, designed to build the country, defend it from enemies, and radically transform the population into a homogeneous, religionless Khmer society of worker peasants. The trial chamber found that this common purpose was not necessarily criminal in itself, but its successful implementation ultimately determined the criminal character of that common purpose, as it, to quote, was contingent upon the execution of harmful policies and the elimination of all counter-revolutionary elements. The trial chamber found that the accused's role in the common purpose was through his significant contribution in publicly supporting, promoting, and endorsing its objects through his senior positions within the CPK and the DK, and by his personal leading of sessions and rallies instructing, enlisting, and producing support for those CPK policies. Secondly, the trial chamber found that in his senior positions within the hierarchy of the CPK, the accused had aided and abetted the crime against humanity of murder with dolus eventualis at various crime sites. The accused always denied that he had a senior position or role in the CPK, or that he had any knowledge of what was occurring in DK outside of his limited sphere of responsibility for ordering and distributing essential goods such as medicines, as the liaison between Prince Sihanouk and the CPK, and as titular head of the DK. He raises various grounds of appeal in relation to his convictions under both modes of liability. Regarding his liability under joint criminal enterprise, the accused raises many arguments against the trial chamber's approach to the evidence and to its findings, which may be grouped and summarized as follows. The first group of arguments relates to the legal foundation of the concept of joint criminal enterprise liability. The accused argues that the trial chamber committed various errors. The first error occurred when the wrong legal standard was applied to assess the link between the direct perpetrators and the JCE participants. He submits that when such a participant is held responsible for acts committed by other perpetrators, a strict definition of the common purpose is required. It is not disputed that the purpose of a joint criminal enterprise can evolve over time, so that additional crimes may be included in that common purpose. But he argues that such evolution and the point at which the JCE members became aware of the commission of additional crimes was not described with any precision by the trial chamber. Second, the accused takes issue with the concept that crimes committed pursuant to a joint criminal enterprise could be committed by omission. Third, he argues that the trial chamber erred by lowering the standard of the necessary direct intent to commit a crime. The second group of arguments relates to the common purpose. The accused submits that the trial chamber committed three errors. As the common purpose identified by the trial chamber, the implementation of a rapid socialist revolution, was not criminal in itself, the trial chamber was in error when it found that the common purpose became criminal because the crimes committed during DK, rather than by examining the non-criminal CPK political projects. Next, the trial chamber lowered the requirements for liability under that JCE as it determined the criminal nature of a joint enterprise on its policies rather than its common purpose. The third group of arguments concerns the findings of the accused's contribution to the implementation of the common purpose. First, he submits that the trial chamber erred in fact, as there was insufficient evidence to find that he significantly contributed to the crimes or that it failed to substantiate that significant contribution, a necessary element of liability under joint criminal enterprise. More specifically, he argues that his association with members of the Standing Committee is insufficient to establish significant contribution to the criminal aspects of the policies. Secondly, he disputes the sufficiency of the evidence for the specific factual findings on his role and his powers within the CPK and the DK regime. Third, he submits that its assessment of evidence to establish his contribution to the JCE was biased and selective. This chamber welcomes specifics on the last issue. The last group of arguments relates to the accused's knowledge of the crimes. Recalling that JCE 1 requires direct intent and thus knowledge of the crimes, he argues that he has consistently submitted that he did not have any knowledge of the crimes, and in particular, he was unaware of the working and living conditions imposed at the cooperatives and worksites. He submits that the trial chamber generally failed to appreciate the strict principles of secrecy under the Democratic Kampuchea regime, and that the findings regarding his awareness or knowledge of the CPK communication system were in error. He argues that he had no actual knowledge of the crimes perpetrated across the country. Turning to his liability for aiding and abetting, he argues that the trial chamber's findings are tainted by several errors of fact and law. He raises two main arguments. First, the trial chamber incorrectly defined the mens rea of aiding and abetting. While it adopted the standard that for an accused to be guilty of such accessory liability, he must know that a crime would likely be committed, the trial chamber then unjustifiably applied a lesser degree of intent, which was not covered by customary international law as it stood at the time that the crimes were committed. He particularly disputes the trial chamber's reliance on the ICTY appeals chamber's conclusions from Frunzia, Akayesu, and Blaskic on aiding and abetting. He challenges the trial chamber finding that the mens rea of aiding and abetting was established. The finding that he was at all times aware of the essential elements of the crimes committed by the direct perpetrators is rejected, and he submits that the evidence supports his claim that he was not aware of the real likelihood that deaths would result from the conditions imposed at the charged worksites and cooperatives, nor was he aware that murders were committed at the charged security centers and execution sites. The accused may wish to direct the chamber to this evidence, which it is alleged supports his claim that he was unaware of deaths and killings at those sites. He then says the trial chamber erred in finding that the actus reus of aiding and abetting murders with dolus eventualis was met at various worksites and security centers. The accused disputes the trial chamber's findings that moral support, implicit encouragement, or practical assistance to decision-making bodies of the CPK and visits to some of these sites had a substantial effect on the commission of these murders. Lastly, he argues that his mere attendance at meetings does not amount to aiding and abetting. Again, he disputes the lawfulness of the reliance of the trial chamber placing on Frunzia, Akayesu, and Blaskic decisions on aiding and abetting. This concludes our report on the grounds of appeal relevant to individual criminal responsibility. But while I have the floor, I would like to remind the defense team that on a number of occasions in our report, we have specifically asked that the defense would focus on pointing out to this chamber the exculpatory evidence, which is alleged in very many places, was ignored by the trial chamber, And I think we've asked the same questions in this report to direct us specifically to the exculpatory evidence that was ignored. I'm not expecting you to answer now. Perhaps you'd be able to answer those questions tomorrow. Thank you.
I would like to hand the floor to the defense for Khieu Samphan to make submissions. Thank you.
Bonjour, Monsieur le Président.
Mr. President, Your Honors, I thank you for giving me the floor for this extremely important theme. And I must say that I am approaching this theme of the individual criminal liability of Mr. Khieu Samphan with the clear awareness of how difficult this task is, because it's not easy to stand twice before virtually the same judges and at the same time hoping for a result that would be different from the previous time they found on the same legal issue. Furthermore, tackling the issue of the JCE, similarly to that of murder with dolus eventualis, also requires us to explain why we believe the Supreme Court erred in trial 0201. And it's never an easy matter to tell judges who hold in their hands the fate of the accused that you represent that you think they've erred. And I'm, in this connection, reminded of what was said by another magistrate who summarized perfectly the kind of duty that is mine today. Justice Moloto, a South African judge at the ex-Yugoslav tribunal, said the following: the main important function of the defense counsel, that the defense counsel must think of at all times, is the very obvious one. Defend your client. Defend your client to the best of your ability. Refuse to be browbeaten by anybody in the exercise of that duty to your client, whether that person be from the prosecution, be a judge, or be any other counsel. Your job is to defend your client, and at the end of the trial, whatever the result, if you can say, I couldn't do any better, then you are entitled to peaceful sleep. So I shall do my best not to be intimidated by my own misgivings. And I keep in mind the guarantee of your own freedom of spirit that was mentioned by the special judges panel. It is in that spirit that I shall now mention the different modes of liability retained by the Chamber against Khieu Samphan in the species of the JCE and aiding and abetting. I shall begin with the JCE. The co-prosecutors and magistrates of the trial chamber and of the Supreme Court were faced with a dual difficulty. First of all, the common purpose as defined in the indictment of the co-investigating judges, that one was not criminal. It was a political project. And secondly, the trial chamber had concluded that the third category, criminal enterprise, was not part of international customary law at the time of the facts. For us, these two difficulties are central to all the mistakes that have been made in the decisions handed down regarding the liability of Khieu Samphan at the trial or at the appeal stage. Either there has been an attempt to get the crimes included in the JCE, or including the specific probability of JCE3, having that included into the constitutive elements of a JCE1. And that is what, in our final brief for 0202, That is what we had called a hybrid joint criminal enterprise. Now, to overcome these two difficulties, the trial chamber, followed by the Supreme Court chamber, ventured into redefining the constitutive elements of a JCE. The Supreme Court, in its ruling 0201, broadened the moral element of JCE, of the type 1, and by including the idea of dolus eventualis. The trial chamber, in its judgment 0202, did not do that because redefining JCE1 would be contrary to the law. But to achieve the same result, that chamber redefined the common purpose. So in both cases, Khieu Samphan is found guilty for crimes to which he did not directly make a contribution, for which he never had the necessary moral element, and when those crimes were committed by persons over whom he had no control. We have an argumentation on all this in our brief, Paris 1947-1953. First of all, and correctly so, the trial chamber did not follow the interpretation of the Supreme Court. And I refer you to the motivation of the judgment in paragraph 3715. The chamber stated in terms of the intention of a JCE that it does not follow the interpretation of the Supreme Court. Consequently, and then in agreement with the defense of Khieu Samphan, the chamber believes that the degree of intent required for the first category of JCE to be present, that requires direct intent. The chamber, the trial chamber, returned to formulating a correct legal criterion by criticizing the analysis of the notion of direct intent of the prosecution, and I refer you to the judgment paragraph 3716, where reference is made to the final conclusions of the prosecution. And the chamber states, thus, the standard described by the co-prosecutors as second-degree direct dolus directus actually corresponds to a degree of intention that is below that of direct intent, which is actually closer to notions of deliberate carelessness and dolus eventualis. Having said that, it redefined the common purpose to characterize a project involving or implying crimes in the sense that it must be committed, meaning dolus directus of the second degree. And here I refer you to para 4068 of judgment 2.2. The chamber considered that it is an established fact that these policies were intrinsically connected with the common purpose and implied the commission of crimes, the perpetration of crimes. It thus considers that the JCE, that the common purpose was intrinsically of a criminal nature. Consequently, here we have a broadening of the category. In our appeals brief, we criticized this idea of policies intrinsically connected with, which involve the sense of broadening the common purpose. And in our brief, I would refer you to our paragraphs 1968 to 1980 and 1981 to 2007. By way of response, the co-prosecutors contended that and this was in their response para 954, they contended that the defense, and I quote, is limiting its legal analysis to a JCE in which the common purpose is consisted of the commission of a crime, instead of considering the JCE to which he actually did participate, which implied the perpetration of crimes, end of quote. So according to the prosecution, even if the common purpose is not criminal, if a crime is a means of reaching your objective, so if there is a goal to establish a socialist revolution, this must be assessed as an objective jointly with the means to achieve it. In other words, the policies of CPK, which are concerned by the second trial in file 2. But we believe that there is no demonstration of a direct causality link. The participation in a project of a socialist revolution would inevitably involve the definition and application enforcement of policies as defined by the Chamber in our case file. It is not demonstrated by the prosecution how such a means was the only possible means that would make the crimes inevitable for the achievement of the goals pursued, such as forced transfers of people when the objective is to constitute forcefully or coercively a territory that is ethnically homogeneous. Furthermore, in case file 2, it is clear that the means that could be used for a socialist revolution were not unequivocal and not monolithic. There is thus no direct link of causality and inevitability between the objective, the project of a socialist revolution, and the means defined by the Chamber and the co-prosecutors. So once again, in terms of the defense of Khieu Samphan, we disagree with the notion that the policies of the CPK that were known to Khieu Samphan and the project of socialist revolution familiar to him were in correspondence with what is implied in this case. Now, the prosecution believes that separating the policies of socialist revolution would involve an illogical distinction. Paragraph 955 in their brief. According to them, and I quote, the fixation of the defender, of the appellant, on an alleged project that would allegedly have been benevolent and non-criminal, his fixation on the fact that the crimes were only undesirable consequences in the application of the joint project. This is not pertinent. So what we see is that the project for a revolution that he believed in does not correspond to what was described by the prosecution and thereafter by the Chamber.
De causalité et cette notion d'inévitabilité.
And this causal link and concept of unavoidability being linked should have been at the heart of the demonstration of the prosecution. But the prosecution did not wish to do this because, in effect, it doesn't really believe in this position of the Chamber because it had a different one throughout the trial. And here, I would like to refer you to the appeals brief which was prepared by the prosecution in trial 2-1, where throughout their contentions in that brief, that is document F11 paragraph 1, it said that the trial chamber had committed an error of law by excluding the possibility that the accused high-level leaders of the regime of Kampuchea Democratic were recognized as being legally or criminally responsible in agreement with the theory of joint enterprise for having perpetrated crimes, given the fact that they had contributed to the common project of which they could not reasonably predict that crimes would flow that were not explicitly part of its objective or goal. And so today they find themselves faced with the need to endorse an argumentation of the trial chamber which they don't really believe in. In Tutu, the prosecution at times concludes that the perpetration of crimes was the result of simple probability. And here I refer you to paragraph 914 of the rejoinder, where the prosecution says, it is therefore rightfully that the chamber ruled that the appellant was aware of the preparation of plans and that they would be implemented and that there was a real probability that crimes would be perpetrated. And here we see quite clearly the discomfort of the prosecution, which is unable to demonstrate the inevitability of crimes flowing from the project in the sense of dolus directors. Therefore, at times, they stay on the position of dolus eventualis, hoping that the chamber of the Supreme Court will say that they were right by reasserting its erroneous definition of JCE1, which was found in its ruling of 021. However, the mode of responsibility with dolus eventualis is incompatible with the perpetration of a crime requiring dolus specialis, such as persecution or genocide. By introducing dolus eventualis in JCE1, the chamber cannot convict for these crimes. And therefore, our contention in this regard is that the chamber of the Supreme Court must abandon its definition of JCE1 given in the conclusions of 021. Why? Because the definition of JCE1 given by the Supreme Court chamber in case file 0201 is based on a partial and erroneous understanding of the post-war jurisprudence and the Tadic jurisprudence. And this is what we said in our final brief for 0202, and the chamber, in fact, agreed with us on this point. The position of the architect of JCE itself. It is interesting to recall that the architect of the JCE himself and his amicus curiae to the ECCC, Professor Kasese, used the example of population transfers and armed robbery used by the Supreme Court in its demonstration relating to the moral element of JCE1, the mens rea of JCE1. And he also used the example of the displacement of civilians, the judgment of 0201. He used them to illustrate the moral component of the JCE of a third category, and that is a means of saying that the formulation and definition as they had been offered in ruling 2.1 in fact corresponded to this. In trial 2.1, the Supreme Court explained and that's paragraph 807 of the judgment, that it is important in the utmost to know the criteria which make it possible to identify crimes which are part of a JCE. And it's settled by saying that it was a purely factual appreciation. And I quote, to know whether a crime is or is not taken into consideration in the common purpose is first of all a question of facts, which must be examined by taking into account all the relevant circumstances, and particularly the overall objective of the common purpose and the probability of achieving this objective exclusively at the cost of perpetrating crimes. In doing so, it opened the door for the trial chamber to characterize in the vaguest manner possible which objectives imply or don't imply crimes. And as a former substitute of co-prosecutors in the ECCC clearly explained, and we must here salute his intellectual honesty. It was written in English, and I'll quote it in English, and please excuse me, because my accent is not necessarily the best. But this is what he said by commenting the definition of JCE as it is put forward in number 1.
Of individual liability for group action below that one of the most criticized aspects of international criminal law. Fin de citation.
End of quote. On another point, and which was underscored by the Supreme Court chamber in its ruling on 021, it states that the common purpose lies at the heart of this mode of participation because it is the element which binds the participants to the joint criminal enterprise and justifies that their respective acts of a nature such that it will commit their criminal responsibility can be imputed to each one of the members. However, for this mutual attribution to be justified, it is not enough that those who agree to act with a common purpose satisfy themselves with adhering to any common goal. In fact, it has to be criminal. And the trial chamber settled for asserting that the top leadership shared the common purpose or project. And as is demonstrated, and I have it here, it says at the time when it mentions the common project or purpose in the joint criminal enterprise, it states a group of several persons, among which were found high levels of leadership, Pol Pot Noan, Khieu, Samphan, Yensari, Yengtiri, Sonsen, and Warren Vet until he was arrested at the end of 1978, and zone secretaries, including Tamok, Kepok, Khoi Tuong, until he was placed under house arrest mid-76, Chuchet until he was arrested in March 78, Runim until his arrest in May-June 1978, and Sao Pim until his suicide in June 78, shared the same common purpose. However, it has never been the case that there was evidence that Khieu Samphan shared the objectives or the criminal intent of all of these people. However, it is solely on this basis that one could justify imputing to Khieu Samphan crimes perpetrated by these other participants in the JCE, either directly or via their hierarchical authority or their functional authority in regard of the authors of these material crimes. This approach, in fact, finds a shortcut by deducing a criminal intent from the sole quality of being a member of the DK and thus criminalizes the fact that one belongs to the DK. And I wish to thank my colleagues who showed the reference of paragraph 4210, I believe. And so the problem with the reasoning of the trial chamber is as follows. Since Khieu Samphan was a member of the leadership of DK, he shared the criminal common purpose and must therefore be held responsible for the entirety of the crimes perpetrated. This is a hazardous reasoning because it substitutes the characterization of a criminal objective and the intent required to the objective fact of belonging to a political project. And to paraphrase the Berdanin ruling must be recalled here, which was is found in the 1949 paragraph 1949 of our appeals brief, which states that the chamber could not simply conclude that the appellant had been in contact with criminals. It had to establish that he intended to commit a crime, and that he associated with other persons in order to achieve this objective, and furthermore, that he broadly contributed to the crime. Short of that, one cannot say that there was, or prove that there was, intent to commit the crimes. And thus, unable to determine a specific action representing significant contribution, the chamber concluded on the role and the contributions that were alleged. The chamber essentially concluded that adhesion to the criminal aspects of the politics of Khieu Samphan by his the fact that he was connected to the members of the CP, and his intent to commit crimes and contribute by official speeches during the Democratic Kampuchea regime, or statements made after the fact and functions, even though they were linked to non-criminal aspects of the project. And being unable to determine a specific action of Khieu Samphan characterizing his contribution to criminal aspects of the common project, the chamber used artificial arguments to include KS in a collective responsibility, contrary to the need to determine and assess his individual responsibility. This paragraph 2008. And we will return to this in our response to the questions of the Supreme Court. The consequence of this was that with the definition selected for joint criminal enterprise in this case, any individual having held any position at the time of the events that are being considered can be considered as a co-perpetrator who was not indicted. The legal basis and constitutive elements of a mode of responsibility must be secure, particularly that which can criminalize any type of conduct or behavior. If these are too broad or insufficiently clear, there is too much room left for political considerations to replace a rational application of the law. Constant evolution of the constituent elements of the JCE shows that more than 20 years after the creation of that doctrine, it still leaves the door wide open to abuse. And in fact, the proof of this is that the trial chamber, the co-prosecutors, and the chamber of the Supreme Court retain, after 15 years of procedure in this case, do not do not select the of JCE corresponding to the definition of the moral element given to JCE 3 by the co-prosecutors. The trial chamber then disagreed with the Supreme Court chamber and gave up the recognition of the fact that JCE 1 included the concept of dolus eventualis prior to emptying it of any meaning by redefining the common purpose or project. And then, concerning the common project itself, prosecution itself agreed that an accused cannot be held responsible for crimes flowing from a project which was lawful at its origin, and the entirety of the argumentation today consists in demonstrating the opposite. And I would like to refer you to the complementary observations of the co-prosecutors on joint criminal enterprise, which is the D97/8 paragraph 44 of 31/12/2008. Therefore, it appears obvious that given the distortions of JCE 1 in the case of the ECCC's apprehension of them, these constituent elements were not sufficiently precise in the sense required to satisfy the requirements of a principle of legality. And given the various evolutions of the definition, we see that there is a need to make a type of responsibility that is cut size in order to allow for a conviction, a bespoke responsibility. And we can observe that similar treatment of definition of aiding and abetting, in which the chamber systematically lowered the moral element because there was no direct intention for the majority of the crimes in this case. A few words now concerning aiding and abetting, and I will be brief here and refer you to paragraph 2020-2021. There was a similar MO of the chamber, which we find in its definition of aiding and abetting. The chamber systematically lowered the mens rea, the moral element, because there is no direct intent for the majority of the crimes listed in this case. This is particularly true for murder with the dolus eventualis, and I insist again that we supplied a certain number of sources, new sources, in the list supplied in this hearing, and that it is fundamental to refer to them in order to observe that at the time of these events there was no dolus eventualis either for the crimes or for intent. And so this element of law having been recalled, I will now look at the questions of the chamber and in effect raise the factual issues which seem to us to neglect exculpatory elements in favor of Mr. Khieu Samphan, and in doing so I will respond to paragraphs 44, 43, 44, and 52 of your report. First of all, as I said earlier, and this was summarized in the paragraph which was in the report this morning, the fact that the role of the accused for the chamber was to support, promote, and publicly approve the objectives of the CPK, that he held positions of leadership during the regime of Democratic Kampuchea and held education sessions. And this is what the chamber relied on in order to define the contribution of Mr. Khieu Samphan.
Au paragraphe 50.
Your second question relating to paragraph 52 had to do with the elements of evidence regarding the allegations of the accused. I would like to clarify that on certain themes, both aspects of knowledge and contribution are connected. Knowledge stems from the contribution. I'd like to recall, and this is important, what we had said regarding the definition of the common purpose as this appears in the motivations of the judgment, and I refer to our paragraphs 1975 to 1980 in our brief. Knowing that there have been different ways of wording this during the judgment, in paragraph 1980, which in the judgment corresponds to para 3918, has to do with promoting the implementation of the common purpose of a quick socialist revolution with a great leap forward, defending the country against the enemies and radically transforming the population into a homogeneous society of peasant workers. And to draw a parallel, I would like to say the definition of the common purpose in the closing order in paragraph 1524, according to the co-investigating judges, was a project defined to implement in Cambodia a rapid socialist revolution with using all necessary means through a great leap forward and by defending the country against enemies internal and external to the country. It's interesting to compare the two definitions because there is a nuance that is introduced here by the trial chamber. I refer also to everything that I said just a moment ago on JCE, and I would like to recall also the notion of the prosecution of the probability of crimes being committed as an element that has to be taken into consideration. I mentioned earlier the appeals brief in para 2008, and there we also summarize the contribution of Khieu Samphan according to the trial chamber. I quote, "The chamber has in essence found that there were criminal aspects to the policy of Khieu Samphan through his frequentation of the members of the permanent committee, through his official discourse during a DK, his statements after the fact, and these various functions which are connected with the non-criminal aspects of the joint purpose." I cannot revisit all these errors, but I would like to illustrate a few examples, starting with the standing committee. You find reference to this in our paragraphs 1730 and following. There was a biased use by the chamber of the minutes of the standing committee, where we find neglect neglect of the exculpatory aspects regarding Khieu Samphan. The chamber says in its paragraph 602 in its judgment, it says that Khieu Samphan had a unique position in the regime, that he knew everything that was happening across the territory of Democratic Cambodia because he was an active participant in the meetings of the standing committee. Active participant. In our brief, our paragraph 1736 to 38, and 1745 to 48. We recall that in the file there are 16 sets of minutes going up to June 1976, but the Democratic Kampuchea did not end before 79. So the participation in the meetings for which we do have minutes, and that's one thing, and then on what basis are we judging that there is active participant of Khieu Samphan? The name of Khieu Samphan appears only twice, and not at least, as is said by the chamber. And his appearance always has to do with reporting to the committee. So Khieu Samphan was never a member of that committee. Further, as regards reports, those minutes, the reports of Khieu Samphan to that committee are reports on substance around the time of the resignation of Norodom Sihanouk, and we see him referring to activities, general activities of that type. There is nothing in his reports that relates to his activities with trade, and nothing that is connected to criminal activities. So that's an aspect that has not been taken into consideration. What then do you mean by active participant when you have reported twice to a committee? It's not the same thing as active participation. Still on the same topic of the minutes of the Standing Committee, these minutes have been used by the Chamber to conclude that Khieu Samphan was aware of what had been done at the airport of Kampong Chnan. And here we have a proof of the extrapolation and bias of the Chamber in respect of the Kampong Chnan airfield. I'm referring to a paragraph 1741-42. What does the Chamber say here? Motivation of the judgment, paragraph 4258. The Chamber draws the supposed knowledge of the crimes committed in the airport by invoking the presence of Khieu Samphan in a meeting that mentioned the project, and in later meetings, we don't know which ones, where Son Sen, being in charge of the army, would have intervened. So in our paragraph 1742, the reality is that 3 sets of minutes are mentioned. The Kampong Chnan airfield, a 1975 report where participants are not named, another one for 1976 where the issue of construction is still under study, under review. I don't see how Khieu Samphan could have been informed of crimes committed on the site at that point. And another report for May 75 where there are technical considerations about gravel that are mentioned. So those are the 3 reports that are the basis for the conclusions of the Chamber regarding the alleged fact that Khieu Samphan knew about crimes being committed in Kampong Chnan. If it's Son Sen who's talking about the airport, it's because it's a military airport, so it's under the responsibility of the military authorities of DK. Consequently, Khieu Samphan was never part of the military branch, and this has been acknowledged by the Chamber. Further, the Chamber refers to the contribution of Khieu Samphan in his duties related to trade. A number of discussions have taken place regarding the proof in trials 2.1 and 2.2. But if the Chamber finds that Khieu Samphan had a supervisory role, he was never at the helm of the Trade Ministry. And this is also very clear. In our brief, Paris 1738, 68, 69, say clearly sorry, I'll give you the correct references in a minute. Anyway, references made to the different minutes of the Standing Committee, where references are made to trade, and the two major people in charge were Ganzert and Van Riet. So, in each case, in particular when we're dealing with marriage, Khieu Samphan is shown to be at the head of the Trade Ministry, but this is not true. This appears nowhere, in particular in the light of these minutes. Further, the points of our brief where we refer to trade are in paragraphs 1463 and following in our appeals brief. Another function under trade, Khieu Samphan is said to work collaboratively in matters of trade with Dunn, who was in charge of Office 870. This has been much debated during both trials, and it's very clear that Khieu Samphan never was the successor of Dunn at the head of 870, but the Chamber does say that he was the successor. And here I refer you to our brief, Paris 1638, 68, 69, where the Chamber says that Khieu Samphan allegedly succeeded Dunn at the head of 870. The prosecution tells us, oh, that's probably a typo, a minor error. But at any rate, the prosecution agrees that this is not what the Chamber had understood earlier. Anyway, in each case, basically what I want to point out is that we have very specific points regarding the limited scope of the activities of Khieu Samphan, and they are extrapolated, they're stretched, they're expanded to draw them into the aspects of a criminal policy. Another aspect that is connected with Office 870 is in terms of the communication structures. There is a very important witness statement of Nam Sampong, who was in communications, and he said that communications at 70 operated in a special channel, and it was a different channel that dealt with the activities, trade-related activities of Khieu Samphan. So separate channels of communication. Another point, the treatment or the few witnesses that referred to statements of Khieu Samphan. Much is said about this in our final and our appeal briefs, and we find here that we have two witnesses who come up with major contradictions. But the Chamber, nevertheless, used those statements to, in fact, attribute statements to Khieu Samphan that might indicate that he was aware of certain arrests. Witness Ekem and civil party Eken is referred to in our appeal at para 1759, and our request for additional evidence under document F51 of 8 October 2019, para 17-238, and further, here we analyze the witness statement of Ik-N, the fact that she provided different versions of the education sessions that she attended with the presence of Khieu Samphan, during which he allegedly spoke. And here we have contradictions depending on whether it's the first or the second meeting. There are different versions that should not normally allow the chamber to retain this particular statement, witness statement, as reliable, especially when the witness herself recognizes, and here you can look at our para 25, when she says that her memories are not, she can't remember clearly. And nevertheless, the chamber and the prosecution ignore the important points in the written declarations that contradict the earlier statements. So we had to wait for the appeal to be able to see the a new set of even more different points which were communicated after the end of the debates of the hearings in trial 2-2 by the witness, and the chamber did not reopen the hearing for us to be able to have access to those documents for inclusion in our discussion. On the same issue of education, there's also the case of M.Un, civilian party M.Un, and what he attributes to Khieu Samphan during an education session. I would like to make it clear that both Ek-En as a witness and the civil party are not referring to the same education session. For M.Un, as civil party, there are huge contradictions in the witness statements received. They're not minor contradictions, they're not minor issues. The civil party cannot situate coherently and consistently certain events within the same witness statement. He has different versions of the death of his parents, saying that during the education session he allegedly found out that it was Khieu Samphan because his father told him that this was the president of the presidium, whereas in fact his father was deceased before the advent of DK. So we've got a pretty extreme contradiction here. Here you can look at our appeals brief paras 17, 57, 58, our response to the prosecutor's appeal in terms of the marriage issue in para 58 of document F50/1, a final pleading E1235/1, and the contradictions which were acknowledged in the ruling of the Supreme Court in paragraph 247. So that is the kind of contradiction that the chamber is leaving aside in its desire to have inculpatory elements. In its ruling 2-1, it recognized the contradictions.
Mais elle trouve des...
It says this, but finds excuses, stating that there is an absence of prejudice for Khieu Samphan throughout this trial 2-1. However, in trial 2-2, the statements of the civil party witness M1 is used by the chamber to conclude that Khieu Samphan would have been aware of certain arrests subsequent to the training session which he is alleged to have taken part in. And this is in the F54 part of our appeals brief to specify as well that this paragraph contains all the references during which civil party M1 was used by the chamber. Another point on the issue of handling evidence, they're trying to put so much in his mouth, trying to prove so hard that Khieu Samphan was aware of the alleged criminal behavior, the alleged contribution of Mr. Khieu Samphan to forced marriage, which we challenge elsewhere. This, to have stated that he discussed marriage, is based on a single testimony of the civil parties, Chidip. And you will recall that in paragraph 1233 to 1242 and 2028, you will find that when the civil party mentions Khieu Samphan for the first time, even though it had already made a civil party statement during the trial, it shows that these recollections come very late in the day. And then it's interesting to note as well that the chamber uses this testimony and looks for ways to corroborate. And so this civil party, which is alleged to have worked at the Trade Ministry or Commerce Ministry, evoked a speech of Khieu Samphan where he stated that women above 19 years of age and men of 20 and more should be married, and that marriages would be organized. And so this is testimony by this witness from Commerce, and there were others. No one else ever discussed training or a speech of Khieu Samphan where he mentioned marriage. After this, of course, there are people who spoke of marriage inside Commerce. We have the testimony of Rosui, which was used extensively to show his participation in Commerce, and he never mentioned Khieu Samphan on the issue of arranged marriages in Commerce. And I would like to recall that in any event, Khieu Samphan was not part of the leadership of the Commerce Ministry. He collaborated with that ministry, but he was not the leader of the Commerce Ministry. He was not the head of that ministry. Other elements can continue to raise because we're still discussing arranged marriages. Other elements which were totally overlooked are those of the revolutionary flag. Actually, the chamber used them when it fitted its purpose, but when it was stated black on white that it had an impact on the regulation of marriage under the Khmer Rouge, it has totally ignored this, and going as far as saying for the moral principles, that these so-called moral principles were published by the red flag in 1978 was too late, and it was just a means of pursuing propaganda purposes. So first of all, the revolutionary flag was distributed exclusively to CPK members, so why would you want to make propaganda in that circle? And secondly, going back to what was said on the section of marriages, as François Ponchot said, and we wanted him to be able to testify in neutral fashion on this issue, and it is that he would have said to the chamber, we would have had this element, that they were cadres and they had reason to lie. He was a Frenchman who settled in Cambodia in 1975 and was a witness to the progression of the Khmer Rouge prior to their seizure of power and followed what was happening, was perfectly aware of these moral principles, which did not suddenly appear in the Red Flag in 1978. And here I refer you to the appeals brief, paragraphs 293 to 95, also on issues concerning the Red Flag, and various elements related to the regulation of marriage in general, which can be found in our appeals brief and other statements that I made on the question of testimony that I described, and various facts that I also alluded to, which in their vast majority alluded to this. Another interesting element to show the manner in which the chamber used various elements by stating that they demonstrate a corroboration still on the marriage policy, that the corroboration for Chidip, the civil party, again, who is the only person mentioning Khieu Samphan in relation to marriage. In fact, they described the writings of Norodom Sihanouk, which were quoted at length and were used on several occasions. This is called corroboration. But negative corroboration when it's needed. But this comes from an autobiography, which tends to glorify the person who wrote it, and gives a very personal presentation with very personal recollections, which could not be verified or confronted to other evidence. So this is not only writings that are outside of the scope of the legal proceedings. Not only was Sihanouk dead for 02, we asked for his presence at a hearing in 01, and the national co-prosecutor had opposed that. And so we used the statements of Norodom Sihanouk to conclude that there was knowledge of crimes relating to forced marriage when these were committed. These are paragraphs 3571, 3246, or 49. And there, Norodom Sihanouk evokes alleged statements by Khieu Samphan on the patriotic spirit of young ladies who were willing to take care of national heroes by marrying them. And on the content, if Khieu Samphan said that women found heroic people even though these people suffered handicaps, cannot be a demonstration that there was a policy of forced marriage on his part. On top of it, this is a statement by Norodom Sihanouk in a document where there was absolutely no possibility of cross-examination. All the more so since on this question, Chonti explained that as a matter of fact, in the aspect of celebration of revolutionary heroes, which is found in paragraph 3571, 371 of the motivation of the judgment, which itself quotes a publication of Norodom Sihanouk, one cannot say that he was particularly respectful for veterans, because it must be recalled that they were fighting alongside the Khmer Rouge at a time when they were working as a front with Norodom Sihanouk. Another element which shows things which in absolute fashion can be considered to be positive and are transformed in order to make them negative, and I would like now to refer you to paragraph 2023 of our appeals memorandum, and there we refer a statement used by the Chamber to demonstrate, according to the Chamber, the discriminatory intent of Khieu Samphan against Buddhists, because, and we have to quote it because otherwise you can't understand the nature of the use of these proofs, where this is a speech where Khieu Samphan supports and congratulates a Buddhist, and then says that he maintained in a dishonest fashion an impression of normality in public, all the while encouraging that marriages be organized that were fundamentally incompatible with tradition. This is, in fact, an attempt to connect a discriminatory intent by Khieu Samphan in a speech which otherwise does not demonstrate that. And we have also elements of speeches and statements wrongly attributed to Khieu Samphan to conclude that he participated in the development of the common project, and that it was of a criminal nature. And this is used by the Chamber to that effect, and we can prove that this is not attributable to Khieu Samphan. We said it, and we were not the only ones. You said it yourselves. And here, we can go to paragraph 1699 to 1701 of the appeals brief. You have at least two documents which are wrongly attributed to Khieu Samphan. First of all, a speech of 11 April 76, E3165, and in your judgment 2-1, F36, paragraph 1023, you stated that it was not Khieu Samphan. So let me repeat.
Please give the reference number of the document again. You are a little bit too fast for the interpreter.
Je répète le numéro. 1, le paragraphe.
Let me repeat the number. Paragraph 1023 of Judgment 2-1. Similarly, we have document E3/608, which is an interview about which we had stated, and Ms. François Ponchot stated that it was a forgery, which is nevertheless used by the Chamber to conclude that Khieu Samphan was aware of the crimes after they had been committed. And I go back to our presentation at 1791 and 181. And the Chamber used this document to condemn KS. When you use something, it becomes positive, and if something that is written is found, it is discounted unless it is inculpatory. And again, still with Sihanouk's writings, the writings of Sihanouk are used to say that Khieu Samphan used incitement to hatred against the Vietnamese in their policy against the Vietnamese by stating that it was necessary to hate the Yun a bit more every day. That is again the autobiography of Sihanouk, which cannot be verified. And this is used as an argument that there was in fact aiding and abetting and encouragement of hatred against the Yun in general. These are statements which were made by Notre Dame Sihanouk and published in 2000. And here, the Chamber states that given these paragraphs of 4,278, etc., that not only did Khieu Samphan adhere to the common project, but he participated in its implementation, making use of his high-level functions in order to ensure that they would be implemented, in this case against the Vietnamese. Whereas the speeches that are used by the Chamber, apart from these alleged corroborating statements by Sihanouk, we've always said the speeches of Khieu Samphan, and particularly the one of April 78, cannot be looked at without placing them in the context of armed conflict with Vietnam, and that Khieu Samphan never called on the population to attack innocent civilians. He was talking about the Vietnamese army, which in December 77 and early 78 had crossed over into Cambodian territory. And then I would like to refer to paragraphs 1080 to 1082, where in 22457/6/4/1, paragraph 801 to 811, we had shown a chronology of the armed conflict in order to show at what time each speech was made. And it's clear that if you hear a speech made by any leader after an attack or after an armed incursion of an enemy army into the country, they won't be sympathetic. And you can say that statements were made against the military enemy, but certainly not against a civilian population. Again, connection with links with the specific groups. And here, if you look at paragraphs 1806 to 1838 and 2006 of the appeals brief, and mention of a statement alleged and attributed to him concerning a book of observations of elements which had been gathered after the facts, and Khieu Samphan was not the one who had written that, and so this is in our appeals. The Buddhists now, I mentioned that, this misleading appearance of normality, no element on the Cham, because we're told that there was a discriminatory intent, but I would like to remind you that Khieu Samphan was accused of Cham genocide. The motivation of the judgment, paragraph 4290, no evidence produced before the court gives a sufficient level of proof, probative value, allows us to establish to the level of proof required that Khieu Samphan had the specific intent of destroying the religious and ethnic group Chang as such. And it's hard to understand then what were the elements upon which the chamber based itself to say that the special dolus specialis required had been demonstrated on the issue of discrimination against the Cham attributed to Khieu Samphan, even though nothing can be found in the red flag, which was extensively quoted. There is nothing there that can demonstrate that there was such a policy against the CHUM. Again, on the issue of work cooperatives, in paragraph 4277 of the judgment, which we raise in the appeals brief in paragraph 2030, where it is explained to us that Khieu Samphan, in the framework of his statement, had a silent incitement. So either you incite or you don't, but silent incitement is not incitement.
Et là,
And now I come to the end of my presentation, and I would like to briefly respond as regards question 52, to the effect that the issue of Khieu Samphan knowing or not knowing in terms of the mode of liability under aiding and abetting. So here again we draw a parallel between the declarations of Sihanouk and Khieu Samphan, and the Chamber uses in paragraph 4265 the 2000 book of Sihanouk, saying that Khieu Samphan had perfect knowledge of what was going on, whereas Khieu Samphan has always asserted, and this was elucidated in the course of the trial, that when there were official visits, the rare sites that he visited in the company of Norodom Sihanouk, who said very different things publicly, as we also found in our debates, saying that what was being shown was not, of course, the problems. It was clear that the situation was not good during decay, before decay, and this is one of the reasons why Khieu Samphan wanted a revolution to change the situation. But the goal was not to abuse the population and to murder, to kill people. Here again, the Chamber voluntarily left aside the statements of Sihanouk in terms of the knowledge held by Khieu Samphan. In fact, in the last pleadings, and I refer you to the final conclusions, to the final pleadings.
Defense counsel, please wait a little bit. The IT unit need to change a DVD. Defense counsel, you may continue.
donc, mon confrère me demande.
So I shall repeat the references. In our appeals brief in paragraph 2021, we say that the Chamber did not take into consideration our points regarding the contradictions in the statements and the writings of Sihanouk. I was also mentioning what we said in the final pleadings, document E1/234.1, between 1058 and 1101, as well as our final conclusions in para 1173, as well as our appeal brief regarding living conditions, paragraph 1507. And there's also the exculpatory aspects that have been completely ignored when they were presented in case 2.1 and 2.2 and in the appeal. And never have these points been taken into consideration. First of all, a very eloquent case, that of Samphan, which I've already referred to in our appeals brief 1877-78. The witness testimony of Samphan is interesting because he was a military sent to the zone of Trevir. And what he says is used to say that he reported once to Khieu Samphan, and Khieu Samphan was thus aware of the arrest of Kang Chap through this report. But we also have the interview of the defense on this point, which did not allow the chamber to draw the same conclusion. You can look at the statements of the 9th October hearing of McGuinn. We mentioned this in our brief in Paris 1876-187. We can look at the way in which it was requested that the report be sent to Khieu Samphan, and the people in charge told him that this message could not be sent because of issues. He said that the message was not sent, and thus and then between 14 hours and 14:15, he said, I'm not sure whether it was transmitted because I got no reply. So that gives us a witness testimony that the chamber uses to say he knew and he reported. But the person who is in charge of sending the report says that that I'm not sure the report was sent. Another point. As regards the sites, part 5 of our appeal brief, particularly paragraphs 704 to 715, 1604 to 1605, sorry, where we look site by site at the different elements that the chamber could use I had mentioned the witness statement of Duik on the issue of what Pong would have told him regarding what Khieu Samphan allegedly may have known at the time of a particular meeting, a hearsay as to about S21, a place of torture where Duik is the head, and the chamber says no, because they want to use this element to find that Khieu Samphan had the knowledge. Consequently, there have been certain ways of linking Khieu Samphan with certain alleged policies. I'm not referring to his presence in Phnom Penh and to his official positions that he never challenged, but I'm referring to the extrapolations from Ek and M.N. Witness testimonies, where the issue of marriage is mentioned, and Khieu Samphan ordering marriages to be performed. Writings regarding the attitudes of the accused with contradictions that have never been mentioned, interviews of the defense which are deemed non-existent, the work of authors that were not summoned. So those are the points that we want to mention. But there is also the essential point of stating he could not know. And that is the core problem of this fail. He was in Phnom Penh, consequently he had to know. Yet, in case 0201, as we have been recalling in 0202, and Mr. President, I'm about to conclude, there is this moment where we are told he could not know. We don't have any evidence of this, but reference is made to overall liability because he was in charge of different roles in the government, that he took part in certain meetings of the Standing Committee, but not as a member, and looking at statements that were made after the facts, and the prosecution will be able to show these to you, none of which demonstrate the reality of crimes at the time. And there's also on video the different witness statements of various authors. But the basic reason why the chamber has distorted the JC and the aid and abetting has to do because they did not have enough evidence as to the direct intent to commit crimes, to participate in the criminal aspects of the alleged policies. This is the reason upon which we base our appeal, and for this reason we want you to reverse the judgment of Khieu Samphan. This changes nothing to the fact that Khieu Samphan will die in prison, but at least it will be important for the court legacy of ECCC. Thank you, Mr. President.
President, the chamber will have a short recess, and we will return at 11:05. The court is now in recess. President, please be seated. I would like now to hand the floor to the co-prosecutor to make submissions.
Good morning, Your Honour, Mr. President, and parties. The appellant challenges his conviction based on his commission through a joint criminal enterprise in 3 areas: the nature of the common purpose, his participation in the common purpose, and his intention to participate in the common purpose and intent to commit the underlying crimes. I will address the common purpose and intent grounds, while the international co-prosecutor will address his participation in the common purpose and his liability for aiding and abetting murder. As to the nature of the common purpose, the appellant's grounds are based on a misconception of the law and a disregard for the totality of the evidence. He argues that the common purpose pursued by the CPK leaders was the benevolent creation of a better society through a socialist revolution, arguing that all the crimes committed across DK were beyond the CPK's leadership's control, a deviation of their policies, not the policies themselves. However, the extensive body of evidence supporting the Chamber's findings demonstrate these crimes were integral to implementing their socialist revolution. Although the Chamber found that the primary objective of the common purpose was not necessarily criminal in nature, they found the means to achieve that objective were making the common purpose criminal in character. Such a construction of the common purpose is in line with Your Honour's definition that a JCE common purpose must either have one of its primary objectives, the commission of a crime, or must contemplate the commission of a crime as a means to achieve an objective that is not necessarily criminal. The Chamber found the common purpose to which the appellant and other senior CPK leaders belonged for the entire DK period was to rapidly implement a socialist revolution in Cambodia through a great leap forward, designed to build the country, defend it from enemies, and radically transform the population into an atheistic and homogenous Khmer society of worker peasants. They found it was implemented across DK by the party's entire administrative network: zone, sector, district, and local secretaries, CPK cadres and RAK forces through the execution of at least 5 policies. These policies being intrinsically linked to the common purpose and involve the commission of crimes, making the common purpose criminal in character. Fundamentally, the appellant argues that the Chamber was in error by finding these criminal policies were established. However, based on the extensive evidence before the Chamber, no such error is made out. For example, if we look at the Chamber's finding that the CPK senior leaders established a policy to identify, arrest, isolate, and smash the most serious category of enemy at security centres and execution sites and re-educate bad elements, the argument of the appellant that it was a deviation from and not a policy is in stark contrast to the comprehensive and compelling evidence before the trial chamber. The chamber found that this policy involved the crimes of imprisonment, enslavement, other inhumane acts through attacks against human dignity and enforced disappearances, torture, murder, extermination, and persecution. They found it was implemented on a widespread and systematic basis, finding that at least 200 security centres were established and operated countrywide. They found this enemy policy was ordered from the CPK's highest levels and was carried out by the entire administrative network. They found it was intrinsically linked to the common purpose, making it criminal in character. Document E3/12 demonstrates the central nature of the policy. It's a decision of the Central Committee, the highest CPK committee recognised in the party statute, to which the appellant belonged, dated the 30th of March 1976. In this decision, the committee delegates to zone, party centre and general staff committees, I quote, the right to smash inside and outside the party ranks. It states the purpose of this decision is to establish a framework to carry out our absolute revolution, to strengthen our socialist democracy, and to strengthen our state authority. In other words, the decision gave the authority to murder so-called enemies issued from the top of the party to which Khieu Samphan belonged, down the line to their offices countrywide. S21 Security Centre is the clearest example of the implementation of this policy nationwide, because of the thousands of documents left behind and the former CPK and victim witnesses who testified. The chamber found that well over 11,742 registered S21 prisoners were executed over the 3.5 years of its operation. The prisoners were arrested from most zones, military divisions, DK ministries as a result of nationwide purges of CPK enemies. The chamber found it was supervised by standing committee members Sun Sen and Nguyen Chia through the general staff. The appellant's argument that extrajudicial killings of party enemies was not a CPK policy, but a deviation, lacks any logical, objective assessment of the evidence. His further argument that the use of terms such as elimination of enemies in his and other CPK leaders' speeches and training and propaganda materials was simply Marxist rhetoric to eliminate ideological and political traits in others is disproved by the evidence of the tens of thousands of so-called CPK enemies murdered across the country. We'll turn now to the appellant's argument that the CPK policy to establish and operate cooperatives and work sites did not involve crimes. Again, the appellant disregards the totality of the evidence. The chamber found that this policy involved the crimes of enslavement, other inhumane acts through attacks against human dignity and enforced disappearances, murder and political persecution based on the scale and duration of these crimes at the charged crime sites. The chamber found that Norodom Sihanouk compared these work sites to concentration camps after visiting some of them with the appellant. This observation accurately reflects the extensive, diverse and consistent witness and documentary evidence before the Chamber, establishing the CPK's absolute control over every aspect of people's lives. The findings established that CPK cadres in charge were solely focused on rapidly meeting the leadership's production goals, no matter the cost, forcing people to work long hours, labour hard, under appalling conditions. Those who failed to meet the party's ambitious production quotas or did not work hard enough were punished. People suffered and died from exhaustion, meagre food rations, inadequate medical care, and basic hygiene facilities, as well as substandard accommodation. Families were separated and spouses could not meet freely. The Chamber found this policy had multiple goals, which were intrinsically linked to the common purpose. One, it was the driving force to build economic infrastructure and food for internal consumption and export to generate capital. Two, it was a means to destroy the social class system, forcing city people to become worker peasants, replacing private ownership with collectivization. Three, it was a control structure to identify enemies by requiring biographies to be completed and to monitor counter-revolutionary behaviour, which resulted in disappearances and killings. The appellant's arguments that the Chamber was in error by attempting to criminalise the policy by improperly using pattern evidence of crimes outside of those sites charged, by misinterpreting the CPK pre-DK terms to control and capture the population, and failing to acknowledge the significance of not sending rice, all rice for export, are all unsubstantiated. First, it's settled law that evidence outside of the temporal or geographic scope of an indictment can be used to clarify context, demonstrate a deliberate pattern of conduct, and establish elements of charged criminal conduct. Second, the CPK terms control and capture were used by the Chamber as evidence to support the criminal nature of the policy, not as argued by the appellant as the sole basis to find that it involved crimes. Third, the Chamber did acknowledge some rice was kept for internal consumption, yet that still did not alter its view that the mistreatment continued at these sites. The appellant's argument that this policy was benevolent chooses to ignore that CPK accepted the cost of implementing it was through the systematic violations of the population's most fundamental human rights. As my colleagues have addressed the appellant's grounds relating to the targeting of specific groups of enemies, Vietnamese, Cham, Khmer Republic officials and Buddhists, and regulation of policy yesterday, I will turn to the issue of the appellant's grounds alleging the Chamber erred in law and fact by finding he intended to participate in these crimes. First, to prove intent or knowledge of crimes, contrary to appellant's argument, it's not required for the appellant to intend or know of specific criminal incidents. The appeals chamber in the cases of Perlich and Stoic at the Yugoslavia Tribunal on the 29th of November 2017 held, as long as the accused had the intent for crimes to be committed or knowledge that crimes had been committed pursuant to the common purpose, it's not required to intend or know of specific criminal incidents occurring at specific places and times or against specific victims to prove this element. Indeed, it would be artificial, impractical, and defeat the purpose of having JCE liability in the first place to require the precise intent or precise knowledge of each and every crime committed in the course of a large-scale, ongoing joint criminal enterprise. As long as the appellant intended or was aware of the general types of crimes being committed pursuant to the common purpose, that is all that is required. Second, the appellant's argument that the trial chamber determined his intent only on his mere participation in the common purpose is not established. As it's clear, the chamber found it was based on his knowledge of crimes being committed pursuant to it and his ongoing participation in the common purpose. I will address the knowledge and intent aspects, and the International Co-Prosecutor will address the grounds relating to his ongoing participation. The Chamber established the appellant's knowledge of the common purpose crimes through an evidence analysis of the pre-DK and DK periods. Addressing the pre-DK period, the Chamber concluded that on entering the DK period, the appellant knew of the CPK policies and was aware of the substantial likelihood that crimes would be committed pursuant to them. They based this on his prominent long-time CPK membership, his support for a strict collectivist economy, and his calling for the elimination of Khmer Republic officials by violent means. They also based this conclusion on his knowledge that in liberated areas, CPK policies were being implemented and were resulting in patterns of conduct involving crimes, such as cooperatives were being forcibly established to increase rice production, markets were being closed, monks were being forcibly disrobed and were subjugated to collectivist policies, marriages were being arranged as a matter of CPK practice, CPK political opponents, especially those linked to Vietnam, were being executed, and the CPK was conducting purges within its own ranks. The appellant admits his knowledge of the criminal practices of the CPK regime coming into the DK period in his book E318, where he states, and I quote, "I could not remain neutral. At each crucial historical event at that time, I chose to side with the forces which, despite their reputation and their contradictory acts, seemed in essence to support Cambodian sovereignty," unquote. Your Honours, the appellant was well aware of the criminal nature of his party entering the DK period, but he chose to continue to support them anyway. In a separate assessment, the Chamber then addressed the appellant's knowledge of common purpose crimes committed during the DK period, finding he knew that they were being committed. The appellant's argument that this finding was in error is heavily contradicted by the totality of the findings and the evidence supporting how this knowledge was gained. They found he gained his knowledge through the leadership positions he held, his privileged daily access to the small group of the most powerful CPK leaders, his ability to travel throughout the country, his regular attendance at standing committee meetings, his and other leaders' statements relating to the 5 policies, his access to policy and training documents such as Revolutionary Flag and youth publications, his attendance at training and study sessions where the criminal policies were communicated, discussed and incited, including criminal conduct towards enemies, his receipt of reports from international bodies of atrocities against Khmer Republic officials and other CPK detractors, his public rejection of stories of massacres claiming the execution of traitors was justified. The appellant's argument that the Chamber was in error in finding that the CPK principle of secrecy only occasionally applied to him, and that the appellant had access to the revolutionary flag magazines, is contradicted by the very findings they made based on his high-level roles and functions given to him, and the contributions he made to the common purpose. The fact that the Chamber found the revolutionary flags were not only printed and delivered to DK ministries and officers of the party centre, but were written by members of the Standing Committee, makes the appellant's claim all the more implausible. The evidence clearly demonstrates the appellant was required to keep party secrets, not have them kept from him. I'll now address the appellant's grounds alleging errors in finding that he intended to participate in the enemy policy, which involved the commission of crimes. Again, his arguments fail as they ignore the totality of the evidence. In finding his intent to commit these crimes, the Chamber found that the appellant contributed to nationwide purges which were intrinsically linked to the operation of the security centres by publicly advocating for the identification of enemies, warning that traitors would be killed. For example, on the 15th of April 1977, when he called for the neat and thorough wiping out of the enemy, imploring cadres to uphold their, and I quote, spirit of revolutionary vigilance at all times against the enemies of all quarters, both at home and abroad, whether from outside or from within, unquote. On the 15th of April 1978, he celebrated the continuous victories over the enemy and pledging those in the attendance to, and I quote, maintain national unity in the struggle to exterminate the enemies of all stripes, unquote. Whilst calling for the killing of enemies, the Chamber also found he knew of high and low-level purges of alleged traitors were occurring. They found he supported and had acute knowledge of the circumstances of his fellow leaders' arrests due to his unique privileged position in CPK and DK, and because of his active facilitation of arrest and purges. At the same time, he also knew of the purges occurring at the lower levels as a result of widespread arrests of people at the bases founded on real or perceived affiliations with enemies. It's clear from the Chamber's findings and the evidence that he was well aware of the killing of enemies policy, incited it, and knew it was being implemented. An example of his knowledge and justification of killing so-called traitors in the DK period is evident in his admissions, his many admissions after the DK period. For example, in August 1980, he told Stephen Hedder that all of the UN undercover agents had been, I quote, dealt with, and that, I quote, not a single one of them was innocent, unquote. In 1987, as Vice President of the Democratic Kampuchea for Foreign Affairs, the appellant acknowledged the death of 10,000 Vietnamese agents acting in violation of state policy, as well as 8,000 organisers of the 6 coups d'etats and the chief traitors who, in connivance with the Vietnamese, tried to take control of the eastern zone. I quote, he states they were imprisoned, also stating that 3,000, I quote, minor offenders or innocent civilians had died from our mistakes. His argument that he's not responsible for these large-scale purges at the security centres and execution sites, because he states he was not aware of the specific incidents of crimes, is not relevant as addressed. The law does not require this level of particularity. As the appellant intended for the killings to occur, as seen in his incitement and support of them, he does not need to know exactly where they were committed. Yet, as the chamber found, he knew of the purges of specific high-level individuals, he knew of the widespread arrests and killings, and knew of the existence and operation of the charged specific security centres S21, Krang Ta Chan, Ao Kan Sang, and Phnom Krol, based on numerous sources. For example, as for S21, the trial chamber found that the appellant would have known of S21 due to his unique standing in the party as part of the small group of well-informed CPK leaders. The appellant had met Duc and instructed him that S21, Duc being the head of S21, should continue working as normal in the face of Vietnamese advances into DK territory. The trial chamber also reasonably established that the appellant knew that grave breaches were being committed against Vietnamese prisoners there. As for Krang Ta Chan, the trial chamber found that reports of deaths that were passed up to an established chain of command to the party, that Tram Kak district, where Krang Ta Chan was located, was awarded the honorary red flag of the Central Committee, to which the appellant belonged as a model district, and that the appellant is likely to have visited the district with Ta Mok, who was known to have visited Krang Ta Chan and was apprised of its operation. As for Ao Kan Song, the trial chamber found that reports regarding the progress of internal purges across the zone and inside Division 801 were sent directly to the party centre. As for Phnom Krol, the trial chamber found that Phnom Krol's security centre operated under the control of sector authorities who reported directly to the party centre at Office 870, of which the appellant was a member. Further, it heard testimony that the sector did not have any discretion to decide on the treatment of enemies or such instruction. It had to come from the centre. His argument that the chamber misrepresented his words when it found he had urged cadres to identify enemies and incite hatred towards them is unsupported and ignores similar findings of his incitement to kill enemies at other rallies and meetings. His argument that his knowledge of the arrest, detention and mistreatment of residents at Preah Vihear should be excluded because he's not charged with those incidents fail, as pattern evidence can be used to assist in proving intent and knowledge of charged crimes. Lastly, his argument that his post-DK interviews cannot be used to prove his knowledge and intent lack any legal basis. Of course, caution must be taken when using admissions to assist in proving a crime. However, the contention that admissions used in their proper context cannot be used to support any aspect of a criminal offence is meritless. He cannot explain away all of his admissions from 1980 onwards in recorded written interviews and video as information coming from someone else when the nature of the interview shows otherwise. Simply, the appellant has not established any other plausible inference that the trial chamber made an error in finding that he intended CPK, real or perceived enemies, to be killed through the enemy policy. As to the appellant's grounds that the chamber was in error in finding that he intended to participate in the cooperatives and worksite policy which involved crimes, that is not established as it disregards the totality of the evidence. The chamber found that the appellant maintained his support of the policy by 1, driving the policy by publicly promoting it whilst overseeing quotas and export for rice and other goods. 2, by monitoring the policy. 3, by being aware of the appalling living and working conditions at the cooperatives and work sites. 4, by being aware of, supporting and promoting the discrimination and identification of enemies at the work sites and cooperatives. And 5, nonetheless, continuing to advocate this policy continue at an unrelenting pace due to an enthusiasm to achieve the CPK's unrealistic goals. As to his argument that he wasn't aware of the specific incidents of the crimes as discussed, such specific knowledge is simply not required. Nonetheless, the chamber found he had knowledge of these specific cooperatives and work sites: Tram Kuk, 1st of January Dam, Trapang Tamar Dam, and Kampong Chenang Airfield. His argument that converting the population into a society of worker peasants does not demonstrate criminal intent is clearly wrong, as on the evidence the CPK forced people to the work sites, forced them to work, prohibited them from leaving, which is a key indicia of the crime of enslavement. His argument that he was not aware of the appalling working and living conditions at these locations is not established, as the chamber found that the CPK leadership received numerous reports of on-site diseases and food shortages. They found that the systematic vertical reporting regime of the CPK, combined with evidence of sector committees, numerous visits on locations, his factual knowledge of the workforce, his measures taken to rectify certain abuses, as he himself calls it, a report he received on the conditions in Priya Vihir, statements he has made, left no other possible inference that he knew of the appalling living and working conditions at the sites. Yet despite all of this, he kept pushing the workers to achieve the rapid revolution, while knowing by his own admission that they were coerced to do so. As to the argument that he wasn't aware of unequal treatment of new people at the work sites, this fails, as the chamber did not solely rely on his book, where the appellant admits to this, but they also explicitly refer to other evidence of his knowledge of this unequal treatment. Such evidence including the civil party testimony that the appellant had urged cadres to give new people a lot of work and little food. The appellant has not established an error by the chamber that would disturb its finding that he intended to enslave the population under inhumane living and working conditions, whilst individuals were being identified and targeted for execution at those work sites in order to achieve the CPK's rapid social revolution. Lastly, I'll now address the appellant's argument that the chamber made a factual error in finding that he intended crimes of forced marriage and rape as other inhumane acts to be committed pursuant to the regulation of marriage policy. Again, the allegations fail as he ignores the totality of the evidence on which the findings were made. Based on the evidence the Chamber found, the appellant intended to participate in this policy and intended to force people to marry and force consummations. 1, by giving instructions that all ministries should arrange marriages. 2, by knowing of the minimum quotas for forced marriages in the Commerce Ministry through his oversight role. 3, by encouraging in a speech, the policy goal of the CPK to rapidly increase the population. 4, encouraging CPK cadres to put the interests of the revolution, class and nation over personal and family interests. And 5, admitting that during DK period that young women were forced to marry handicapped soldiers were, I quote, fervently patriotic. In light of the highly coercive environment in which the appellant would have been acutely aware, where people were in fear of the consequences of disobeying the goals and instructions of the party and their supervisors, it was logical for the Chamber to conclude that the appellant knew his instructions and encouragement for marriages would occur and for the population to grow rapidly, that it would be done by force. The appellant has not established that the conclusion drawn by the Chamber that he intended the forced marriages and rapes to occur was unreasonable. To close, key to the appellant's failure to establish these grounds is the fundamental view, based on the evidence, that during the DK period, he and his fellow CPK leaders believed they had the right to violate their population's most basic fundamental human rights to achieve their political cause. I will now hand the floor to the International Co-Prosecutor to continue with our submissions.
Good morning, Mr. President, Your Honors, and parties. Before I discuss additional aspects of the appellant's individual criminal responsibility, I would like very briefly to address the question from the bench regarding exculpatory evidence and bias on the part of the trial chamber. If we look at some of the evidence before the trial chamber, we realize very quickly that these allegations are unfounded. For example, in the judgment, paragraphs 1130 to 1136 and 1137, the trial chamber rejects evidence about appellant's visits to certain locations, finding that the evidence is not reliable. Despite what we suggest is a typographic error relating to the Office 870 situation after Duan was arrested, the reality is the trial chamber found the evidence was insufficient to say that appellant succeeded Duan as the chairman of that office. They also found the evidence insufficient to prove him guilty as a superior. They found the evidence was not sufficient to hold him criminally liable for the genocide of the Cham. And in breaking out modes of liability into JCE and aiding and abetting, they did that because the evidence they found was insufficient to include all of the crimes which had been committed to find him guilty of those crimes based on joint criminal enterprise. So instead, as they had to do, they looked to the other forms of liability to determine if he was responsible under those forms of liability, and found the evidence proved he was guilty as an aider and abetter to murder dolus eventualis. Now, Mr. President, Your Honors, I will now address three aspects of appellant's individual criminal responsibility: his roles, functions, and close associations with other senior CPK leaders, his significant contribution to the crimes of which he stands convicted pursuant to JCE, and his aiding and abetting murder dolus eventualis at a number of crime sites. I rely on our written response for the full explanation of why appellant fails to establish his challenges to the trial chamber's analyses and findings in relation to all three of these aspects. I will highlight a few of those reasons in my remarks. Examples that I use in my submissions are equally relevant to all three of these aspects. Contrary to his submissions, appellant's many and diverse roles and functions and very close association with other senior leaders such as Pol Pot and Nguyen Chia are reflective of his privileged, trusted, senior leadership position within the CPK and gave him the authority, gravitas, platform, and knowledge to significantly contribute to the JCE crimes and to aid and abet murder dolus eventualis. Therefore, I will first focus on why appellant's piecemeal approach fails to establish any legal or factual errors worthy of appellate intervention regarding this aspect of his criminality, fully briefed in our response section 8B, paragraphs 886 to 952. Appellant cannot reasonably dispute that compelling evidence supports the trial chamber's findings on his roles, functions, and close associations. So instead, he attempts to minimize their importance. In so doing, very often he is arguing with himself. I will refer to his admissions in his book, E318, his interviews with the co-investigating judges, E327, 37, 557, his testimony before the chamber, E1, 21, 1, and E1, 198.1, his appeal brief at paragraph 1710, and some of his out-of-court interviews, E3, 108, E3, 3198, E3, 4201R, E3, 4043, and 4044. So let us consider some of his admissions which support the associated trial chamber findings. For example, he admits that he was a member of the Central Committee since 1971, a full rights member from 1976. He accepts that the Central Committee issued directives, that he attended standing committee meetings where policy decisions were made and directives were issued for their implementation. As the trial chamber found, regular reports on that implementation were received by the standing committee. Indeed, the trial chamber had before it 31 sets of minutes of standing committee meetings. Appellate attended 16 of the 22 meetings for which attendance was recorded, the most frequent attendee other than Pol Pot and Nguyen Chia. There is no reason the frequency of his attendance would be different for meetings where attendance was not recorded. Appellant noted that he attended these meetings so he would have information he needed as head of state to liaise with heads of state and to be able to speak on current issues with diplomats. This would be equally true for all meetings of this decision-making body, not just those for which attendance was recorded. So it is reasonable to conclude from his admissions and all the evidence that appellant was a frequent attendee at all standing committee meetings during the DK period. Any attendance at these meetings, especially frequent attendance, again demonstrates his trusted status as a CPK leader, as very few people were allowed to attend. His attendance at these meetings and membership in the Central Committee must be viewed in context to fully appreciate their significance for his knowledge of and assent to decisions regarding criminal policies and their implementation and the status of that implementation at lower echelons. The Central Committee appointed the members of the Standing Committee who were drawn from Central Committee members. Appellant accepts that the Standing Committee informed the Central Committee of its policies, the implementation of which the Central Committee then discussed, and that it was a forum for the dissemination of Standing Committee decisions. It is reasonable to conclude from this context that no policies were implemented that were contrary to Central Committee positions, and that appellant was privy to Standing Committee and Central Committee discussions and decisions. And at least at the Central Committee level, he had the right to speak and later to vote on, at the very least, the implementation of these decisions. Appellant also admits he was a member of Office 870, whose chairman, he says, was tasked to both implement Standing Committee decisions and to monitor suspected members of the party for the Standing Committee. The trial chamber rightly found appellant actually took part in such investigations, and also rightly found that the office, in addition, transmitted information to and from the committee and monitored implementation of its decisions. After his colleague, Duan, was arrested in early 1977, appellant remained in the office, and the office continued to operate and receive reports from lower echelons regarding, for example, economic and military matters, work activities, food shortages, and smashing internal enemies. It is reasonable to conclude appellant was privy to those reports, as by his account, he and Duan were the only members of this office, at least at the most senior level, and the information would have been important for him to have to carry out his duties as head of the DK and diplomatic liaison. As for his involvement in commercial matters, appellant admits that part of his Office 870 responsibilities was to implement Standing Committee decisions regarding distribution of products to zones and regions and to import products. He also admits he was responsible for procuring medicines, which he accepts were never sufficient to deal with the rampant illnesses among the population. Other evidence also establishes his significant oversight of commerce activities. For example, commerce-related reports flowed to him, often as the primary recipient, and he provided advice, that is guidance, on commerce-related matters to lower echelons. Appellant also admits to his close association with senior CPK leaders, in particular Pol Pot and Nuon Chea, once again showing his unique standing, power, and authority in the party. For example, he admits that Pol Pot invited him to Pol Pot's headquarters to participate and listen regarding the last offensive on Phnom Penh, on which Pol Pot personally briefed him on occasion. It was Pol Pot who took him to Phnom Penh after the city was captured. He lived and worked with Pol Pot, Nuon Chea, and other leaders at various locations after the capture of Phnom Penh, at the railway station, at the Silver Pagoda, at K1 with Pol Pot for 2 or 3 months, and at K3 where most senior leaders lived, including Nuon Chea. Pol Pot himself occasionally stayed at K3, and the Standing Committee sometimes held its meetings there. He says that during 1975 to 1978, he had contact with those within the CPK who had the right to participate in its inner meetings. But in fact, he participated in these meetings, such as the Standing Committee meetings and the multi-day meetings at the Silver Pagoda in April 1975, where policies and their implementation were discussed. His participation is no surprise, as he also admitted that between 1970 to 1975, he stayed permanently with Khmer Rouge leaders. He followed Pol Pot all the time, like a shadow. That after he, Pol Pot, and Nguyen Chia relocated to Phnom Penh following CPK victory, they did nothing separately, and knowing each other well, would talk as normal. So we see that his attempt to paint himself as a distrusted outsider with no power is proven false by his own admissions and the evidence in toto. Appellant was chosen for his multiple roles and functions because he was a valued, trusted member of the top echelon of CPK leadership, Pol Pot's shadow, a man who would abide by the CPK criminal policies and their implementation, advocate for them, and paint favorable pictures of them at home and abroad. I now turn to appellant's erroneous challenges regarding his significant contribution to JCE crimes, discussed in detail in our response section 8C2, paragraphs 1040 to 1095. First, as my colleague Mr. Smith has noted, appellant misapprehends much of the law regarding common purpose and significant contribution. He ignores that common purpose is comprised of both objective and means, and that whereas here the means are criminal, the common purpose is criminal. So his arguments regarding a non-criminal part of the common purpose are not relevant to this aspect of his criminality, as the common purpose herein was criminal. He also misapprehends what is required to establish significant contribution. That, as he did, appellant participated in some way in the furtherance of this criminal common purpose, and this participation had a direct or indirect effect on the commission of JCE crimes. His contribution must have been more than that of a mere bystander, which the evidence proves it was. Furthermore, appellant's participation need not have involved commission of a specific crime, but may take the form of assistance in or contribution to the execution of the common purpose. As this chamber made clear in F36, paragraph 984, where, as here, the common purpose was intrinsically linked to the identified criminal policies, even activities which on their face are unrelated to the commission of crimes may be considered, as such activities may support the commission of crimes, even if only indirectly. The significance of his contribution is determined taking into account factors such as his positions, the level and efficiency of his participation, and any efforts to prevent crimes. Contrary to his arguments, the evidence in this case establishes appellant's multiple important positions and functions and his high-level efficient participation. The evidence establishes only one instance where appellant intervened to prevent any of the crimes, when he used his authority to get his wife's relatives released from confinement in Preah-Vihear. In so doing, he also learned of mass arrest, detention, and starvation there. Appellant's arguments also fail because in assessing the significance of his contributions, he did not consider the totality of his activities as he was required to do and as the trial chamber did. His piecemeal approach ignores the trial chamber's extensive analysis of his multivariate contributions in paragraphs 4257, 4278. In the context of his many roles, functions, and close associations. This extensive analysis also belies appellant's claim that he is the victim of guilt by association. The judgment clearly establishes that his conduct was the basis of the trial chamber's findings, not his associations. His contributions must be assessed in light of the fact that, as he admitted, he was considered the leader of the Khmer Rouge since the 1970 coup. He was the president of the DK, the head of state. Thus, as the trial chamber rightly found, he was the face of the DK, that is, of the CPK, because, as appellant said, the CPK was the state. So his conduct was perceived to be the actions of the DK and the CPK, giving those actions tremendous impact on all with whom he interacted, directly or indirectly, at home and abroad. This is true of both his positive acts and his silent assent to decisions and pronouncements of CPK decision-making bodies and leaders. When he spoke, people listened. When he remained silent, people noticed. Highlighting a few examples of the various ways in which appellant significantly contributed to JCE crimes illustrates why his challenges do not warrant appellate intervention. He supported the criminal common purpose as a regular attendee of standing committee meetings and as a member of the Central Committee by, for example, silently assenting to or affirmatively supporting the Standing Committee's decision for state acquisition of 30, 50, or even 100% of rice production to be taken from the mouths of workers, despite knowing it was the starving, ill, enslaved workforce that was being called on as the sole source for achieving unrealistic production and construction goals. And to the Central Committee decision my colleague Mr. Smith referred to, delegating authority to lower echelons to smash, that is, execute inside and outside CPK ranks. He was informally named president of the state presidium in the same document. For this reason, and because he was a member of the Central Committee, who would also require this information to fulfill his duties as president and diplomatic liaison, it is reasonable to conclude he was aware of and assented to this decision. As a high-level CPK leader, close associate of Pol Pot and Nguyen Chia, in a system with democratic centralism, he would have been heard had he spoken out against these decisions, if not in the Standing Committee, then certainly in the Central Committee and at other meetings. Appellant publicly promoted, confirmed, and endorsed the criminal common purpose, including by participating in the multi-day meeting of the Central Committee, other senior leaders, and zone secretaries at the Silver Pagoda, where displacement of populations was justified and establishment of cooperatives and quick construction of irrigation projects were given priority. He encouraged, incited, and legitimized the implementation of the criminal common purpose through its policies, including by, as the head of the DK, and despite being aware of the plight of the workers and those imprisoned in security centers, praising the construction of dikes, canals, reservoirs, and dams by a labor force working day and night without rest, celebrating the CPK target to build irrigation projects at a pace never before attained, relying only on manual labor of tens of thousands of workers, pushing the captive population and its cadre overseers to fulfill or overfulfill production plans, to maintain under all circumstances CPK production targets. As my colleague mentioned, calling on the people to favor allegiance to Ankar over parents, as Ankar would take on the role of parents, inciting the population to hate Yuan more and more every day, and to exterminate enemies of all stripes. He instructed on the implementation of the criminal common purpose through its policies by, for example, calling for the evacuation, read that, deportation of all Vietnamese from Cambodia, later saying that Cambodia should be free of Vietnamese, identifying broad categories of people as enemies to be eliminated. He enabled and controlled implementation of the criminal common purpose and its policies by, for example, enabling the smooth functioning of the DK administration as a member of Office 870 and overseer of DK Trade and Commerce by ensuring Dewan's commerce-related responsibilities were carried out after Dewan's arrest, and by ensuring cooperatives handed over rice for export while underfed workers suffered from these acquisition policies. Considering appellant's activities in toto, as is required, refutes his challenges to the trial chamber's findings and firmly establishes that appellant's contribution to JCE crimes was significant. Finally, I turn to appellant's erroneous challenges in regard to his conviction as an aider and abettor to murder dolus eventualis. Addressed in detail in section 8D of our response, paragraphs 1247 to 1283. Appellant fails in large part because he misapprehends the legal framework for aiding and abetting. First, appellant wrongly argues that the trial chamber erred by finding he must know that a crime would likely be committed and arguing that this standard of intent did not exist at the time of his acts. In making this argument, appellant misunderstands the mens rea requirements for aiding and abetting. He erroneously conflates the requirement of knowledge of the likelihood a crime would be committed with the requirement of knowledge that his conduct will assist or facilitate the commission of a crime if it occurs. An accurate understanding of these two knowledge requirements makes clear that the trial chamber articulated and applied well-settled law that was part of international customary law at the time of appellant's conduct. As we explain in more detail in our response at paragraphs 1266 to 1270. Nor is it required that he knew the precise crime to be committed, only that he was aware that one of a number of crimes would likely be committed and a crime was in fact committed. Appellant's knowledge can be inferred from all the circumstances of this case. Those circumstances are discussed in detail in our written response and have been elaborated upon during this oral hearing, and include his own admissions of knowledge of the violence being done in his name by CPK cadre. As he says in E318, he could not bring himself to raise his voice against that violence. And his knowledge of the murderous events taking place. We also would look to the trial chamber's judgment, paragraph 4207, where the trial chamber lays out for us the policies whose implementation had begun before 1975, during a time that appellant was a member of the CPK and was in close proximity to the leaders of the CPK. And paragraph 4, Your Honors, I may be misciting this, I think it is 4208, where they talk about the fact that these policies continued into and through the DK regime. If we look at all the circumstances of this case, there's only one reasonable conclusion, that he knew both that one of a number of crimes would likely occur and that his conduct would assist or facilitate the crime if it did occur. Appellant also misapprehends the requirement he was aware of the essential elements of murder dolus eventualis, including awareness of the direct perpetrator's state of mind, though he need not have shared that state of mind. And my colleague, Ms. Worsnop, has spoken to you in detail about the state of mind required for murder dolus eventualis. the perpetrator's knowledge that the conditions would likely lead to death, or the acceptance of the possibility of this fatal consequence. Awareness of the essential elements of this crime does not require that he was aware of every criminal act or that he had technical knowledge of the elements of the crime, nor that he knew details such as time, location, and victims. While he also misapprehends the actus reus element of aiding and abetting. While his conduct must substantially contribute to the commission of a crime, it need not be a condition precedent to its commission, nor does international customary law require that his contribution have been specifically directed to the commission of a crime. Rather, proof of his substantial effect on the commission of the crime is sufficient to show his culpable link to the crime. Also, contrary to appellant's argument, aiding and abetting by encouragement, including implicit encouragement, does not require physical presence at the scene of the crime. However, when considering appellant's implicit encouragement and moral support to
The co-prosecutor, please hold on. We do not hear any translation. Yes, Mr. President, we do not hear Khmer interpretation.
I'm not sure when it went off. You remember when it went off? Let me go back to the misapprehension of the actus reus element of aiding and abetting, Your Honors, because I'm not sure when the microphone went off. While his conduct must substantially contribute to the commission of a crime, it need not be a condition precedent to its commission, nor does international customary law require that his contribution have been specifically directed to the commission of a crime. Rather, proof of his substantial effect on the commission of the crime is sufficient to show his culpable link to the crime.
Co-prosecutor, please wait. We need to change another DVD.
Aiding and abetting.
Co-prosecutor, you may continue.
Thank you, Mr. President. Also, contrary to appellant's argument, aiding and abetting by encouragement, including implicit encouragement, does not require physical presence at the scene of the crime. However, when considering appellant's implicit encouragement and moral support to the decision makers who were planning and implementing the policies regarding cooperatives, work sites, and enemies, we must remember his close proximity to them and that he was present at meetings of these decision makers, such as those of the Central Committee and other leaders at the Silver Pagoda, and of the Standing Committee, where, for example, decisions were made regarding implementation of criminal policies and unrealistic economic plans and construction targets were set, and where purges of CPK cadre were discussed and decided upon. Meetings where, again, his voice in opposition would have been heard, as discussed previously. The decision makers were aware of his silent assent or active support at these meetings, giving them additional confidence, encouragement to continue on the same destructive path regarding their criminal policies and implementation at cooperatives, work sites, and security centers, as did his calls for the execution of those who betrayed the party or revolution. To understand how his encouragement and support to the cadres substantially contributed to murder dolus eventualis, we must again consider that because of his standing, his voice was perceived to be the voice of the DK, that is, of the CPK, and required close attention. His silence on the violence being committed in his name spoke as loudly as his voice. In this context, his conduct, including public pronouncements and statements, and silent assent to the pronouncements of other senior leaders, such as Pol Pot and Nguyen Chia, in addition to his failure to voice his opposition to the violence being committed in his name, substantially affected the conduct of the cadres who committed this crime. Some examples of his public pronouncements at mass meetings of workers and cadres and his public statements help to understand his substantial contribution. For example, as my colleague mentioned, calling on the people to make all efforts to fulfill the tasks given them by the party, and in doing so, to put the interest of the nation and revolution first. Directing the cadres to transform their behavior to meet party goals and also to identify enemies. Lecturing them on the necessity of meeting production targets. Encouraging them to fulfill work plans regardless of the cost to workers. Telling attendees at these mass rallies to pass on the contents of these meetings to their base. At the same time, he was praising the workers for working day and night without rest to achieve party goals, exhorting an underfed, overworked, ill, enslaved population to eat less to achieve party goals, and to meet or exceed production targets under all circumstances. As late as 1977, continuing to advise cadres that the object of the revolution was to eliminate Lon Nol regime members, capitalist, feudalist, intellectuals. Telling cadres that new people were to be fed less and given more work, that malingerers were enemies who betrayed the party, and that those who betrayed the party or revolution would be killed, and those pulled out in that way were no loss. His public pronouncements and statements put cadres carrying out murder dolus eventualis on notice that workers must achieve the CPK production targets at all costs, and the cadres must take all necessary steps to ensure the workers did that, and made clear those steps could include working them for long hours without rest, giving them less to eat, that even those who were ill had to work, to be even harsher with the new people and to others considered enemies. Also, that the cadres must ferret out and deal accordingly with enemies, eliminate them, treat them harshly. If they died, their deaths were no loss. In short, the message to cadres was, do whatever is necessary to implement party policies and goals, regardless the impact on workers and those imprisoned as enemies, and all will be well with you. Fail to implement the policies, achieve the goals, you may well become the enemy. And it was well known what happened to enemies of the CPK. They were disappeared, tortured, and killed. Considering these examples and the evidence in toto, as we must, not in the piecemeal fashion as appellant does, it is clear that his challenges to the trial chamber's findings regarding his liability as an aider and abettor fail. The grounds of appeal relating to his conviction for aiding and abetting murder dolus eventualis should be dismissed, as should all the grounds of appeal relating to his individual criminal responsibility. Mr. President, Your Honors, if there are no questions, this concludes the prosecution's submissions on appellant's individual criminal responsibility.
We will have a recess now and resumed at 14:05. And security officer, please take the accused to his room and bring him back at 13:50. The court is now in recess.
Trongជំរះវិសម័យក្នុងតុលាការកម្ពុជាដែលគេស្គាល់ថាសាលាដីខ្មែរក្រហមត្រូវបានបង្កើតឡើងដើម្បីឆ្លើយតបទៅនឹងឧក្រិដ្ឋកម្មដែលបានប្រព្រឹត្តនៅចន្លោះថ្ងៃទី17ខែមេសាឆ្នាំ1975រហូតដល់ថ្ងៃទី6ខែមករាឆ្នាំ1979ជារយៈពេលដែលប៉ុល ពត កាន់កាប់អំណាចប្រជាជនយ៉ាងហោចណាស់1.7 លាននាក់ត្រូវបានជឿជាក់ថាត្រូវបានស្លាប់ដោយសារការធ្វើការងារហួសកម្លាំងការបង្អត់អាហារការធ្វើទារុណកម្មសម្លាប់និងលក្ខខណ្ឌរស់នៅដ៏អមនុស្សធម៌ដទៃទៀតសំណុំរឿង002 វគ្គ 2 គឺជាការជំនុំជម្រះដីទី2ប្រឆាំងទៅនឹងអតីតប្រមុខរដ្ឋខៀវសំផននិងអតីតអនុលេខាបកកុម្មុយនីសកម្ពុជាលោកនួនជាជនជាប់ចោទទាំងពីរត្រូវបានបញ្ជូនទៅជំនុំជម្រះដីកាលពីខែកញ្ញាឆ្នាំ2010ដោយសារទំហំនិងភាពស្មុគស្មាញនៃបទចោទនាពេលរស់រានមានជីវិតរបស់ជនជាប់ចោទឬក្នុងពេលដែលជនជាប់ចោទនៅអាចជំនុំជម្រះដីបានដែលការបញ្ជូនរឿងទៅជំនុំជម្រះត្រូវបានបែងចែកជាការជំនុំជម្រះដីចំនួន2ដែលហៅថាសំណុំរឿង002 វគ្គទី1និងសំណុំរឿង002 វគ្គទី2ការជំនុំជម្រះក្តីដំណាក់កាលទី1ផ្ដោតសំខាន់ទៅលើបទចោទឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិដែលតាក់ទងទៅនឹងការជំលៀសដោយបង្ខំពីទីក្រុងភ្នំពេញកាលពីខែមេសាឆ្នាំ1975និងក្រោយមកគឺមានការជំលៀសពីតំបន់ដទៃទៀតក៏មានបទចោទតាក់ទងទៅនឹងការសម្លាប់អតីតទាហានសាធារណរដ្ឋខ្មែរនៅទួលពោធិ៍ជ្រៃនៅក្នុងស្រុកកណ្ដៀងខេត្តពោធិ៍សាត់អង្គជំនុំជម្រះសាលាដំបងនៃអង្គជំនុំជម្រះវិសម័យក្នុងតុលាការកម្ពុជាហៅកាត់ថាអវតកបានរកឃើញនួនជានិងខៀវសំផនមានពិរុទ្ធពីបទឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិនិងបានសម្រេចផ្តន្ទាទោសពួកគាត់ដាក់ពន្ធនាគារអស់មួយជីវិតកាលពីថ្ងៃទី7ខែសីហាឆ្នាំ2014ទាំងការធ្វើមុខភាពការធ្វើទុកបុកម្នេញសហព្រះរាជអាជ្ញាជនជាប់ចោទទាំងពីរបានប្តឹងសារទុកទៅកាន់អង្គជំនុំជម្រះតុលាការកំពូលហើយតុលាការកំពូលបានធ្វើសវនាការរួចហើយតាក់ទងទៅនឹងបណ្ដឹងសារទុកនៅក្នុងសំណុំរឿង002/01ព្រមទាំងបានស្ដាប់សក្ខីកម្មរបស់សាក្សី3រូបកាលពីថ្ងៃទី2ទី3និងទី6ខែកក្កដាឆ្នាំ2015នៅថ្ងៃទី16 17 18ខែកក្កដាឆ្នាំ2016អង្គជំនុំជម្រះតុលាការកំពូលបានធ្វើសវនាការស្ដាប់សារណាផ្ទាល់មាត់លើបញ្ហានានា ដែលបានលើកឡើងនៅក្នុងបណ្ដឹងសារទុកនៅក្នុងសំណុំរឿង02 វគ្គ01នៅថ្ងៃទី23ខែវិច្ឆិកាឆ្នាំ2016អង្គជំនុំជម្រះតុលាការកំពូលនៃអង្គជំនុំជម្រះរាជសម្បត្តិក្នុងតុលាការកម្ពុជាបានប្រកាសសាលដីការបស់ខ្លួនលើបណ្ដឹងសារទុកប្រឆាំងនឹងសាលក្រមនៅក្នុងសំណុំរឿង002 វគ្គ1ដោយបានតម្កល់សាលក្រមរបស់អង្គជំនុំជម្រះសាលាដំបងផ្ដន្ទាទោសនួនជានិងខៀវសំផនដាក់ពន្ធនាគារអស់មួយជីវិតសំណុំរឿង002 វគ្គ2ដែលជាសំណុំរឿងបន្តពីសំណុំរឿង002 វគ្គ1មានបទចោទជារួមគឺឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិនិងការរំលោភបំពានយ៉ាងធ្ងន់ធ្ងរទៅលើអនុសញ្ញាទីក្រុងហ្សឺណែវឆ្នាំ1949ព្រមទាំងឧក្រិដ្ឋកម្មប្រល័យពូជសាសន៍អង្គជំនុំជម្រះសាលាដំបងបានសម្រេចថាទីតាំងឧក្រិដ្ឋកម្មនិងបទចោទសំខាន់ដទៃទៀតខាងក្រោមនេះគឺជាមូលដ្ឋាននៃការជំនុំជម្រះក្តីសំណុំរឿង002 វគ្គ2អំពើប្រល័យពូជសាសន៍ទៅលើជនជាតិចាមនិងជនជាតិវៀតណាមការរៀបការដោយបង្ខំនិងការរំលោភសេពសន្តិវៈនៅទូទាំងប្រទេសការបោះសម្អាតផ្ទៃក្នុងឧក្រិដ្ឋកម្មដែលបានប្រព្រឹត្តនៅមន្ទីរសន្តិសុខចំនួន4គឺមន្ទីរសន្តិសុខស21ក្រាំងតាចាន់អូកន្សែងនិងភ្នំក្រោនឧក្រិដ្ឋកម្មដែលបានប្រព្រឹត្តនៅការដ្ឋានចំនួន3គឺទំនប់1មករាទំនប់ត្រពាំងថ្មនិងការដ្ឋានសាងសង់ប្រលានយន្តហោះកំពង់ឆ្នាំងឧក្រិដ្ឋកម្មដែលបានប្រព្រឹត្តនៅសហករណ៍ត្រាំកក់ការធ្វើទុកបុកម្នេញខាងព្រះពុទ្ធសាសនាការធ្វើទុកបុកម្នេញមន្ត្រីសាធារណរដ្ឋខ្មែរកម្រិតត្រឹមសហករណ៍ត្រាំកក់ការដ្ឋានទំនប់1មករាមន្ទីរសន្តិសុខស21និងមន្ទីរសន្តិសុខក្រាំងតាចាន់សវនកម្មលើសំណុំរឿង002 វគ្គ2បានចាប់ផ្ដើមដោយសេចក្តីថ្លែងបើករបស់សហភាពអាជ្ញាកាលពីថ្ងៃទី17ខែតុលាឆ្នាំ2014
អំពើឃោរឃៅមកលើប្រជាជនកម្ពុជាមិនចេះចាប់មិនចេះហើយនឹងបានមានទ្រង់ទ្រាយកាន់តែធំទៅមិនធ្លាប់មានពីមុនដែលបានបណ្ដាលឲ្យទឹកដីកម្ពុជាពោពេញទៅដោយរដូវសាកសពនិងការបាត់បង់ជីវិតបាត់បង់បងប្អូនសាច់ញាតិនេះគឺជាកេរដំណែលដ៏សាហាវពិតដែលបានសល់ទុកដោយមេដឹកនាំបកកុម្មុយនីសកម្ពុជាដែលកំពុងអង្គុយនៅចំពោះមុខយើងទាំងអស់គ្នានៅថ្ងៃនេះដូច្នេះយើងសម្រាប់អ្នករាល់គ្នាដែលបានសួរថាតើហេតុអ្វីបានជាពួកយើងត្រូវការសាវនាការមួយទៀតនៅពេលដែលជនជាប់ចោទដែលមានវ័យចាស់ជរាបានទទួលការផ្ដន្ទាទោសអស់មួយជីវិតទៅហើយនោះចម្លើយគឺសាមញ្ញពួកយើងធ្វើនេះដោយសារប្រជាជនកម្ពុជារាប់លាននាក់ដែលបានស្លាប់ដោយសាររបបមួយនេះក្នុងកំឡុងពេល3ឆ្នាំ8ខែនិង20ថ្ងៃក្នុងរបបកម្ពុជាប្រជាធិបតេយ្យមានតែពួកជ្រាំមានតែសក្តិវិនាសនិងទុកព្រួយមានតែការឈឺចាប់និងសក្តិស្លាប់
ខ្ញុំបានទទួលស្គាល់ថាមានជនរួមជាតិជាច្រើនមានការឈឺចាប់នៅក្នុងរបបកម្ពុជាប្រជាធិបតេយ្យដែលបង្កឡើងដោយពួកបំផ្លាញស៊ីរួមទីក្នុងខ្ញុំសោកស្ដាយចំពោះទុក្ខលំបាកនោះហើយខ្ញុំសូមទទួលខុសត្រូវនៃសិលធម៌ចំពោះអំពើនេះដោយសារខ្ញុំជាមេដឹកនាំជាន់ខ្ពស់ម្នាក់នៃបកកុម្មុយនីសកម្ពុជា
នួនជាបានជម្រាបទៅចៅក្រមថាគាត់បានបង្គាប់ឲ្យមេធាវីរបស់គាត់ធ្វើពហិការមិនចូលរួមជំនុំជម្រះក្តីរហូតដល់ពេលវេលាសំណើប្តឹងដិតចិត្តរបស់គាត់ទៅលើចៅក្រមសាលាដំបងពាក់ព័ន្ធទៅនឹងកំហុសឆ្គងមួយចំនួនត្រូវបានសម្រេចជាមុនសិននៅពេលក្រោយមកក្រុមចៅក្រមពិសេសមួយត្រូវបានបង្កើតឡើងនិងបានច្រានចោលសំណើប្តឹងដិតចិត្តរបស់នួនជាហើយមេធាវីការពារក្តីរបស់គាត់ក៏បានចូលរួមនៅក្នុងការកាត់ក្តីវិញគឺរៀងមុខចោតតែនៅចំពោះមុខអង្គជំរះនេះជនជាប់ចោតទី2គឺខៀវសំផនបានជម្រាបអង្គជំនុំជម្រះសាលាដំបងថាគាត់បានបង្គាប់ឲ្យមេធាវីរបស់គាត់ចង់អារម្មណ៍តែទៅលើបណ្ដឹងសារទុកជាមុនសិនមុននឹងគាត់និងមេធាវីរបស់គាត់ចូលរួមនៅក្នុងការជំនុំជម្រះក្តីនៃសំណុំរឿង002 វគ្គ2
អាកាត់ក្តីសំណុំរឿង002លើ01អស់លោកបានកាត់ទុកខ្ញុំដោយផ្អែកលើទម្រង់ផតានិងការស្មាននានាដែលខ្ញុំជំទាស់ហើយដោយប្រើមធ្យោបាយដែលខ្ញុំយល់ឃើញថាជាការរំលោភ លើសិទ្ធិរបស់ខ្ញុំដែលខ្ញុំត្រូវមានត្រូវបានទទួលការកាក្តីដោយយុត្តិធម៌ហេតុនេះហើយបានជាខ្ញុំបានជម្រាបមេធាវីខ្ញុំឲ្យប្រឹងឧទ្ធរណ៍ដែលនៅក្នុងតុលាការនេះគេហៅថាបណ្ដឹងសារទុកសេចក្តីសំអាងហេតុនិងសេចក្តីសន្និដ្ឋានរបស់អស់លោកនៅក្នុងការកាត់ក្តីនេះបង្ហាញច្បាស់ជាមុនស្រេចទៅហើយអស់លោកនឹងសម្រេចយ៉ាងណានៅក្នុងការកាត់ក្តីសំណុំរឿង002លើ02ខាងមុខនេះគ្មានអ្វីគួរឲ្យខ្ញុំស្រពេចស្រពិលទេបើអស់លោកនៅតែប្រើរបៀបគិតគូរដែលខ្ញុំជំទាស់ដោយចំពោះមុខតុលាការកំពូលតាក់ទងនឹងការចោទប្រកាន់ថាខ្ញុំបានចូលរួមប្រព្រឹត្តសហអក្រិតកម្មរួមខ្ញុំដឹងជាមុនស្រេចទៅហើយថាអស់លោកប្រកាសជានឹងផ្ដន្ទាទោសខ្ញុំទៀតក្នុងការកាត់ក្តីដែលអស់លោកកំពុងតែបើកនៅថ្ងៃនេះ
នៅអំឡុងពេលនៃសវនាការអង្គជំនុំជម្រះសាលាដំបងបានស្ដាប់ការបង្ហាញខុសខាងលើប្រធានបទស្ដីពីសហគមន៍ត្រាំកក់រួមទាំងមន្ទីរសន្តិសុខក្រាំងកាចាន់និងការប្រព្រឹត្តលើពុទ្ធសាសនិកការដ្ឋានទំនប់1មករាការដ្ឋានសាងសង់ប្រលានយន្តហោះកំពង់ឆ្នាំងការដ្ឋានទំនប់ត្រពាំងថ្មការប្រព្រឹត្តទៅលើជនជាតិចាមនិងជនជាតិវៀតណាមមន្ទីរសន្តិសុខអូកន្សែងមន្ទីរសន្តិសុខភ្នំក្រោលនិងមន្ទីរសន្តិសុខស21និងការបោសសម្អាតផ្ទៃក្នុងការចេញបទបញ្ជាអំពីការរៀបអាពាហ៍ពិពាហ៍លក្ខណៈនៃចំនួនប្រដាប់អាវុធនិងជាចុងក្រោយអំពីទូនាទីរបស់ជនជាប់ចោទនៅថ្ងៃទី11ខែមករាឆ្នាំ2017អង្គជំនុំជម្រះសាលាដំបងបានបិទបញ្ចប់សវនាការលើកផុសតាងនៅក្នុងសំណុំរឿង002វគ្គ2ពាក់ព័ន្ធទៅនឹងបទចោទប្រកាន់ស្ដីអំពីឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិអំពើប្រល័យពូជសាសន៍និងការបំពានបំពានយ៉ាងធ្ងន់ធ្ងរលើអនុសញ្ញាក្រុងហ្សឺណែវប្រឆាំងទៅនឹងជនជាប់ចោទនួនជានិងខៀវសុផត
ប្រជាជនកម្ពុជាទូទាំងរបប
អង្គជំនុំជម្រះសាលាដំបងបានបើកសវនាការធ្វើសេចក្តីសន្និដ្ឋានផ្ទាល់មាត់បិទបញ្ចប់កិច្ចពិភាក្សាដេញដោលនៅខែមិថុនាឆ្នាំ2017
រដ្ឋវិញ្ញាម្នាក់បានផ្ដល់សេចក្តីកម្មអំពីវិជាសនកម្មដោយ
សូមជម្រាបថាអង្គជំនុំជម្រះបានធ្វើសវនាការរយៈពេល274ថ្ងៃនៅក្នុងសំណុំរឿង002វគ្គ2និងបានស្ដាប់សេចក្តីកម្មសាក្សីចំនួន114នាក់ដើមបណ្ដឹងរដ្ឋប្រវេណីចំនួន63នាក់និងអ្នកជំនាញចំនួន8នាក់លើសពីនេះទៀតអង្គជំនុំជម្រះបានផ្ដល់ឱកាសឲ្យភាគីបង្ហាញភស្តុតាងជាឯកសារសំខាន់ពាក់ព័ន្ធទៅនឹងប្រធានបទសវនាការនីមួយៗនិងបានស្ដាប់ការបញ្ជាក់បន្ថែមរបស់សហមេធាវីនាំមុខតំណាងដើមបណ្ដឹងរដ្ឋប្រវេណីស្ដីពីការទាមទារសំណងនៅក្នុងអំឡុងពេលសវនាការនៅក្នុងសំណុំរឿង002វគ្គ2នេះមានសាធារណជនសរុបចំនួន776,604នាក់បានចូលរួមស្ដាប់ដោយផ្ទាល់នៅក្នុងសាលសវនាការរបស់អង្គជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាអង្គជំនុំជម្រះសាលាដំបងនៃអង្គជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាបានប្រកាសសេចក្តីសម្អាងហេតុនិងផ្នែកនៃសេចក្តីសម្រេចនៃសាលក្រមនៅក្នុងសំណុំរឿង002/02ពាក់ព័ន្ធទៅនឹងជនជាប់ចោទនួនជានិងខៀវសំផនកាលពីថ្ងៃទី16ខែវិច្ឆិកាឆ្នាំ2018នៅក្នុងសាលសវនាការធំនៃអវតក
អង្គជំរះសាលាដំបងរកឃើញថាជនជាប់ចោទនួនជាមានបរិបទដែលបានប្រព្រឹត្តនៅលើទឹកដីនៃប្រទេសកម្ពុជាចន្លោះថ្ងៃទី17ខែមេសាឆ្នាំ1975ដល់ថ្ងៃទី6ខែមករាឆ្នាំ1979ដោយបានរៀបរាប់ដោយសង្ខេបខាងលើនេះនិងដោយលម្អិតនៅក្នុងសាលក្រមជាលិលាអក្សរតាមរយៈអំពើសកម្មនិងអកម្មចំពោះអកតកម្មទាំងឡាយដូចខាងក្រោមអកតកម្មប្រឆាំងនឹងមនុស្សជាតិតាមរយៈការធ្វើនុភាពការសម្លាប់រង្គាលការនិរទេសការធ្វើឲ្យទៅជាសតកការដាក់ក្នុងមន្ទីរឃុំឃាំងការធ្វើទុកបុកម្នេញដោយមូលហេតុនយោបាយការធ្វើទុកបុកម្នេញដោយមូលហេតុសាសនានិងការធ្វើទុកបុកម្នេញដោយមូលហេតុសាសន៍និងអំពើអនុប្រព័ន្ធផ្សេងៗទៀតក្រុមទម្រង់ជាការប៉ះពាល់ដល់សេចក្តីថ្លៃថ្នូររបស់មនុស្ស អំពើអមនុស្សធម៌ផ្សេងទៀតក្រុមតម្រង់ជាការបាត់ខ្លួនដោយបង្ខំអំពើអមនុស្សធម៌ផ្សេងទៀតក្រុមតម្រង់ជាការជំនះដោយបង្ខំនិងអំពើអមនុស្សធម៌ផ្សេងទៀតក្រុមតម្រង់ជាការរៀបអាពាហ៍ពិពាហ៍ដោយបង្ខំនិងការរំលោភផ្លូវភេទនៅក្នុងបទបទនៃការរៀបអាពាហ៍ពិពាហ៍ដោយបង្ខំអនុលោមតាមបទបញ្ញត្តិនៃវិធានមាត្រា5មាត្រា29ថ្មីនិងមាត្រា39ថ្មីនៃច្បាប់ដីពីការបង្កើតអវតកការបំពេញយ៉ាងធ្ងន់ធ្ងរលើអនុសញ្ញាទីក្រុងហ្សឺណែវតាមរយៈការធ្វើមនុស្សភាពដោយចេតនាការធ្វើទរណកម្មការធ្វើបាបដោយអវិធម៌ការបង្កដោយចេតនាឲ្យមានរបួសធ្ងន់ឬឲ្យមានការឈឺចាប់ដល់រាងកាយឬសុខភាពការដកហូតដោយចេតនាពីជ្រុយសិទ្ធិឬជនស៊ីវិលនៅសិទ្ធិទទួលបានការកាត់ទោសដោយយុត្តិធម៌និងទៀងទាត់និងការឃុំខ្លួនជនស៊ីវិលដែលខុសច្បាប់អនុលោមតាមមាត្រា6មាត្រា29ថ្មីនិងមាត្រា39ថ្មីនៃច្បាប់ស្តីពីការបង្កើតអវតកឧក្រិដ្ឋកម្មបល័យពិសាសតាមរយៈការធ្វើមនុស្សឃាតលើសមាជិកនៃក្រុមជនជាតិវៀតណាមនិងជនជាតិចាមអង្គជំនះសាលាដំបងរកឃើញថាជនជាប់ចោទគឺសំផនមានវិរុទ្ធដែលបានប្រព្រឹត្តនៅលើទឹកដីនៃប្រទេសកម្ពុជានៅចន្លោះពីថ្ងៃ17ខែមេសាឆ្នាំ1975រហូតដល់ថ្ងៃទី6ខែមករាឆ្នាំ1979ដោយបានរៀបរាប់ដោយសង្ខេបខាងលើអង្គជំរះបានពិចារណាទៅលើភាពធ្ងន់ធ្ងរនៃអកតកម្មរួមទាំងទំហំនិងភាពសាហាវព្រៃផ្សៃក៏ដូចជាចំនួននិងភាពទន់ខ្សោយរបស់ជនរងគ្រោះដែលជនជាប់ចោទត្រូវបានរកឃើញមានប្រវត្តិភាពរួមទាំងស្ថានទម្ងន់និងស្ថានដំណើរទោសនានាដែលពាក់ព័ន្ធអង្គជំរះសម្រាប់ផ្ដន្ទាទោសជនជាប់ចោទនួនជាដាក់ពន្ធនាគារអស់មួយជីវិតដោយពិចារណាលើការផ្ដន្ទាទោសដាក់ពន្ធនាគារអស់មួយជីវិតចំពោះគាត់នៅក្នុងតំណរឿង002/01អង្គជំរះសម្រាប់រួមបញ្ចូលគ្នានៅការផ្ដន្ទាទោសទាំងពីរទៅជាការផ្ដន្ទាទោសដាក់ពន្ធនាគារអស់មួយជីវិតតែមួយអង្គជំរះសម្រាប់ផ្ដន្ទាទោសជនជាប់ចោទគឺសំផនដាក់ពន្ធនាគារអស់មួយជីវិតដោយពិចារណាទៅលើការផ្ដន្ទាទោសដាក់ពន្ធនាគារអស់មួយជីវិតចំពោះគាត់នៅក្នុងតំណរឿង002/01អង្គជំរះសម្រាប់រួមបញ្ចូលគ្នានៅការផ្ដន្ទាទោសទាំងពីរទៅជាការផ្ដន្ទាទោសដាក់ពន្ធនាគារអស់មួយជីវិតតែមួយ
សាធារណជនប្រមាណជាជាង700នាក់រួមមានតំណាងរាជរដ្ឋាភិបាលកម្ពុជាតំណាងអង្គការសហប្រជាជាតិនិងមន្ត្រីអង្គទូតអង្គការសង្គមស៊ីវិលនានារួមនឹងសាធារណជននិងអ្នកសារព័ត៌មានជាតិនិងអន្តរជាតិបានចូលរួមស្ដាប់ការប្រកាសសារក្រមជាប្រវត្តិសាស្ត្រនេះយើងខ្ញុំសូមរំលឹកសាធារណជនថានៅក្នុងដំណាក់កាលនេះបទចោទប្រឆាំងទៅនឹងនួនជានិងឃ្យូសំផននៅក្នុងសំណុំរឿង002/2គ្រាន់តែជាការចោទប្រកាន់តែប៉ុណ្ណោះមិនទាន់មានការសម្រេចជាស្ថាពរនៅឡើយទេថាតើជនជាប់ចោទទាំងពីរមានទោសឬក៏គ្មានទោសជនជាប់ចោទទាំងពីរត្រូវបានសន្មតទុកជាមុនថាគ្មានទោសដរាបណាសាលដីកាស្ថាពរមិនទាន់ចូលជាធរមាននៅឡើយអង្គជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាដែលគេស្គាល់ថាសាលាដីខ្មែរក្រហមត្រូវបានបង្កើតឡើងដើម្បីឆ្លើយតបទៅនឹងឧក្រិដ្ឋកម្មដែលបានប្រព្រឹត្តនៅចន្លោះថ្ងៃទី17ខែមេសាឆ្នាំ1975រហូតដល់ថ្ងៃទី6ខែមករាឆ្នាំ1979ជារយៈពេលដែលប៉ុល ពតកាន់កាប់អំណាចប្រជាជនយ៉ាងហោចណាស់1,700,000 នាក់ត្រូវបានជឿជាក់ថាត្រូវបានស្លាប់ដោយសារការធ្វើការងារហួសកម្លាំងការបង្អត់អាហារការធ្វើទារុណកម្មសម្លាប់និងលក្ខខណ្ឌរស់នៅដ៏អមនុស្សធម៌ដទៃទៀតសំណុំរឿង002/2គឺជាការជំនុំជម្រះដីទី2ប្រឆាំងទៅនឹងអតីតប្រមុខរដ្ឋខៀវសំផននិងអតីតអនុលេខាបកកុម្មុយនីសកម្ពុជាលោកនួនជា ជនជាប់ចោតទាំងពីរត្រូវបានបញ្ជូនទៅជំនុំជម្រះក្តីកាលពីខែកញ្ញាឆ្នាំ2010ដោយសារទំហំនិងភាពស្មុគស្មាញនៃបទចោទនាពេលរស់រានមានជីវិតរបស់ជនជាប់ចោតឬក្នុងពេលដែលជនជាប់ចោតនៅអាចជំនុំជម្រះក្តីបានដែលការបញ្ជូនរឿងទៅជំនុំជម្រះត្រូវបានបែងចែកជាការជំនុំជម្រះក្តីចំនួន2ដែលហៅថាសំណុំរឿង002វគ្គទី1និងសំណុំរឿង002វគ្គទី2ការជំនុំជម្រះក្តីដំណាក់កាលទី1ផ្ដោតសំខាន់ទៅលើបទចោទឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិដែលតាក់ទងទៅនឹងការជំនះដោយបង្ខំពីទីក្រុងភ្នំពេញកាលពីខែមេសាឆ្នាំ1975និងក្រោយមកគឺមានការជំនះពីតំបន់ដទៃទៀតក៏មានបទចោទតាក់ទងទៅនឹងការសម្លាប់អតីតទាហានសាធារណរដ្ឋខ្មែរនៅទួលពោធិ៍ជ្រៃនៅក្នុងស្រុកកណ្ដៀងខេត្តពោធិ៍សាត់អង្គជំនុំជម្រះសាលាដំបូងនៃអង្គជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាហៅកាត់ថាអវតកបានរកឃើញនួនជានិងខៀវសំផនមានពិរុទ្ធពីបទឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិនិងបានសម្រេចផ្តន្ទាទោសពួកគាត់ដាក់ពន្ធនាគារអស់មួយជីវិតកាលពីថ្ងៃទី7ខែសីហាឆ្នាំ2014
ទាំងការធ្វើមុខភាពការធ្វើទុកបុកម្នេញ
សហព្រះរាជអាជ្ញាជនជាប់ចោទទាំងពីរបានប្តឹងសារទុកទៅកាន់អង្គជំនុំជម្រះតុលាការកំពូលហើយតុលាការកំពូលបានធ្វើសវនាការរួចហើយតាក់ទងទៅនឹងបណ្ដឹងសារទុកនៅក្នុងសំណុំរឿង002/01ព្រមទាំងបានស្ដាប់សក្ខីកម្មរបស់សាក្សី3រូបកាលពីថ្ងៃទី2ទី3និងទី6ខែកក្កដាឆ្នាំ2015នៅថ្ងៃទី16 17 18ខែកក្កដាឆ្នាំ2016អង្គជំនុំជម្រះតុលាការកំពូលបានធ្វើសវនាការស្ដាប់សារណាផ្ទាល់មាត់លើបញ្ហានានាដែលបានលើកឡើងនៅក្នុងបណ្ដឹងសារទុកនៅក្នុងសំណុំរឿង02វគ្គ01នៅថ្ងៃទី23ខែវិច្ឆិកាឆ្នាំ2016អង្គជំនុំជម្រះតុលាការកំពូលនៃអង្គជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាបានប្រកាសសាលដីការបស់ខ្លួនលើបណ្ដឹងសារទុកប្រឆាំងនឹងសាលក្រមនៅក្នុងសំណុំរឿង002វគ្គ1ដោយបានតម្កល់សាលក្រមរបស់អង្គជំនុំជម្រះសាលាដំបូងផ្ដន្ទាទោសនួនជានិងខៀវសំផនដាក់ពន្ធនាគារអស់មួយជីវិតសំណុំរឿង002វគ្គ2ដែលជាសំណុំរឿងបន្តពីសំណុំរឿង002វគ្គ1មានបទចោទជារួមគឺឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិនិងការរំលោភបំពានយ៉ាងធ្ងន់ធ្ងរទៅលើអនុសញ្ញាក្រុងហ្សឺណែវឆ្នាំ1949ព្រមទាំងឧក្រិដ្ឋកម្មប្រល័យពូជសាសន៍អង្គជំនុំជម្រះសាលាដំបូងបានសម្រេចថាទីតាំងឧក្រិដ្ឋកម្មនិងបទចោទសំខាន់ដទៃទៀតខាងក្រោមនេះគឺជាមូលដ្ឋាននៃការជំនុំជម្រះក្តីសំណុំរឿង002វគ្គ2អំពើប្រល័យពូជសាសន៍ទៅលើជនជាតិចាមនិងជនជាតិវៀតណាមការរៀបការដោយបង្ខំនិងការរំលោភសេពសន្តិវៈនៅទូទាំងប្រទេសការបោះសម្អាតផ្ទៃក្នុងឧក្រិដ្ឋកម្មដែលបានប្រព្រឹត្តនៅមន្ទីរសន្តិសុខចំនួន4គឺមន្ទីរសន្តិសុខស21ក្រាំងតាច័ន្ទអូកន្សែងនិងភ្នំក្រោលឧក្រិដ្ឋកម្មដែលបានប្រព្រឹត្តនៅការដ្ឋានចំនួន3គឺទំនប់1មករាទំនប់ត្រពាំងថ្មនិងការដ្ឋានសាងសង់ប្រលានយន្តហោះកំពង់ឆ្នាំងឧក្រិដ្ឋកម្មដែលបានប្រព្រឹត្តនៅសហករណ៍ត្រាំកក់ការធ្វើទុកបុកម្នេញខាងព្រះពុទ្ធសាសនាការធ្វើទុកបុកម្នេញមន្ត្រីសាធារណរដ្ឋខ្មែរកម្រិតត្រឹមសហករណ៍ត្រាំកក់ការដ្ឋានទំនប់1មករាមន្ទីរសន្តិសុខស21និងមន្ទីរសន្តិសុខក្រាំងតាច័ន្ទសវនកម្មលើសំណុំរឿង002វគ្គ2បានចាប់ផ្ដើមដោយសេចក្តីថ្លែងបើករបស់សហព្រះអាជ្ញាកាលពីថ្ងៃទី17ខែតុលាឆ្នាំ2014
អំពើឃោរឃៅមកលើប្រជាជនកម្ពុជាមិនចេះចប់មិនចេះហើយនឹងបានមានទ្រង់ទ្រាយកាន់តែធំទៅមិនធ្លាប់មានពីមុនដែលបានបណ្ដាលឲ្យទឹកដីកម្ពុជាពោពេញទៅដោយរដូវសាកសពនិងការបាត់បង់ជីវិតបាត់បង់បងប្អូនសាច់ញាតិនេះគឺជាគេដំណើរដ៏សាហាវពិតដែលបានសល់ទុកឲ្យមេដឹកនាំបកកុម្មុយនីសកម្ពុជាដែលកំពុងអង្គុយនៅចំពោះមុខយើងទាំងអស់គ្នានៅថ្ងៃនេះដូច្នេះយើងសម្រាប់អ្នករាល់គ្នាដែលបានសួរថាតើហេតុអ្វីបានជាពួកយើងត្រូវការសវនាការមួយទៀតនៅពេលដែលជនជាប់ចោទដែលមានវ័យចាស់ជរាបានទទួលការផ្តន្ទាទោសអស់មួយជីវិតទៅហើយនោះចម្លើយគឺសាមញ្ញពួកយើងធ្វើនេះដោយសារប្រជាជនកម្ពុជារាប់លាននាក់ដែលបានស្លាប់ដោយសាររបបមួយនេះក្នុងកំឡុងពេល3ឆ្នាំ8ខែនិង20ថ្ងៃក្នុងរបបកម្ពុជាប្រជាធិបតេយ្យមានតែពួកជ្រាំមានតែសក្តិវិនាសនិងទុកព្រួយមានតែការឈឺចាប់និងសក្តិស្លាប់
ខ្ញុំបានទទួលស្គាល់ថា មានជនរួមជាតិជាច្រើនមានការឈឺចាប់នៅក្នុងរបបកម្ពុជាប្រជាធិបតេយ្យដែលបង្កឡើងដោយពួកបំផ្លាញស៊ីរួមទីក្នុងខ្ញុំសោកស្ដាយចំពោះទុក្ខលំបាកនោះហើយខ្ញុំសូមទទួលខុសត្រូវនៃសិលធម៌ចំពោះអំពើនេះដោយសារខ្ញុំជាមេដឹកនាំជាន់ខ្ពស់ម្នាក់នៃបកកុម្មុយនីសកម្ពុជា
នួនជាបានជម្រាបទៅចៅក្រមថាគាត់បានបង្គាប់ឲ្យមេធាវីរបស់គាត់ធ្វើពហិការបញ្ចូលរួមជំនុំជម្រះក្តីរហូតដល់ពេលវេលាសំណើប្តឹងដិតចិត្តរបស់គាត់ទៅលើចៅក្រមសាលាដំបងពាក់ព័ន្ធទៅនឹងកំហុសឆ្គងមួយចំនួនត្រូវបានសម្រេចជាមុនសិននៅពេលក្រោយមកក្រុមចៅក្រមពិសេសមួយត្រូវបានបង្កើតឡើងនិងបានច្រានចោលសំណើប្តឹងដិតចិត្តរបស់នួនជាហើយមេធាវីការពារក្តីរបស់គាត់ក៏បានចូលរួមនៅក្នុងការកាត់ក្តីវិញ
គឺរៀងវងតតែនៅចំពោះមុខអង្គជំរះនេះ
ជនជាប់ចោតទី 2 គឺខៀវសំផតបានជម្រាបអង្គជំនុំជម្រះសាលាដំបងថាគាត់បានបង្គាប់ឲ្យមេធាវីរបស់គាត់ចង់អារម្មណ៍តែទៅលើបណ្ដឹងសារទុកជាមុនសិនមុននឹងគាត់និងមេធាវីរបស់គាត់ចូលរួមនៅក្នុងការជំនុំជម្រះក្តីនៃសំណុំរឿង 002 វគ្គ 2
អាកាត់ក្តីសំណុំរឿង 002 លើ 01 អស់លោកបានកាត់ទុកខ្ញុំ ដោយផ្អែកលើទម្រង់ផតានិងការស្មាននានាដែលខ្ញុំជំទាស់ហើយដោយប្រើមធ្យោបាយដែលខ្ញុំយល់ឃើញថាជាការរំលោភលើសិទ្ធិរបស់ខ្ញុំដែលខ្ញុំត្រូវមានត្រូវបានទទួលការកាត់ក្តីដោយយុត្តិធម៌ ហើយនេះហើយបានជាខ្ញុំបានជម្រាបមេធាវីខ្ញុំឲ្យប្រឹងឧទ្ធរណ៍ដែលនៅក្នុងតុលាការនេះគេហៅថាបណ្ដឹងសារទុកសេចក្តីសំអាងហេតុនិងសេចក្តីសន្និដ្ឋានរបស់អស់លោកនៅក្នុងការកាត់ក្តីនេះបង្ហាញច្បាស់ជាមុនស្រេចទៅហើយអស់លោក នឹងសម្រាប់យ៉ាងណានៅក្នុងការកាត់ក្តីសំណុំរឿង 002 លើ 02 ខាងមុខនេះគ្មានអ្វីគួរឲ្យខ្ញុំស្រពេចស្រពិលទេបើអស់លោកនៅតែប្រើរបៀបគិតគូរដែលខ្ញុំជំទាស់ទៅចំពោះមុខតុលាការកំពូល តាក់ទងនឹងការចោទប្រកាន់ថាខ្ញុំបានចូលរួមប្រព្រឹត្តសហអក្រិតកម្មរួមខ្ញុំដឹងជាមុនស្រេចទៅហើយថាអស់លោកប្រកាសជានឹងផ្ដល់ទាទោសខ្ញុំទៀតក្នុងការកាត់ក្តីដែលអស់លោកកំពុងតែបើកនៅថ្ងៃនេះ
នៅអំឡុងពេលនៃសវនាការអង្គជំនុំជម្រះសាលាដំបងបានស្ដាប់ការបង្ហាញខុសខាងលើប្រធានបទស្ដីពីសហគមន៍ត្រាំកក់រួមទាំងមន្ទីរសន្តិសុខក្រាំងតាចាន់និងការប្រព្រឹត្តលើពុទ្ធសាសនិកការដ្ឋានទំនប់1មករាការដ្ឋានសាងសង់ប្រលានយន្តហោះកំពង់ឆ្នាំងការដ្ឋានទំនប់ត្រពាំងថ្មការប្រព្រឹត្តទៅលើជនជាតិចាមនិងជនជាតិវៀតណាមមន្ទីរសន្តិសុខអូកន្សែងមន្ទីរសន្តិសុខភ្នំក្រោលនិងមន្ទីរសន្តិសុខស21និងការបោសសម្អាតផ្ទៃក្នុងការចេញប័ណ្ណបញ្ជាអំពីការរៀបអាពាហ៍ពិពាហ៍ លក្ខណៈនៃចំនួនប្រដាប់អាវុធនិងជាចុងក្រោយអំពីទូនាទីរបស់ជនជាប់ចោទនៅថ្ងៃទី 11 ខែមករាឆ្នាំ 2017 អង្គជំនុំជម្រះសាលាដំបងបានបិទបញ្ចប់សវនាការលើកផុសតាងនៅក្នុងសំណុំរឿង 002 វគ្គ 2 ពាក់ព័ន្ធទៅនឹងបទចោទប្រកាន់ស្ដីអំពីឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិអំពើប្រល័យពូជសាសន៍និងការបំពានបំពានយ៉ាងធ្ងន់ធ្ងរលើអនុសញ្ញាទីក្រុងហ្សឺណែវប្រឆាំងទៅនឹងជនជាប់ចោទនួនជានិងខៀវសំផត
ប្រជាជនកម្ពុជាទូទាំងរបប
អង្គជំនុំជម្រះសាលាដំបងបានបើកសវនាការធ្វើសេចក្តីសន្និដ្ឋានផ្ទាល់មាត់បិទបញ្ចប់កិច្ចពិភាក្សាដេញដោលនៅខែមិថុនាឆ្នាំ 2017
រដ្ឋវិនិម្នាក់ម្នាក់បានផ្ដល់សក្ខីកម្មអំពីវិជាសនកម្មដោយ
សូមជម្រាបថាអង្គជំនុំជម្រះបានធ្វើសវនាការរយៈពេល 274 ថ្ងៃនៅក្នុងសំណុំរឿង 002 វគ្គ 2 និងបានស្ដាប់សក្ខីកម្មសាក្សីចំនួន 114 នាក់ ដើមបណ្ដឹងរដ្ឋប្រវេណីចំនួន63នាក់និងអ្នកជំនាញចំនួន8នាក់លើសពីនេះទៀតអង្គជំនុំជម្រះបានផ្ដល់ឱកាសឲ្យភាគីបង្ហាញផុសតាងជាឯកសារសំខាន់ពាក់ព័ន្ធទៅនឹងប្រធានបទសវនាការនីមួយៗនិងបានស្ដាប់ការបញ្ជាក់បន្ថែមរបស់សហមេធាវីនាំមុខតំណាងដើមបណ្ដឹងរដ្ឋប្រវេណីស្ដីពីការទាមទារសំណងនៅក្នុងអំឡុងពេលសវនាការនៅក្នុងសំណុំរឿង002វគ្គ2នេះមានសាធារណជនសរុបចំនួន 776,604 នាក់បានចូលរួមស្ដាប់ដោយផ្ទាល់នៅក្នុងសារសវនាការរបស់អង្គជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាអង្គជំនុំជម្រះសាលាដំបូងនៃអង្គជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាបានប្រកាសសេចក្តីសម្អាងហេតុនិងផ្នែកនៃសេចក្តីសម្រេចនៃសាលក្រមនៅក្នុងសំណុំរឿង 002/02 ពាក់ព័ន្ធទៅនឹងជនជាប់ចោទនួនជានិងខៀវសំផនកាលពីថ្ងៃទី 16 ខែវិច្ឆិកាឆ្នាំ 2018 នៅក្នុងសារសវនាការធំនៃអវតក
អង្គជំរះសាលាដំបងរកឃើញថាជនជាប់ចោទនួនជាមានបរិទ្ធដែលបានប្រព្រឹត្តនៅលើទឹកដីនៃប្រទេសកម្ពុជាចន្លោះថ្ងៃទី 17 ខែមេសាឆ្នាំ 1975 ដល់ថ្ងៃទី 6 ខែមករាឆ្នាំ 1979 ដោយបានរៀបរាប់ដោយសង្ខេបខាងលើនេះនិងដោយលម្អិតនៅក្នុងសារក្រមជាលិលាអក្សរតាមរយៈអំពើសកម្មនិងអកម្មចំពោះអកតកម្មទាំងឡាយដូចខាងក្រោមអកតកម្មប្រឆាំងនឹងមនុស្សជាតិតាមរយៈការធ្វើនុភាពការសម្លាប់រង្គាលការនិរទេសការធ្វើឲ្យទៅជាសេដ្ឋករការដាក់ក្នុងមន្ទីរឃុំឃាំងការធ្វើទុកបុកម្នេញដោយមូលហេតុនយោបាយការធ្វើទុកបុកម្នេញដោយមូលហេតុសាសនានិងការធ្វើទុកបុកម្នេញដោយមូលហេតុសាសន៍និងអំពើអយុត្តិធម៌ផ្សេងៗទៀតក្រុមទម្រង់ជាការប៉ះពាល់ដល់សេចក្តីថ្លៃថ្នូររបស់មនុស្សអំពើអមនុស្សធម៌ផ្សេងៗទៀតក្រុមទម្រង់ជាការបាត់ខ្លួនដោយបង្ខំអំពើអមនុស្សធម៌ផ្សេងៗទៀតក្រុមទម្រង់ជាការជំលះដោយបង្ខំនិងអំពើអមនុស្សធម៌ផ្សេងៗទៀតក្រុមទម្រង់ជាការរៀបអាពាហ៍ពិពាហ៍ដោយបង្ខំនិងការរំលោភផ្លូវភេទនៅក្នុងបទបទនៃការរៀបអាពាហ៍ពិពាហ៍ដោយបង្ខំអនុលោមតាមបទបញ្ញត្តិនៃវិធានមាត្រា5មាត្រា29ថ្មីនិងមាត្រា39ថ្មីនៃច្បាប់នៃពីការបង្កើតអវតកការបំពេញបំពេញយ៉ាងធ្ងន់ធ្ងរលើអនុសញ្ញាទីក្រុងហ្សឺណែវតាមរយៈការធ្វើមនុស្សភាពដោយចេតនាការធ្វើទរណកម្មការធ្វើបាបដោយអវិជ្ជធម៌ការបង្កដោយចេតនាឲ្យមានរបួសធ្ងន់ឬឲ្យមានការឈឺចាប់ដល់រាងកាយឬសុខភាពការដកហូតដោយចេតនាពីជ្រើសិទ្ធិឬជនស៊ីវិលនៅសិទ្ធិទទួលបានការកាត់ទោសដោយយុត្តិធម៌និងទៀងទាត់និងការឃុំខ្លួនជនស៊ីវិលដែលខុសច្បាប់អនុលោមតាមមាត្រា6មាត្រា29ថ្មីនិងមាត្រា39ថ្មីនៃច្បាប់ស្តីពីការបង្កើតអវតកឧក្រិដ្ឋកម្មបលាយពិសាសតាមរយៈការធ្វើមនុស្សភាពលើសមាជិកនៃក្រុមជនជាតិវៀតណាមនិងជនជាតិចាមអង្គជំរះសាលាដំបងរកឃើញថាជនជាប់ចោទគឺសំផនមានវិរុទ្ធដែលបានប្រព្រឹត្តនៅលើទឹកដីនៃប្រទេសកម្ពុជាដោយចន្លោះពីថ្ងៃ 17 ខែមេសាឆ្នាំ 1975 រហូតដល់ថ្ងៃទី 6 ខែមករាឆ្នាំ 1979 ដោយបានរៀបរាប់ដោយសង្ខេបខាងលើអង្គជំរះបានពិចារណាទៅលើភាពធ្ងន់ធ្ងរនៃអកតកម្មរួមទាំងទំហំនិងភាពសាហាវព្រៃផ្សៃក៏ដូចជាចំនួននិងភាពទន់ខ្សោយរបស់ជនរងគ្រោះដែលជនជាប់ចោទត្រូវបានរកឃើញមានប្រសិទ្ធភាពរួមទាំងស្ថានទម្ងន់និងស្ថានតម្រូវទោសនានាដែលពាក់ព័ន្ធអង្គជំរះសម្រាប់ផ្តន្ទាទោសជនជាប់ចោទនួនជាដាក់ពន្ធនាគារអស់មួយជីវិតដោយពិចារណាលើការផ្តន្ទាទោសដាក់ពន្ធនាគារអស់មួយជីវិតចំពោះគាត់នៅក្នុងសំណុំរឿង 002/01 អង្គជំរះសម្រាប់រួមបញ្ចូលគ្នានៅការផ្តន្ទាទោសទាំងពីរទៅជាការផ្តន្ទាទោសដាក់ពន្ធនាគារអស់មួយជីវិតតែមួយអង្គជំរះសម្រាប់ផ្តន្ទាទោសជនជាប់ចោទគឺសំផនដាក់ពន្ធនាគារអស់មួយជីវិតដោយពិចារណាទៅលើការផ្តន្ទាទោសដាក់ពន្ធនាគារអស់មួយជីវិតចំពោះគាត់នៅក្នុងសំណុំរឿង 002/01 អង្គជំរះសម្រាប់រួមបញ្ចូលគ្នានៅការផ្តន្ទាទោសទាំងពីរទៅជាការផ្តន្ទាទោសដាក់ពន្ធនាគារអស់មួយជីវិតតែមួយ
សាធារណជនប្រមាណជាជាង 700 នាក់រួមមានតំណាងរាជរដ្ឋាភិបាលកម្ពុជាតំណាងអង្គការសហប្រជាជាតិនិងមន្ត្រីអង្គទូតអង្គការសង្គមស៊ីវិលនានារួមនឹងសាធារណជននិងអ្នកសារព័ត៌មានជាតិនិងអន្តរជាតិបានចូលរួមស្ដាប់ការប្រកាសសារក្រមជាប្រវត្តិសាស្ត្រនេះ យើងខ្ញុំសូមរំលឹកសាធារណជនថានៅក្នុងដំណាក់កាលនេះបទចោទប្រឆាំងទៅនឹងនួនជានិងឃីវសំផននៅក្នុងសំណុំរឿង002 វគ្គ 2 គ្រាន់តែជាការចោទប្រកាន់តែប៉ុណ្ណោះមិនទាន់មានការសម្រេចជាស្ថាពរនៅឡើយទេថាតើជនជាប់ចោទទាំងពីរមានទោសឬក៏គ្មានទោសជនជាប់ចោទទាំងពីរត្រូវបានសន្មត់ទុកជាមុនថាគ្មានទោសដរាបណាសាលដីកាស្ថាពរមិនទាន់ចូលជាធរមាននៅឡើយអង្គជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាដែលគេស្គាល់ថាសាលាដីខ្មែរក្រហមត្រូវបានបង្កើតឡើងដើម្បីឆ្លើយតបទៅនឹងឧក្រិដ្ឋកម្មដែលបានប្រព្រឹត្តនៅចន្លោះថ្ងៃទី17 ខែមេសាឆ្នាំ1975រហូតដល់ថ្ងៃទី6 ខែមករាឆ្នាំ1979ជារយៈពេលដែលប៉ុល ពតកាន់កាប់អំណាចប្រជាជនយ៉ាងហោចណាស់1.7 លាននាក់ត្រូវបានជឿជាក់ថាត្រូវបានស្លាប់ដោយសារការធ្វើការងារហួសកម្លាំងការបង្អត់អាហារការធ្វើទារុណកម្មសម្លាប់និងលក្ខខណ្ឌរស់នៅដ៏អមនុស្សធម៌ដទៃទៀតសំណុំរឿង002 វគ្គ 2 គឺជាការជំនុំជម្រះដីទី2ប្រឆាំងទៅនឹងអតីតប្រមុខរដ្ឋខៀវសំផននិងអតីតអនុលេខាបកកុម្មុយនីសកម្ពុជាលោកនួនជាជនជាប់ចោទទាំងពីរត្រូវបានបញ្ជូនទៅជំនុំជម្រះដីកាលពីខែកញ្ញាឆ្នាំ2010ដោយសារទំហំនិងភាពស្មុគស្មាញនៃបទចោទនាពេលរស់រានមានជីវិតរបស់ជនជាប់ចោទឬក្នុងពេលដែលជនជាប់ចោទនៅអាចជំនុំជម្រះដីបានដែលការបញ្ជូនរឿងទៅជំនុំជម្រះត្រូវបានបែងចែកជាការជំនុំជម្រះដីចំនួន2ដែលហៅថាសំណុំរឿង002 វគ្គទី1និងសំណុំរឿង002 វគ្គទី2ការជំនុំជម្រះក្តីដំណាក់កាលទី1ផ្ដោតសំខាន់ទៅលើបទចោទឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិដែលតាក់ទងទៅនឹងការជំនះដោយបង្ខំពីទីក្រុងភ្នំពេញកាលពីខែមេសាឆ្នាំ1975និងក្រោយមកគឺមានការជំនះពីតំបន់ដទៃទៀតក៏មានបទចោទតាក់ទងទៅនឹងការសម្លាប់អតីតទាហានសាធារណរដ្ឋខ្មែរនៅទួលពោធិ៍ជ្រៃនៅក្នុងស្រុកកណ្ដៀងខេត្តពោធិ៍សាត់អង្គជំនុំជម្រះសាលាដំបងនៃអង្គជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាហៅកាត់ថាអវតកបានរកឃើញនួនជានិងឃីវសំផនមានពិរុទ្ធពីបទឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិនិងបានសម្រេចផ្តន្ទាទោសពួកគាត់ដាក់ពន្ធនាគារអស់មួយជីវិតកាលពីថ្ងៃទី7 ខែសីហាឆ្នាំ2014រួមទាំងការធ្វើមុខភាពការធ្វើទុកបុកម្នេញសហព្រះរាជអាជ្ញាជនជាប់ចោទទាំងពីរបានប្តឹងសារទុកទៅកាន់អង្គជំនុំជម្រះតុលាការកំពូលហើយតុលាការកំពូលបានធ្វើសវនាការរួចហើយតាក់ទងទៅនឹងបណ្ដឹងសារទុកនៅក្នុងសំណុំរឿង002/01ព្រមទាំងបានស្ដាប់សក្ខីកម្មរបស់សាក្សី3រូបកាលពីថ្ងៃទី2 ទី 3 និងទី 6 ខែកក្កដាឆ្នាំ2015នៅថ្ងៃទី16, 17, 18 ខែកក្កដាឆ្នាំ2016អង្គជំនុំជម្រះតុលាការកំពូលបានធ្វើសវនាការស្ដាប់សារណាផ្ទាល់មាត់លើបញ្ហានានាដែលបានលើកឡើងនៅក្នុងបណ្ដឹងសារទុកនៅក្នុងសំណុំរឿង002 វគ្គ 01នៅថ្ងៃទី23 ខែវិច្ឆិកាឆ្នាំ2016អង្គជំនុំជម្រះតុលាការកំពូលនៃអង្គជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាបានប្រកាសសាលដីការបស់ខ្លួនលើបណ្ដឹងសារទុកប្រឆាំងនឹងសាលក្រមនៅក្នុងសំណុំរឿង002 វគ្គ 1ដោយបានតម្កល់សាលក្រមរបស់អង្គជំនុំជម្រះសាលាដំបងផ្តន្ទាទោសនួនជានិងឃីវសំផនដាក់ពន្ធនាគារអស់មួយជីវិតសំណុំរឿង002 វគ្គ 2ដែលជាសំណុំរឿងបន្តពីសំណុំរឿង002 វគ្គ 1មានបទចោទជារួមគឺឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិនិងការរំលោភបំពានយ៉ាងធ្ងន់ធ្ងរទៅលើអនុសញ្ញាទីក្រុងហ្សឺណែវឆ្នាំ1949ព្រមទាំងឧក្រិដ្ឋកម្មប្រល័យពូជសាសន៍អង្គជំនុំជម្រះសាលាដំបងបានសម្រេចថាទីតាំងឧក្រិដ្ឋកម្មនិងបទចោទសំខាន់ដទៃទៀតខាងក្រោមនេះគឺជាមូលដ្ឋាននៃការជំនុំជម្រះក្តីសំណុំរឿង002 វគ្គ 2អំពើប្រល័យពូជសាសន៍ទៅលើជនជាតិចាមនិងជនជាតិវៀតណាមការរៀបការដោយបង្ខំនិងការរំលោភសេពសន្តិវៈនៅទូទាំងប្រទេសការបោសសម្អាតផ្ទៃក្នុងឧក្រិដ្ឋកម្មដែលបានប្រព្រឹត្តនៅមន្ទីរសន្តិសុខចំនួន4គឺមន្ទីរសន្តិសុខស21ក្រាំងតាច័ន្ទអូកន្សែងនិងភ្នំក្រោលឧក្រិដ្ឋកម្មដែលបានប្រព្រឹត្តនៅការដ្ឋានចំនួន3គឺទំនប់1មករា ទំនប់ត្រពាំងថ្មនិងការដ្ឋានសាងសង់ប្រលានយន្តហោះកំពង់ឆ្នាំងឧក្រិដ្ឋកម្មដែលបានប្រព្រឹត្តនៅសហគមន៍ត្រាំកក់ការធ្វើទុកបុកម្នេញខាងព្រះពុទ្ធសាសនាការធ្វើទុកបុកម្នេញមន្ត្រីសាធារណរដ្ឋខ្មែរកម្រិតត្រឹមសហគមន៍ត្រាំកក់ការដ្ឋានទំនប់1មករាមន្ទីរសន្តិសុខស21និងមន្ទីរសន្តិសុខក្រាំងតាចាន់សវនកម្មលើសំណុំរឿង002វគ្គ2បានចាប់ផ្ដើមដោយសេចក្តីថ្លែងបើករបស់សហព្រះអាជ្ញាកាលពីថ្ងៃទី17ខែតុលាឆ្នាំ2014
អំពើឃោរឃៅមកលើប្រជាជនកម្ពុជាមិនចេះចាប់មិនចេះហើយនឹងបានមានទ្រង់ទ្រាយកាន់តែធំទៅមិនធ្លាប់មានពីមុនដែលបានបណ្ដាលឲ្យទឹកដីកម្ពុជាពោពេញទៅដោយរដូវសាកសពនិងការបាត់បង់ជីវិតបាត់បង់បងប្អូនសាច់ញាតិនេះគឺជាគេដំណើរដ៏សាហាវពិតដែលបានសល់ទុកឲ្យមេដឹកនាំបកកុម្មុយនីសកម្ពុជាដែលកំពុងអង្គុយនៅចំពោះមុខយើងទាំងអស់គ្នានៅថ្ងៃនេះដូច្នេះយើងសម្រាប់អ្នករាល់គ្នាដែលបានសួរថាតើហេតុអ្វីបានជាពួកយើងត្រូវការសាវនាការមួយទៀតនៅពេលដែលជនជាប់ចោតដែលមានវ័យចាស់ជរាបានទទួលការផ្ដន្ទាទោសអស់មួយជីវិតទៅហើយនោះចម្លើយគឺសាមញ្ញពួកយើងធ្វើនេះដោយសារប្រជាជនកម្ពុជារាប់លាននាក់ដែលបានស្លាប់ដោយសាររបបមួយនេះក្នុងកំឡុងពេល3ឆ្នាំ8ខែនិង20ថ្ងៃក្នុងរបបកម្ពុជាប្រជាធិបតេយ្យមានតែពួកជ្រាំមានតែសក្តីវិនាសនិងទុកព្រួយមានតែការឈឺចាប់និងសក្តីស្លាប់
ខ្ញុំបានទទួលស្គាល់ថាមានជនរួមជាតិជាច្រើនមានការឈឺចាប់នៅក្នុងរបបកម្ពុជាប្រជាធិបតេយ្យដែលបង្កឡើងដោយពួកបំផ្លាញស៊ីរួមទីក្នុងខ្ញុំសោកស្ដាយចំពោះទុក្ខលំបាកនោះហើយខ្ញុំសូមទទួលខុសត្រូវនៃសិលធម៌ចំពោះអំពើនេះដោយសារខ្ញុំជាមេដឹកនាំជាន់ខ្ពស់ម្នាក់នៃបកកុម្មុយនីសកម្ពុជា
នួនជាបានជម្រាបទៅចៅក្រមថាគាត់បានបង្គាប់ឲ្យមេធាវីរបស់គាត់ធ្វើពហិការមិនចូលរួមជំនុំជម្រះក្តីរហូតដល់ពេលវេលាសំណើប្តឹងដិតចិត្តរបស់គាត់ទៅលើចៅក្រមសាលាដំបូងពាក់ព័ន្ធទៅនឹងកំហុសឆ្គងមួយចំនួនត្រូវបានសម្រេចជាមុនសិននៅពេលក្រោយមកក្រុមចៅក្រមពិសេសមួយត្រូវបានបង្កើតឡើងនិងបានច្រានចោលសំណើប្តឹងដិតចិត្តរបស់នួនជាហើយមេធាវីការពារក្តីរបស់គាត់ក៏បានចូលរួមនៅក្នុងការកាត់ក្តីវិញធ្វើរៀងមុខចោតតែនៅចំពោះមុខអង្គជំរះនេះជនជាប់ចោតទី2គឺខៀវសំផនបានជម្រាបអង្គជំនុំជម្រះសាលាដំបូងថាគាត់បានបង្គាប់ឲ្យមេធាវីរបស់គាត់ចង់អារម្មណ៍តែទៅលើបណ្ដឹងសារទុកជាមុនសិនមុននឹងគាត់និងមេធាវីរបស់គាត់ចូលរួមនៅក្នុងការជំនុំជម្រះក្តីនៃសំណុំរឿង002វគ្គ2
កាត់ក្តីសំណុំរឿង002លើ01អស់លោកបានកាត់ទុកខ្ញុំដោយផ្អែកលើទម្រង់ផតានិងការស្មាននានាដែលខ្ញុំជំទាស់ហើយដោយប្រើមធ្យោបាយដែលខ្ញុំយល់ឃើញថាជាការរំលោភលើសិទ្ធិរបស់ខ្ញុំដែលខ្ញុំត្រូវបានទទួលការកាត់ក្តីដោយយុត្តិធម៌ហេតុនេះហើយបានជាខ្ញុំបានជម្រាបមេធាវីខ្ញុំឲ្យប្រឹងឧស្សរដែលនៅក្នុងតុលាការនេះគេហៅថាបណ្ដឹងសារទុកសេចក្តីសំអាងហេតុនិងសេចក្តីសន្និដ្ឋានរបស់អស់លោកនៅក្នុងការកាត់ក្តីនេះបង្ហាញច្បាស់ជាមុនស្រេចទៅហើយអស់លោកនឹងសម្រេចយ៉ាងណានៅក្នុងការកាត់ក្តីសំណុំរឿង002លើ02ខាងមុខនេះគ្មានអ្វីគួរឲ្យខ្ញុំស្រពេចស្រពិលទេបើអស់លោកនៅតែប្រើរបៀបគិតគូរដែលខ្ញុំជំទាស់ទៅចំពោះមុខតុលាការកំពូលតាក់ទងនឹងការចោទប្រកាន់ថាខ្ញុំបានចូលរួមប្រព្រឹត្តសហអក្រិតកម្មរួមខ្ញុំដឹងជាមុន ស្រេចទៅហើយថាអស់លោកប្រកាសជានឹងផ្ដល់ទីទូខ្ញុំទៀតក្នុងការកាត់ក្តីដែលអស់លោកកំពុងតែបើកនៅថ្ងៃនេះ
នៅអំឡុងពេលនៃសវនាការអង្គជំនុំជម្រះសាលាដំបងបានស្ដាប់ការបង្ហាញផុសតាងលើប្រធានបទស្ដីពីសហគមន៍ត្រាំកក់រួមទាំងមន្ទីរសន្តិសុខក្រាំងតាច័ន្ទនិងការប្រព្រឹត្តលើពុទ្ធសាសនិកការដ្ឋានទំនប់1មករាការដ្ឋានសាងសង់ប្រលានយន្តហោះកំពង់ឆ្នាំងការដ្ឋានទំនប់ត្រពាំងថ្មការប្រព្រឹត្តទៅលើជនជាតិចាមនិងជនជាតិវៀតណាមមន្ទីរសន្តិសុខអូកន្សែងមន្ទីរសន្តិសុខភ្នំក្រោលនិងមន្ទីរសន្តិសុខស21និងការបោះសម្អាតផ្ទៃក្នុងការចេញបទបញ្ជាអំពីការរៀបអាពាហ៍ពិពាហ៍លក្ខណៈនៃចំនួនប្រដាប់អាវុធនិងជាចុងក្រោយអំពីទូនាទីរបស់ជនជាប់ចោទនៅថ្ងៃទី11ខែមករាឆ្នាំ2017អង្គជំនុំជម្រះសាលាដំបងបានបិទបញ្ចប់សវនាការលើកផុសតាងនៅក្នុងសំណុំរឿង002វគ្គ2ពាក់ព័ន្ធទៅនឹងបទចោទប្រកាន់ស្ដីអំពីឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិអំពើប្រល័យពូជសាសន៍និងការបំពានបំពានយ៉ាងធ្ងន់ធ្ងរលើអនុសញ្ញាទីក្រុងហ្សឺណែវប្រឆាំងទៅនឹងជនជាប់ចោទនួនជានិងខៀវសំផន
ប្រជាជនកម្ពុជាទូទាំងរបប
អង្គជំនុំជម្រះសាលាដំបងបានបើកសវនាការធ្វើសេចក្តីសន្និដ្ឋានផ្ទាល់មាត់បិទបញ្ចប់កិច្ចពិភាក្សាដេញដោលនៅខែមិថុនាឆ្នាំ2017
រដ្ឋវិញ្ញាម្នាក់បានផ្ដល់សេចក្តីកម្មអំពីជាសនកម្មដែល
សូមជម្រាបថាអង្គជំនុំជម្រះបានធ្វើសវនាការរយៈពេល274ថ្ងៃនៅក្នុងសំណុំរឿង002វគ្គ2និងបានស្ដាប់សេចក្តីកម្មសាក្សីចំនួន114នាក់ដើមបណ្ដឹងរដ្ឋប្រវេណីចំនួន63នាក់និងអ្នកជំនាញចំនួន8នាក់លើសពីនេះទៀតអង្គជំនុំជម្រះបានផ្ដល់ឱកាសឲ្យភាគីបង្ហាញផុសតាងជាឯកសារសំខាន់ៗពាក់ព័ន្ធទៅនឹងប្រធានបទសវនាការនីមួយៗនិងបានស្ដាប់ការបញ្ជាក់បន្ថែមរបស់សហមេធាវីនាំមុខតំណាងដើមបណ្ដឹងរដ្ឋប្រវេណីស្ដីពីការទាមទារសំណងនៅក្នុងអំឡុងពេលសវនាការនៅក្នុងសំណុំរឿង002វគ្គ2នេះមានសាធារណជនសរុបចំនួន776,604នាក់បានចូលរួមស្ដាប់ដោយផ្ទាល់នៅក្នុងសារសវនាការរបស់អង្គជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាអង្គជំនុំជម្រះសាលាដំបងនៃអង្គជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាបានប្រកាសសេចក្តីសម្អាងហេតុនិងផ្នែកនៃសេចក្តីសម្រេចនៃសាលក្រមនៅក្នុងសំណុំរឿង002/02ពាក់ព័ន្ធទៅនឹងជនជាប់ចោទនួនជានិងខៀវសំផនកាលពីថ្ងៃទី16ខែវិច្ឆិកាឆ្នាំ2018នៅក្នុងសារសវនាការធំនៃអវតក
អង្គជំរះសាលាដំបងរកឃើញថាជនជាប់ចោទនួនជាមានបរិបទដែលបានប្រព្រឹត្តនៅលើទឹកដីនៃប្រទេសកម្ពុជាចន្លោះថ្ងៃទី17ខែមេសាឆ្នាំ1975ដល់ថ្ងៃទី6ខែមករាឆ្នាំ1979ដោយបានរៀបរាប់ដោយសង្ខេបខាងលើនេះនិងដោយលម្អិតនៅក្នុងសារក្រមជាលិលាអក្សរតាមរយៈអំពើសកម្មនិងអកម្មចំពោះអកតកម្មទាំងឡាយដូចខាងក្រោមអកតកម្មប្រឆាំងនឹងមនុស្សជាតិតាមរយៈការធ្វើនុភាពការសម្លាប់រង្គាលការនិរទេសការធ្វើឲ្យទៅជាសតកការដាក់ក្នុងមន្ទីរឃុំឃាំងការធ្វើទុកបុកម្នេញដោយមូលហេតុនយោបាយការធ្វើទុកបុកម្នេញដោយមូលហេតុសាសនានិងការធ្វើទុកបុកម្នេញដោយមូលហេតុសាសន៍និងអំពើអនុប្រព័ន្ធផ្សេងៗទៀតក្រុមទម្រង់ជាការប៉ះពាល់ដល់សេចក្តីថ្លៃថ្នូររបស់មនុស្សអំពើអនុប្រព័ន្ធផ្សេងៗទៀតក្រុមទម្រង់ជាការបាត់ខ្លួនដោយបង្ខំអំពើអនុប្រព័ន្ធផ្សេងៗទៀតក្រុមទម្រង់ជាការជំនះដោយបង្ខំនិងអំពើអនុប្រព័ន្ធផ្សេងៗទៀតក្រុមទម្រង់ជាការរៀបអាពាហ៍ពិពាហ៍ដោយបង្ខំនិងការរំលោភផ្លូវភេទនៅក្នុងបទបទនៃការរៀបអាពាហ៍ពិពាហ៍ដោយបង្ខំអនុលោមតាមបទបញ្ញត្តិនៃវិធានមាត្រា5មាត្រា29ថ្មីនិងមាត្រា39ថ្មីនៃច្បាប់នៃពីការបង្កើតអវតកការបំពេញយ៉ាងធ្ងន់ធ្ងរលើអនុសញ្ញាទីក្រុងហ្សឺណែវតាមរយៈការធ្វើមនុស្សភាពដោយចេតនាការធ្វើទរណកម្មការធ្វើបាបដោយអព្យាធម៌ការបង្កដោយចេតនាឲ្យមានរបួសធ្ងន់ឬឲ្យមានការឈឺចាប់ដល់រាងកាយឬសុខភាពការដកហូតដោយចេតនាពីជ្រើសិទ្ធិឬជនស៊ីវិលនៅសិទ្ធិទទួលបានការកាត់ទោសដោយយុត្តិធម៌និងទៀងទាត់និងការឃុំខ្លួនជនស៊ីវិលដែលខុសច្បាប់អនុលោមតាមមាត្រា6មាត្រា29ថ្មីនិងមាត្រា39ថ្មីនៃច្បាប់ស្តីពីការបង្កើតអវតកឧក្រិដ្ឋកម្មបល័យពិសាសតាមរយៈការធ្វើមនុស្សឃាតលើសមាជិកនៃក្រុមជនជាតិវៀតណាមនិងជនជាតិចាមអង្គជំរះសាលាដំបងរកឃើញថា ជនជាប់ចោទគឺសម្ផនមានវិរុទ្ធដែលបានប្រព្រឹត្តនៅលើទឹកដីនៃប្រទេសកម្ពុជាដោយចន្លោះពីថ្ងៃ17ខែមេសាឆ្នាំ1975រហូតដល់ថ្ងៃទី6ខែមករាឆ្នាំ1979ដោយបានរៀបរាប់ដោយសង្ខេបខាងលើអង្គជំរះបានពិចារណាទៅលើភាពធ្ងន់ធ្ងរនៃអកតកម្មរួមទាំងទំហំនិងភាពសាហាវព្រៃផ្សៃក៏ដូចជាចំនួននិងភាពទន់ខ្សោយរបស់ជនរងគ្រោះដែលជនជាប់ចោទត្រូវបានរកឃើញមានប្រតិភិបរួមទាំងស្ថានទម្ងន់និងស្ថានបម្រើទោសនានាដែលពាក់ព័ន្ធអង្គជំរះសម្រាប់ផ្តន្ទាទោសជនជាប់ចោទនួនជាដាក់ពន្ធនាគារអស់មួយជីវិតដោយពិចារណាលើការផ្តន្ទាទោសដាក់ពន្ធនាគារអស់មួយជីវិតចំពោះគាត់នៅក្នុងសំណុំរឿង002/01អង្គជំរះសម្រាប់រួមបញ្ចូលគ្នានៅការផ្តន្ទាទោសទាំងពីរទៅជាការផ្តន្ទាទោសដាក់ពន្ធនាគារអស់មួយជីវិតតែមួយអង្គជំរះសម្រាប់ផ្តន្ទាទោសជនជាប់ចោទគឺសម្ផនដាក់ពន្ធនាគារអស់មួយជីវិតដោយពិចារណាទៅលើការផ្តន្ទាទោសដាក់ពន្ធនាគារអស់មួយជីវិតចំពោះគាត់នៅក្នុងសំណុំរឿង002/01អង្គជំរះសម្រាប់រួមបញ្ចូលគ្នានៅការផ្តន្ទាទោសទាំងពីរទៅជាការផ្តន្ទាទោសដាក់ពន្ធនាគារអស់មួយជីវិតតែមួយ
សាធារណជនប្រមាណជាជាង700នាក់រួមមានតំណាងរាជរដ្ឋាភិបាលកម្ពុជាតំណាងអង្គការសហប្រជាជាតិនិងមន្ត្រីអង្គទូតអង្គការសង្គមស៊ីវិលនានារួមនឹងសាធារណជននិងអ្នកសារព័ត៌មានជាតិនិងអន្តរជាតិបានចូលរួមស្ដាប់ការប្រកាសសារក្រមជាប្រវត្តិសាស្ត្រនេះយើងខ្ញុំសូមរំលឹកសាធារណជនថានៅក្នុងដំណាក់កាលនេះបទចោទប្រឆាំងទៅនឹងនួនជានិងឃ្យូសំផននៅក្នុងសំណុំរឿង002/2គ្រាន់តែជាការចោទប្រកាន់តែប៉ុណ្ណោះមិនទាន់មានការសម្រេចជាស្ថាពរនៅឡើយទេថាតើជនជាប់ចោទទាំងពីរមានទោសឬក៏គ្មានទោសជនជាប់ចោទទាំងពីរត្រូវបានសន្មត់ទុកជាមុនថាគ្មានទោសដរាបណាសាលដីកាស្ថាពរមិនទាន់ចូលជាធរមាននៅឡើយអង្គជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាដែលគេស្គាល់ថាសាលាដីខ្មែរក្រហមត្រូវបានបង្កើតឡើងដើម្បីឆ្លើយតបទៅនឹងឧក្រិដ្ឋកម្មដែលបានប្រព្រឹត្តនៅចន្លោះថ្ងៃទី17ខែមេសាឆ្នាំ1975រហូតដល់ថ្ងៃទី6ខែមករាឆ្នាំ1979ជារយៈពេលដែលប៉ុល ពតកាន់កាប់អំណាចប្រជាជនយ៉ាងហោចណាស់1,700,000 នាក់ត្រូវបានជឿជាក់ថាត្រូវបានស្លាប់ដោយសារការធ្វើការងារហួសកម្លាំងការបង្អត់អាហារការធ្វើទារុណកម្មសម្លាប់និងលក្ខខណ្ឌរស់នៅដ៏អមនុស្សធម៌ដទៃទៀតសំណុំរឿង002/2គឺជាការជំនុំជម្រះដីទី2ប្រឆាំងទៅនឹងអតីតប្រមុខរដ្ឋខៀវសំផននិងអតីតអនុលេខាបកកុម្មុយនីសកម្ពុជាលោកនួនជាជនជាប់ចោទទាំងពីរត្រូវបានបញ្ជូនទៅជំនុំជម្រះដីកាលពីខែកញ្ញាឆ្នាំ2010ដោយសារទំហំនិងភាពស្មុគស្មាញនៃបទចោទនាពេលរស់រានមានជីវិតរបស់ជនជាប់ចោទឬក្នុងពេលដែលជនជាប់ចោទនៅអាចជំនុំជម្រះដីបានដែលការបញ្ជូនរឿងទៅជំនុំជម្រះត្រូវបានបែងចែកជាការជំនុំជម្រះដីចំនួន2ដែលហៅថាសំណុំរឿង002/1និងសំណុំរឿង002/2ការជំនុំជម្រះក្តីដំណាក់កាលទី1ផ្ដោតសំខាន់ទៅលើបទចោទឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិដែលតាក់ទងទៅនឹងការជំនះដោយបង្ខំពីទីក្រុងភ្នំពេញកាលពីខែមេសាឆ្នាំ1975និងក្រោយមកគឺមានការជំនះពីតំបន់ដទៃទៀតក៏មានបទចោទតាក់ទងទៅនឹងការសម្លាប់អតីតទាហានសាធារណរដ្ឋខ្មែរនៅទួលពលជ្រៃនៅក្នុងស្រុកកណ្ដៀងខេត្តពោធិ៍សាត់អង្គជំនុំជម្រះសាលាដំបងនៃអង្គជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាហៅកាត់ថាអវតកបានរកឃើញនួនជានិងឃ្យូសំផនមានពិរុទ្ធពីបទឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិនិងបានសម្រេចផ្តន្ទាទោសពួកគាត់ដាក់ពន្ធនាគារអស់មួយជីវិតកាលពីថ្ងៃទី7ខែសីហាឆ្នាំ2014
រួមទាំងការធ្វើមុខភាព ការ
ត្រូវបានបង្ខំឲ្យនៅក្នុងស្ថានភាព
សហព្រះរាជអាជ្ញាជនជាប់ចោទទាំងពីរបានប្តឹងសារទុកទៅកាន់អង្គជំនុំជម្រះតុលាការកំពូលហើយតុលាការកំពូលបានធ្វើសវនាការរួចហើយតាក់ទងទៅនឹងបណ្ដឹងសារទុកនៅក្នុងសំណុំរឿង 002/01 ព្រមទាំងបានស្ដាប់សក្ខីកម្មរបស់សាក្សី3រូបកាលពីថ្ងៃទី2 ទី3 និងទី 6 ខែកក្កដាឆ្នាំ 2015 នៅថ្ងៃទី 16, 17, 18 ខែកក្កដាឆ្នាំ 2016 អង្គជំនុំជម្រះតុលាការកំពូលបានធ្វើសវនាការស្ដាប់សារណាផ្ទាល់មាត់លើបញ្ហានានាដែលបានលើកឡើងនៅក្នុងបណ្ដឹងសារទុកនៅក្នុងសំណុំរឿង 02 វគ្គ 01 នៅថ្ងៃទី 23 ខែវិច្ឆិកាឆ្នាំ 2016 អង្គជំនុំជម្រះតុលាការកំពូលនៃអង្គជំនុំជម្រះរាជសម្បត្តិក្នុងតុលាការកម្ពុជាបានប្រកាសសាលដីការបស់ខ្លួនលើបណ្ដឹងសារទុកប្រឆាំងនឹងសាលក្រមនៅក្នុងសំណុំរឿង 002 វគ្គ 1 ដោយបានតម្កល់សាលក្រមរបស់អង្គជំនុំជម្រះសាលាដំបងផ្ដន្ទាទោសនួនជានិងខៀវសំផនដាក់ពន្ធនាគារអស់មួយជីវិត សំណុំរឿង 002 វគ្គ 2 ដែលជាសំណុំរឿងបន្តពីសំណុំរឿង 002 វគ្គ 1 មានបទចោទជារួមគឺឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិនិងការរំលោភបំពានយ៉ាងធ្ងន់ធ្ងរទៅលើអនុសញ្ញាទីក្រុងហ្សឺណែវឆ្នាំ 1949 ព្រមទាំងឧក្រិដ្ឋកម្មប្រល័យពូជសាសន៍ អង្គជំនុំជម្រះសាលាដំបងបានសម្រេចថាទីតាំងឧក្រិដ្ឋកម្មនិងបទចោទសំខាន់ៗដទៃទៀតខាងក្រោមនេះគឺជាមូលដ្ឋាននៃការជំនុំជម្រះក្តីសំណុំរឿង 002 វគ្គ 2 អំពើប្រល័យពូជសាសន៍ទៅលើជនជាតិចាមនិងជនជាតិវៀតណាមការរៀបការដោយបង្ខំនិងការរំលោភសេពសន្តិវៈនៅទូទាំងប្រទេសការបោសសម្អាតផ្ទៃក្នុងឧក្រិដ្ឋកម្មដែលបានប្រព្រឹត្តនៅមន្ទីរសន្តិសុខចំនួន 4 គឺមន្ទីរសន្តិសុខស21 ក្រាំងតាច័ន្ទ អូកន្សែងនិងភ្នំក្រោនឧក្រិដ្ឋកម្មដែលបានប្រព្រឹត្តនៅការដ្ឋានចំនួន 3 គឺទំនប់1មករាទំនប់ត្រពាំងថ្មនិងការដ្ឋានសាងសង់ប្រលានយន្តហោះកំពង់ឆ្នាំងឧក្រិដ្ឋកម្មដែលបានប្រព្រឹត្តនៅសហករណ៍ត្រាំកក់ការធ្វើទុកបុកម្នេញខាងព្រះពុទ្ធសាសនាការធ្វើទុកបុកម្នេញមន្ត្រីសាធារណរដ្ឋខ្មែរកម្រិតត្រឹមសហករណ៍ត្រាំកក់ការដ្ឋានទំនប់1មករាមន្ទីរសន្តិសុខស21និងមន្ទីរសន្តិសុខក្រាំងតាច័ន្ទសវនកម្មលើសំណុំរឿង 002 វគ្គ 2 បានចាប់ផ្ដើមដោយសេចក្តីថ្លែងបើករបស់សហព្រះអាជ្ញាកាលពីថ្ងៃទី 17 ខែតុលាឆ្នាំ 2014
អំពើឃោរឃៅមកលើប្រជាជនកម្ពុជាមិនចេះចាប់មិនចេះហើយនឹងបានមានទ្រង់ទ្រាយកាន់តែធំទៅមិនធ្លាប់មានពីមុនដែលបានបណ្ដាលឲ្យទឹកដីកម្ពុជាពោពេញទៅដោយរដូវសាក់សពនិងការបាត់បង់ជីវិតបាត់បង់បងប្អូនសាច់ញាតិនេះគឺជាគេដំណើរដ៏សាហាវពិតដែលបានសល់ទុកដោយមេដឹកនាំបកកុម្មុយនីសកម្ពុជាដែលកំពុងអង្គុយនៅចំពោះមុខយើងទាំងអស់គ្នានៅថ្ងៃនេះដូច្នេះយើងសម្រាប់អ្នករាល់គ្នាដែលបានសួរថាតើហេតុអ្វីបានជាពួកយើងត្រូវការសវនាការមួយទៀតនៅពេលដែលជនជាប់ចោទដែលមានវ័យចាស់ជរាបានទទួលការផ្ដន្ទាទោសអស់មួយជីវិតទៅហើយនោះចម្លើយគឺសាមញ្ញពួកយើងធ្វើនេះដោយសារប្រជាជនកម្ពុជារាប់លាននាក់ដែលបានស្លាប់ដោយសាររបបមួយនេះក្នុងកំឡុងពេល3ឆ្នាំ8ខែនិង20ថ្ងៃក្នុងរបបកម្ពុជាប្រជាធិបតេយ្យមានតែពួកជ្រាំមានតែសក្តិវិនាសនិងទុកព្រួយមានតែការឈឺចាប់និងសក្តិស្លាប់
ខ្ញុំបានទទួលស្គាល់ថាមានជនរួមជាតិជាច្រើនមានការឈឺចាប់នៅក្នុងរបបកម្ពុជាប្រជាធិបតេយ្យដែលបង្កឡើងដោយពួកបំផ្លាញស៊ីរួមទីក្នុងខ្ញុំសោកស្ដាយចំពោះទុក្ខលំបាកនោះហើយខ្ញុំសូមទទួលខុសត្រូវនៃសិលធម៌ចំពោះអំពើនេះដោយសារខ្ញុំជាមេដឹកនាំជនគម្នាក់នៃបកកុម្មុយនីសកម្ពុជា
នួនជាបានជម្រាបទៅចៅក្រមថាគាត់បានបង្គាប់ឲ្យមេធាវីរបស់គាត់ធ្វើពហិការមិនចូលរួមជំនុំជម្រះក្តីរហូតដល់ពេលវេលាសំណើប្តឹងដិតចិត្តរបស់គាត់ទៅលើចៅក្រមសាលាដំបងពាក់ព័ន្ធទៅនឹងកំហុសឆ្គងមួយចំនួនត្រូវបានសម្រេចជាមុនសិននៅពេលក្រោយមកក្រុមចៅក្រមពិសេសមួយត្រូវបានបង្កើតឡើងនិងបានច្រានចោលសំណើប្តឹងដិតចិត្តរបស់នួនជាហើយមេធាវីការពារក្តីរបស់គាត់ក៏បានចូលរួមនៅក្នុងការកាត់ក្តីវិញគឺរៀងវងចោតតែនៅចំពោះមុខអង្គជំរះនេះជនជាប់ចោតទី2គឺខៀវសំផនបានជម្រាបអង្គជំនុំជម្រះសាលាដំបងថាគាត់បានបង្គាប់ឲ្យមេធាវីរបស់គាត់ចង់អារម្មណ៍តែទៅលើបណ្ដឹងសារទុកជាមុនសិន មុននឹងគាត់និងមេធាវីរបស់គាត់ចូលរួមនៅក្នុងការជំនុំជម្រះក្តីនៃសំណុំរឿង002 វគ្គ 2
អាការក្តីសំណុំរឿង002 លើ 01 អស់លោកបានកាត់ទុកខ្ញុំដោយផ្អែកលើទម្រង់ផុសតាងនិងការស្មាននានាដែលខ្ញុំជំទាស់ហើយដោយប្រើមធ្យោបាយដែលខ្ញុំយល់ឃើញថាជាការរំលោភលើសិទ្ធិរបស់ខ្ញុំដែលខ្ញុំត្រូវបានទទួលការកាត់ក្តីដោយយុត្តិធម៌ហេតុនេះហើយបានជាខ្ញុំបានជម្រាបមេធាវីខ្ញុំឲ្យប្រឹងឧទ្ធរណ៍ដែលនៅក្នុងតុលាការនេះគេហៅថាបណ្ដឹងសារទុកសេចក្តីសំអាងហេតុនិងសេចក្តីសន្និដ្ឋានរបស់អស់លោកនៅក្នុងការកាត់ក្តីនេះបង្ហាញច្បាស់ជាមុនស្រេចទៅហើយអស់លោកនឹងសម្រេចយ៉ាងណានៅក្នុងការកាត់ក្តីសំណុំរឿង002 លើ 02 ខាងមុខនេះគ្មានអ្វីគួរឲ្យខ្ញុំស្រពេចស្រពិលទេបើអស់លោកនៅតែប្រើរបៀបគិតគូរដែលខ្ញុំជំទាស់នៅចំពោះមុខតុលាការកំពូលតាក់ទងនឹងការចោទប្រកាន់ថាខ្ញុំបានចូលរួមប្រព្រឹត្តសហអក្រិតកម្មរួមខ្ញុំដឹងជាមុនស្រេចទៅហើយថាអស់លោកប្រកាសជានឹងផ្ដន្ទាទោសខ្ញុំទៀតក្នុងការកាត់ក្តីដែលអស់លោកកំពុងតែបើកនៅថ្ងៃនេះ
នៅអំឡុងពេលនៃសវនាការអង្គជំនុំជម្រះសាលាដំបងបានស្ដាប់ការបង្ហាញផុសតាងលើប្រធានបទស្ដីពីសហគមន៍ត្រាំកក់រួមទាំងមន្ទីរសន្តិសុខត្រាំកញ្ចាំនិងការប្រព្រឹត្តលើពុទ្ធសាសនិកការដ្ឋានទំនប់1មករាការដ្ឋានសាងសង់ប្រលានយន្តហោះកំពង់ឆ្នាំងការដ្ឋានទំនប់ត្រពាំងថ្មការប្រព្រឹត្តទៅលើជនជាតិចាមនិងជនជាតិវៀតណាមមន្ទីរសន្តិសុខអូកន្សែងមន្ទីរសន្តិសុខភ្នំក្រោលនិងមន្ទីរសន្តិសុខស21និងការបោះសម្អាតផ្ទៃក្នុងការចេញបទបញ្ជាអំពីការរៀបអាពាហ៍ពិពាហ៍លក្ខណៈនៃចំនួនប្រដាប់អាវុធនិងជាចុងក្រោយអំពីទូនាទីរបស់ជនជាប់ចោទនៅថ្ងៃទី11ខែមករាឆ្នាំ2017អង្គជំនុំជម្រះសាលាដំបងបានបិទបញ្ចប់សវនាការលើកផុសតាងនៅក្នុងសំណុំរឿង002 វគ្គ 2 ពាក់ព័ន្ធទៅនឹងបទចោទប្រកាន់ស្ដីអំពីឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិអំពើប្រល័យពូជសាសន៍និងការបំពានបំពានយ៉ាងធ្ងន់ធ្ងរលើអនុសញ្ញាទីក្រុងហ្សឺណែវប្រឆាំងទៅនឹងជនជាប់ចោទនួនជានិងខៀវសំផន
ប្រជាជនកម្ពុជាទូទាំងរបប
អង្គជំនុំជម្រះសាលាដំបងបានបើកសវនាការធ្វើសេចក្តីសន្និដ្ឋានផ្ទាល់មាត់បិទបញ្ចប់កិច្ចពិភាក្សាដេញដោលនៅខែមិថុនាឆ្នាំ2017
រដ្ឋវិញ្ញាម្នាក់បានផ្ដល់សេចក្តីកម្មអំពីជាសនកម្មដោយ
សូមជម្រាបថាអង្គជំនុំជម្រះបានធ្វើសវនាការរយៈពេល274ថ្ងៃនៅក្នុងសំណុំរឿង002 វគ្គ 2និងបានស្ដាប់សេចក្តីកម្មសាក្សីចំនួន114នាក់ដើមបណ្ដឹងរដ្ឋប្រវេណីចំនួន63នាក់និងអ្នកជំនាញចំនួន8នាក់លើសពីនេះទៀតអង្គជំនុំជម្រះបានផ្ដល់ឱកាសឲ្យភាគីបង្ហាញផុសតាងជាឯកសារសំខាន់ពាក់ព័ន្ធទៅនឹងប្រធានបទសវនាការនីមួយៗនិងបានស្ដាប់ការបញ្ជាក់បន្ថែមរបស់សហមេធាវីនាំមុខតំណាងតាមបណ្ដឹងរដ្ឋប្រវេណីស្ដីពីការទាមទារសំណងនៅក្នុងអំឡុងពេលសវនាការនៅក្នុងសំណុំរឿង002 វគ្គ 2 នេះមានសាធារណជនសរុបចំនួន 776,604 នាក់បានចូលរួមស្ដាប់ដោយផ្ទាល់នៅក្នុងសារសវនាការរបស់អង្គជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាអង្គជំនុំជម្រះសាលាដំបងនៃអង្គជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាបានប្រកាសសេចក្តីសម្អាងហេតុនិងផ្នែកនៃសេចក្តីសម្រេចនៃសាលក្រមនៅក្នុងសំណុំរឿង002/02 ពាក់ព័ន្ធទៅនឹងជនជាប់ចោទនួនជានិងខៀវសំផនកាលពីថ្ងៃទី16ខែវិច្ឆិកាឆ្នាំ2018នៅក្នុងសារសវនាការធំនៃអវតក
អង្គជំរះសាលាដំបងរកឃើញថាជនជាប់ចោទនួនជាមានបរិបទដែលបានប្រព្រឹត្តនៅលើទឹកដីនៃប្រទេសកម្ពុជាចន្លោះថ្ងៃទី17ខែមេសាឆ្នាំ1975 ហូតដល់ថ្ងៃទី6ខែមករាឆ្នាំ1979ដោយបានរៀបរាប់ដោយសង្ខេបខាងលើនេះនិងដោយលម្អិតនៅក្នុងសារក្រមជាលិលាអក្សរតាមរយៈអំពើសកម្មនិងអកម្មចំពោះអកតកម្មទាំងឡាយដូចខាងក្រោមអកតកម្មប្រឆាំងនឹងមនុស្សជាតិតាមរយៈការធ្វើនុភាពការសម្លាប់រង្គាលការនិរទេសការធ្វើឲ្យទៅជាសតកការដាក់ក្នុងមន្ទីរឃុំឃាំងការធ្វើទុកបុកម្នេញដោយមូលហេតុនយោបាយការធ្វើទុកបុកម្នេញដោយមូលហេតុសាសនានិងការធ្វើទុកបុកម្នេញដោយមូលហេតុភូមិសាស្ត្រនិងអំពើអនុប្រព័ន្ធផ្សេងៗទៀតក្រុមទម្រង់ជាការប៉ះពាល់ដល់សេចក្តីថ្លៃថ្នូររបស់មនុស្សអំពើអនុប្រព័ន្ធផ្សេងៗទៀតក្រុមទម្រង់ជាការបាត់ខ្លួនដោយបង្ខំអំពើអនុប្រព័ន្ធផ្សេងៗទៀតក្រុមទម្រង់ជាការជំនះដោយបង្ខំនិងអំពើអនុប្រព័ន្ធផ្សេងៗទៀតក្រុមទម្រង់ជាការរៀបអាពាហ៍ពិពាហ៍ដោយបង្ខំនិងការរំលោភផ្លូវភេទនៅក្នុងបទបទនៃការរៀបអាពាហ៍ពិពាហ៍ដោយបង្ខំអនុលោមតាមបទបញ្ញត្តិនៃវិធានមាត្រា5មាត្រា29ថ្មីនិងមាត្រា39ថ្មីនៃច្បាប់នៃពីការបង្កើតអវតកការបំពេញបំពេញយ៉ាងធ្ងន់ធ្ងរលើអនុសញ្ញាទីក្រុងហ្សឺណែវតាមរយៈការធ្វើមនុស្សភាពដោយចេតនាការធ្វើទរណកម្មការធ្វើបាបដោយអវិធម៌ការបង្កដោយចេតនាឲ្យមានរបួសធ្ងន់ឬឲ្យមានការឈឺចាប់ដល់រាងកាយឬសុខភាពការដកហូតដោយចេតនាពីជ្រើយសិទ្ធិឬជនស៊ីវិលនៅសិទ្ធិទទួលបានការកាត់ទោសដោយយុត្តិធម៌និងទៀងទាត់និងការឃុំខ្លួនជនស៊ីវិលដែលខុសច្បាប់អនុលោមតាមមាត្រា6មាត្រា29ថ្មីនិងមាត្រា39ថ្មីនៃច្បាប់ស្តីពីការបង្កើតអវតកឧក្រិដ្ឋកម្មបល័យពិសាសតាមរយៈការធ្វើមនុស្សឃាតលើសមាជិកនៃក្រុមជនជាតិវៀតណាមនិងជនជាតិចាមអង្គជំនះសាលាដំបងរកឃើញថាជនជាប់ចោទគឺសំផនមានពិរុទ្ធដែលបានប្រព្រឹត្តនៅលើទឹកដីនៃប្រទេសកម្ពុជាដោយចន្លោះពីថ្ងៃ17ខែមេសាឆ្នាំ1975រហូតដល់ថ្ងៃទី6ខែមករាឆ្នាំ1979ដោយបានរៀបរាប់ដោយសង្ខេបខាងលើអង្គជំនះបានពិចារណាទៅលើភាពធ្ងន់ធ្ងរនៃអកតកម្មរួមទាំងទំហំនិងភាពសាហាវព្រៃផ្សៃក៏ដូចជាចំនួននិងភាពទន់ខ្សោយរបស់ជនរងគ្រោះដែលជនជាប់ចោទត្រូវបានរកឃើញមានប្រវត្តិភាពរួមទាំងស្ថានទម្ងន់និងស្ថានតម្រូវទោសនានាដែលពាក់ព័ន្ធអង្គជំរះសម្រាប់ផ្ដន្ទាទោសជនជាប់ចោទនួនជាដាក់ពន្ធនាគារអស់មួយជីវិតដោយពិចារណាលើការផ្ដន្ទាទោសដាក់ពន្ធនាគារអស់មួយជីវិតចំពោះគាត់នៅក្នុងសំណុំរឿង002/01អង្គជំរះសម្រាប់រួមបញ្ចូលគ្នានៅការផ្ដន្ទាទោសទាំងពីរទៅជាការផ្ដន្ទាទោសដាក់ពន្ធនាគារអស់មួយជីវិតតែមួយអង្គជំរះសម្រាប់ផ្ដន្ទាទោសជនជាប់ចោទគឺសំផនដាក់ពន្ធនាគារអស់មួយជីវិតដោយពិចារណាទៅលើការផ្ដន្ទាទោសដាក់ពន្ធនាគារអស់មួយជីវិតចំពោះគាត់នៅក្នុងសំណុំរឿង002/01អង្គជំរះសម្រាប់រួមបញ្ចូលគ្នានៅការផ្ដន្ទាទោសទាំងពីរទៅជាការផ្ដន្ទាទោសដាក់ពន្ធនាគារអស់មួយជីវិតតែមួយ
សាធារណជនប្រមាណជាជាង700នាក់រួមមានតំណាងរាជរដ្ឋាភិបាលកម្ពុជាតំណាងអង្គការសហប្រជាជាតិនិងមន្ត្រីអង្គទូតអង្គការសង្គមស៊ីវិលនានារួមនឹងសាធារណជននិងអ្នកសារព័ត៌មានជាតិនិងអន្តរជាតិបានចូលរួមស្ដាប់ការប្រកាសសារក្រមជាប្រវត្តិសាស្ត្រនេះយើងខ្ញុំសូមរំលឹកសាធារណជនថានៅក្នុងដំណាក់កាលនេះបទចោទប្រឆាំងទៅនឹងនួនជានិងឃ្យូសំផននៅក្នុងសំណុំរឿង002/2គ្រាន់តែជាការចោទប្រកាន់តែប៉ុណ្ណោះមិនទាន់មានការសម្រេចជាស្ថាពរនៅឡើយទេថាតើជនជាប់ចោទទាំងពីរមានទោសឬក៏គ្មានទោសជនជាប់ចោទទាំងពីរត្រូវបានសន្មតទុកជាមុនថាគ្មានទោសដរាបណាសាលដីកាស្ថាពរមិនទាន់ចូលជាធរមាននៅឡើយជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាដែលគេស្គាល់ថាសាលាដីខ្មែរក្រហមត្រូវបានបង្កើតឡើងដើម្បីឆ្លើយតបទៅនឹងឧក្រិដ្ឋកម្មដែលបានប្រព្រឹត្តនៅចន្លោះថ្ងៃទី17ខែមេសាឆ្នាំ1975រហូតដល់ថ្ងៃទី6ខែមករាឆ្នាំ1979 ជារយៈពេលដែលពលពតកាន់កាប់អំណាចប្រជាជនយ៉ាងហោចណាស់1,700,000 នាក់ត្រូវបានជឿជាក់ថាត្រូវបានស្លាប់ដោយសារការធ្វើការងារហួសកម្លាំងការបង្អត់អាហារការធ្វើទារុណកម្មសម្លាប់និងលក្ខខណ្ឌរស់នៅដ៏អមនុស្សធម៌ដទៃទៀតសំណុំរឿង002 វគ្គ 2 គឺជាការជំនុំជម្រះក្តីទី2ប្រឆាំងទៅនឹងអតីតប្រមុខរដ្ឋខៀវសំផននិងអតីតអនុលេខាបកកុម្មុយនីសកម្ពុជាលោកនួនជាជនជាប់ចោទទាំងពីរត្រូវបានបញ្ជូនទៅជំនុំជម្រះក្តីកាលពីខែកញ្ញាឆ្នាំ2010ដោយសារទំហំនិងភាពស្មុគស្មាញនៃបទចោទនាពេលរស់រានមានជីវិតរបស់ជនជាប់ចោទឬក្នុងពេលដែលជនជាប់ចោទនៅអាចជំនុំជម្រះក្តីបានដែលការបញ្ជូនរឿងទៅជំនុំជម្រះត្រូវបានបែងចែកជាការជំនុំជម្រះក្តីចំនួន2ដែលហៅថាសំណុំរឿង002 វគ្គទី1និងសំណុំរឿង002 វគ្គទី2ការជំនុំជម្រះក្តីដំណាក់កាលទី1ផ្ដោតសំខាន់ទៅលើបទចោទឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិដែលតាក់ទងទៅនឹងការជំនះដោយបង្ខំពីទីក្រុងភ្នំពេញកាលពីខែមេសាឆ្នាំ1975និងក្រោយមកគឺមានការជំនះពីតំបន់ដទៃទៀតក៏មានបទចោទតាក់ទងទៅនឹងការសម្លាប់អតីតទាហានសាធារណរដ្ឋខ្មែរនៅទួលពោធិ៍ជ្រៃនៅក្នុងស្រុកកណ្ដៀងខេត្តពោធិ៍សាត់អង្គជំនុំជម្រះសាលាដំបងនៃអង្គជំនុំជម្រះវិស្ម័យក្នុងតុលាការកម្ពុជាហៅកាត់ថាអវតកបានរកឃើញនួនជានិងខៀវសំផនមានពិរុទ្ធពីបទឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិនិងបានសម្រេចផ្តន្ទាទោសពួកគាត់ដាក់ពន្ធនាគារអស់មួយជីវិតកាលពីថ្ងៃទី7ខែសីហាឆ្នាំ2014
ទាំងការធ្វើមុខភាពការធ្វើទុកបុកម្នេញ
សហព្រះរាជអាជ្ញាជនជាប់ចោទទាំងពីរបានប្តឹងសារទុកទៅកាន់អង្គជំនុំជម្រះតុលាការកំពូលហើយតុលាការកំពូលបានធ្វើសវនាការរួចហើយតាក់ទងទៅនឹងបណ្ដឹងសារទុកនៅក្នុងសំណុំរឿង002/01ព្រមទាំងបានស្ដាប់សក្ខីកម្មរបស់សាក្សី3រូបកាលពីថ្ងៃទី2ទី3និងទី6ខែកក្កដាឆ្នាំ2015នៅថ្ងៃទី16 17 18ខែកក្កដាឆ្នាំ2016អង្គជំនុំជម្រះតុលាការកំពូលបានធ្វើសវនាការស្ដាប់សារណាផ្ទាល់មាត់លើបញ្ហានានាដែលបានលើកឡើងនៅក្នុងបណ្ដឹងសារទុកនៅក្នុងសំណុំរឿង02 វគ្គ 01នៅថ្ងៃទី23ខែវិច្ឆិកាឆ្នាំ2016អង្គជំនុំជម្រះតុលាការកំពូលនៃអង្គជំនុំជម្រះវិស្ម័យក្នុងតុលាការកម្ពុជាបានប្រកាសសាលដីការបស់ខ្លួនលើបណ្ដឹងសារទុកប្រឆាំងនឹងសាលក្រមនៅក្នុងសំណុំរឿង002 វគ្គ 1ដោយបានតម្កល់សាលក្រមរបស់អង្គជំនុំជម្រះសាលាដំបងផ្តន្ទាទោសនួនជានិងខៀវសំផនដាក់ពន្ធនាគារអស់មួយជីវិតសំណុំរឿង002 វគ្គ 2ដែលជាសំណុំរឿងបន្តពីសំណុំរឿង002 វគ្គ 1មានបទចោទជារួមគឺឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិនិងការរំលោភបំពានយ៉ាងធ្ងន់ធ្ងរទៅលើអនុសញ្ញាទីក្រុងហ្សឺណែវឆ្នាំ1949ព្រមទាំងឧក្រិដ្ឋកម្មប្រល័យពូជសាសន៍អង្គជំនុំជម្រះសាលាដំបងបានសម្រេចថាទីតាំងឧក្រិដ្ឋកម្មនិងបទចោទសំខាន់ដទៃទៀតខាងក្រោមនេះគឺជាមូលដ្ឋាននៃការជំនុំជម្រះក្តីសំណុំរឿង002 វគ្គ 2អំពើប្រល័យពូជសាសន៍ទៅលើជនជាតិចាមនិងជនជាតិវៀតណាមការរៀបការដោយបង្ខំនិងការរំលោភសេពសន្តិវៈនៅទូទាំងប្រទេសការបោះសម្អាតផ្ទៃក្នុងឧក្រិដ្ឋកម្មដែលបានប្រព្រឹត្តនៅមន្ទីរសន្តិសុខចំនួន4គឺមន្ទីរសន្តិសុខស21ក្រាំងតាច័ន្ទអូកន្សែងនិងភ្នំក្រោមឧក្រិដ្ឋកម្មដែលបានប្រព្រឹត្តនៅការដ្ឋានចំនួន3គឺទំនប់1មករាទំនប់ត្រពាំងថ្មនិងការដ្ឋានសាងសង់ប្រលានយន្តហោះកំពង់ឆ្នាំងឧក្រិដ្ឋកម្មដែលបានប្រព្រឹត្តនៅសហគមន៍ត្រាំកក់ការធ្វើទុកបុកម្នេញខាងព្រះពុទ្ធសាសនាការធ្វើទុកបុកម្នេញមន្ត្រីសាធារណរដ្ឋខ្មែរកម្រិតត្រឹមសហគមន៍ត្រាំកក់ការដ្ឋានទំនប់1មករាមន្ទីរសន្តិសុខស21និងមន្ទីរសន្តិសុខក្រាំងតាច័ន្ទសវនកម្មលើសំណុំរឿង002 វគ្គ 2បានចាប់ផ្ដើមដោយសេចក្តីថ្លែងបើករបស់សហព្រះអាជ្ញាកាលពីថ្ងៃទី17ខែតុលាឆ្នាំ2014
អំពើឃោរឃៅមកលើប្រជាជនកម្ពុជាមិនចេះចាប់មិនចេះហើយនឹងបានមានទ្រង់ទ្រាយកាន់តែធំទៅមិនធ្លាប់មានពីមុនដែលបានបណ្ដាលឲ្យទឹកដីកម្ពុជាពោពេញទៅដោយរដូវសាកសពនិងការបាត់បង់ជីវិតបាត់បង់បងប្អូនសាច់ញាតិនេះគឺជាគេដំណើរដល់សហពិតដែលបានសល់ទុកដោយមេដឹកនាំបកកុម្មុយនីសកម្ពុជាដែលកំពុងអង្គុយនៅចំពោះមុខយើងទាំងអស់គ្នានៅថ្ងៃនេះដូច្នេះយើងសម្រាប់ អ្នករាល់គ្នាដែលបានសួរថាតើហេតុអ្វីបានជាពួកយើងត្រូវការសវនាការមួយទៀតនៅពេលដែលជនជាប់ចោតដែលមានវ័យចាស់ជរាបានទទួលការផ្ដន្ទាទោសអស់មួយជីវិតទៅហើយនោះចម្លើយគឺសាមញ្ញពួកយើងធ្វើនេះដោយសារប្រជាជនកម្ពុជារាប់លាននាក់តែបានស្លាប់ដោយសាររបបមួយនេះក្នុងកំឡុងពេល3ឆ្នាំ8ខែនិង20ថ្ងៃក្នុងរបបកម្ពុជាប្រជាធិបតេយ្យមានតែពួកជ្រាំមានតែសក្តិវិនាសនិងទុកព្រួយមានតែការឈឺចាប់និងសក្តិស្លាប់
ខ្ញុំបានទទួលស្គាល់ថាមានជនរួមជាតិជាច្រើនមានការឈឺចាប់នៅក្នុងរបបកម្ពុជាប្រជាធិបតេយ្យដែលបង្កឡើងដោយពួកបំផ្លាញស៊ីរួមទីក្នុងខ្ញុំសោកស្ដាយចំពោះទុក្ខលំបាកនោះហើយខ្ញុំសូមទទួលខុសត្រូវនៃសិលធម៌ចំពោះអំពើនេះដោយសារខ្ញុំជាមេដឹកនាំជាន់ខ្ពស់ម្នាក់នៃបកកុម្មុយនីសកម្ពុជា
នួនជាបានជម្រាបទៅចៅក្រមថាគាត់បានបង្គាប់ឲ្យមេធាវីរបស់គាត់ធ្វើពហិការមិនចូលរួមជំនុំជម្រះក្តីរហូតដល់ពេលវេលាសំណើប្តឹងដិតចិត្តរបស់គាត់ទៅលើចៅក្រមសាលាដំបូងពាក់ព័ន្ធទៅនឹងកំហុសឆ្គងមួយចំនួនត្រូវបានសម្រេចជាមុនសិននៅពេលក្រោយមកក្រុមចៅក្រមពិសេសមួយត្រូវបានបង្កើតឡើងនិងបានច្រានចោលសំណើប្តឹងដិតចិត្តរបស់នួនជាហើយមេធាវីការពារក្តីរបស់គាត់ក៏បានចូលរួមនៅក្នុងការកាត់ក្តីវិញធ្វើរៀងវងកញ្ចក់តែនៅចំពោះមុខអង្គជំរះនេះ ជនជាប់ចោតទី2គឺខៀវសំផតបានជម្រាបអង្គជំនុំជម្រះសាលាដំបូងថាគាត់បានបង្គាប់ឲ្យមេធាវីរបស់គាត់ចង់អារម្មណ៍តែទៅលើបណ្ដឹងសារទុកជាមុនសិនមុននឹងគាត់និងមេធាវីរបស់គាត់ចូលរួមនៅក្នុងការជំនុំជម្រះក្តីនៃសំណុំរឿង 002 វគ្គ 2
ការកាត់ក្តីសំណុំរឿង 002 លើ 01 អស់លោកបានកាត់ទុកខ្ញុំដោយផ្អែកលើទម្រង់ផតានិងការស្មាននានាដែលខ្ញុំជំទាស់ហើយដោយប្រើមធ្យោបាយដែលខ្ញុំយល់ឃើញថាជាការរំលោភលើសិទ្ធិរបស់ខ្ញុំដែលខ្ញុំត្រូវមានត្រូវបានទទួលការកាត់ក្តីដោយយុត្តិធម៌ ហេតុនេះហើយបានជាខ្ញុំបានជម្រាបមេធាវីខ្ញុំឲ្យប្រឹងឧស្សរដែលនៅក្នុងតុលាការនេះគេហៅថាបណ្ដឹងសារទុកសេចក្តីសំអាងហេតុនិងសេចក្តីសន្និដ្ឋានរបស់អស់លោកនៅក្នុងការកាត់ក្តីនេះបង្ហាញច្បាស់ជាមុនស្រេចទៅហើយអស់លោកនឹងសម្រេចយ៉ាងណានៅក្នុងការកាត់ក្តីសំណុំរឿង 002 លើ 02 ខាងមុខនេះគ្មានអ្វីគួរឲ្យខ្ញុំស្រពេចស្រពិលទេបើអស់លោកនៅតែប្រើរបៀបគិតគូរដែលខ្ញុំជំទាស់ទៅចំពោះមុខតុលាការកំពូល តាក់ទងនឹងការចោទប្រកាន់ថាខ្ញុំបានចូលរួមប្រព្រឹត្តសហអក្រិតកម្មរួមខ្ញុំដឹងជាមុនស្រេចទៅហើយថាអស់លោកប្រកាសជានឹងផ្ដន្ទាទោសខ្ញុំទៀតក្នុងការកាត់ក្តីដែលអស់លោកកំពុងតែបើកនៅថ្ងៃនេះ
នៅអំឡុងពេលនៃសវនាការអង្គជំនុំជម្រះសាលាដំបូងបានស្ដាប់ការបង្ហាញផុសតាងលើប្រធានបទស្ដីពីសហគមន៍ត្រាំកក់រួមទាំងមន្ទីរសន្តិសុខត្រាំងត្រច័ន្ទនិងការប្រព្រឹត្តលើពុទ្ធសាសនិកការដ្ឋានទំនប់1មករាការដ្ឋានសាងសង់ប្រលានយន្តហោះកំពង់ឆ្នាំងការដ្ឋានទំនប់ត្រពាំងថ្មការប្រព្រឹត្តទៅលើជនជាតិចាមនិងជនជាតិវៀតណាមមន្ទីរសន្តិសុខអូកន្សែងមន្ទីរសន្តិសុខភ្នំក្រោលនិងមន្ទីរសន្តិសុខស21និងការបោះសម្អាតផ្ទៃក្នុងការចេញបទបញ្ជាអំពីការរៀបអាពាហ៍ពិពាហ៍ លក្ខណៈនៃចំនួនប្រដាប់អាវុធនិងជាចុងក្រោយអំពីទូនាទីរបស់ជនជាប់ចោទនៅថ្ងៃទី11ខែមករាឆ្នាំ2017អង្គជំនុំជម្រះសាលាដំបូងបានបិទបញ្ចប់សវនាការលើកផុសតាងនៅក្នុងសំណុំរឿង 002 វគ្គ 2 ពាក់ព័ន្ធទៅនឹងបទចោទប្រកាន់ស្ដីអំពីឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិអំពើប្រល័យពូជសាសន៍និងការបំពានបំពានយ៉ាងធ្ងន់ធ្ងរលើអនុសញ្ញាក្រុងហ្សឺណែវ ប្រឆាំងទៅនឹងជនជាប់ចោទនួនជានិងខៀវសំផន
ប្រជាជនកម្ពុជាទូទាំងរបប
អង្គជំនុំជម្រះស្លាដំបងបានបើកសវនាការធ្វើសេចក្តីសន្និដ្ឋានផ្ទាល់មាត់បិទបញ្ចប់កិច្ចពិភាក្សាដេញដោលនៅខែមិថុនាឆ្នាំ 2017
រដ្ឋវិនិម្នាក់បានផ្ដល់សេចក្តីកម្មអំពីវិជាសនកម្មដោយ
សូមជម្រាបថាអង្គជំនុំជម្រះបានធ្វើសវនាការរយៈពេល274ថ្ងៃនៅក្នុងសំណុំរឿង002វគ្គ2និងបានស្ដាប់សេចក្តីកម្មសាក្សីចំនួន114នាក់ដើមបណ្ដឹងរដ្ឋប្រវេណីចំនួន63នាក់និងអ្នកជំនាញចំនួន8នាក់លើសពីនេះទៀតអង្គជំនុំជម្រះបានផ្ដល់ឱកាសឲ្យភាគីបង្ហាញភស្តុតាងជាឯកសារសំខាន់ៗពាក់ព័ន្ធទៅនឹងប្រធានបទសវនាការនីមួយៗនិងបានស្ដាប់ការបញ្ជាក់បន្ថែមរបស់សហមេធាវីនាំមុខតំណាងដើមបណ្ដឹងរដ្ឋប្រវេណីស្ដីពីការទាមទារសំណង នៅក្នុងអំឡុងពេលសវនាការនៅក្នុងសំណុំរឿង002វគ្គ2នេះមានសាធារណជនសរុបចំនួន 776,604 នាក់បានចូលរួមស្ដាប់ដោយផ្ទាល់នៅក្នុងសារសវនាការរបស់អង្គជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាអង្គជំនុំជម្រះសាលាដំបងនៃអង្គជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាបានប្រកាសសេចក្តីសម្អាងហេតុនិងផ្នែកនៃសេចក្តីសម្រេចនៃសាលក្រមនៅក្នុងសំណុំរឿង 002/02 ពាក់ព័ន្ធទៅនឹងជនជាប់ចោទនួនជានិងខៀវសំផនកាលពីថ្ងៃទី 16 ខែវិច្ឆិកាឆ្នាំ 2018 នៅក្នុងសារសវនាការធំនៃអវតក
អង្គជំរះស្លាដំបងរកឃើញថាជនជាប់ចោទនួនជាមានបរិបទដែលបានប្រព្រឹត្តនៅលើទឹកដីនៃប្រទេសកម្ពុជាចន្លោះថ្ងៃទី 17 ខែមេសាឆ្នាំ 1975 រហូតដល់ថ្ងៃទី 6 ខែមករាឆ្នាំ 1979 ដោយបានរៀបរាប់ដោយសង្ខេបខាងលើនេះនិងដោយលម្អិតនៅក្នុងសារក្រមជាលិលាអក្សរតាមរយៈអំពើសកម្មនិងអកម្មចំពោះអកតកម្មទាំងឡាយដូចខាងក្រោមអកតកម្មប្រឆាំងនឹងមនុស្សជាតិតាមរយៈការធ្វើមនុស្សជាតិការសម្លាប់រង្គាលការនិរទេសការធ្វើឲ្យទៅជាសតកការដាក់ក្នុងមន្ទីរឃុំឃាំងការធ្វើទុកបុកម្នេញដោយមូលហេតុនយោបាយការធ្វើទុកបុកម្នេញដោយមូលហេតុសាសនានិងការធ្វើទុកបុកម្នេញដោយមូលហេតុភូមិសាស្ត្រនិងអំពើអនុប្រព័ន្ធផ្សេងៗទៀតក្រុមទម្រង់ជាការប៉ះពាល់ដល់សេចក្តីថ្លៃថ្នូររបស់មនុស្សអំពើអមនុស្សធម៌ផ្សេងៗទៀតក្រុមទម្រង់ជាការបាត់ខ្លួនដោយបង្ខំអំពើអមនុស្សធម៌ផ្សេងៗទៀតក្រុមទម្រង់ជាការជំនះដោយបង្ខំនិងអំពើអមនុស្សធម៌ផ្សេងៗទៀតក្រុមទម្រង់ជាការរៀបអាពាហ៍ពិពាហ៍ដោយបង្ខំនិងការរំលោភផ្លូវភេទនៅក្នុងបទបទនៃការរៀបអាពាហ៍ពិពាហ៍ដោយបង្ខំអនុលោមតាមបទបញ្ញត្តិនៃវិធានមាត្រា 5 មាត្រា 29 ថ្មីនិងមាត្រា 39 ថ្មីនៃច្បាប់នៃពីការបង្កើតអវតកការបំពេញយ៉ាងធ្ងន់ធ្ងរលើអនុសញ្ញាទីក្រុងហ្សឺណែវតាមរយៈការធ្វើមនុស្សភាពដោយចេតនាការធ្វើទរណកម្មការធ្វើបាបដោយអវិធម៌ការបង្កដោយចេតនាឲ្យមានរបួសធ្ងន់ឬឲ្យមានការឈឺចាប់ដល់រាងកាយឬសុខភាពការដកហូតដោយចេតនាពីជ្រើសិទ្ធិឬជនស៊ីវិលនៅសិទ្ធិទទួលបានការកាត់ទោសដោយយុត្តិធម៌និងទៀងទាត់និងការឃុំខ្លួនជនស៊ីវិលដែលខុសច្បាប់អនុលោមតាមមាត្រា 6 មាត្រា 29 ថ្មីនិងមាត្រា 39 ថ្មីនៃច្បាប់ស្តីពីការបង្កើតអវតកឧក្រិដ្ឋកម្មបលាយពិសាសតាមរយៈការធ្វើមនុស្សឃាតលើសមាជិកនៃក្រុមជនជាតិវៀតណាមនិងជនជាតិចាមអង្គជំរះសាលាដំបងរកឃើញថាជនជាប់ចោទគឺសំផនមានពិរុទ្ធដែលបានប្រព្រឹត្តនៅលើទឹកដីនៃប្រទេសកម្ពុជាដោយចន្លោះពីថ្ងៃ 17 ខែមេសាឆ្នាំ 1975 រហូតដល់ថ្ងៃទី 6 ខែមករាឆ្នាំ 1979 ដោយបានរៀបរាប់ដោយសង្ខេបខាងលើអង្គជំរះបានពិចារណាទៅលើភាពធ្ងន់ធ្ងរនៃអកតកម្មរួមទាំងទំហំនិងភាពសាហាវព្រៃផ្សៃក៏ដូចជាចំនួននិងភាពទន់ខ្សោយរបស់ជនរងគ្រោះដែលជនជាប់ចោទត្រូវបានរកឃើញមានប្រតិភិបរួមទាំងស្ថានទម្ងន់និងស្ថានបម្រើទោសនានាដែលពាក់ព័ន្ធអង្គជំរះសម្រាប់ផ្ដន្ទាទោសជនជាប់ចោទនួនជាដាក់ពន្ធនាគារអស់មួយជីវិតដោយពិចារណាលើការផ្ដន្ទាទោសដាក់ពន្ធនាគារអស់មួយជីវិតចំពោះគាត់នៅក្នុងសំណុំរឿង 002/01 អង្គជំរះសម្រាប់រួមបញ្ចូលគ្នានៅការផ្ដន្ទាទោសទាំងពីរទៅជាការផ្ដន្ទាទោសដាក់ពន្ធនាគារអស់មួយជីវិតតែមួយអង្គជំរះសម្រាប់ផ្ដន្ទាទោសជនជាប់ចោទគឺសំផនដាក់ពន្ធនាគារអស់មួយជីវិតដោយពិចារណាទៅលើការផ្ដន្ទាទោសដាក់ពន្ធនាគារអស់មួយជីវិត ចំពោះគាត់នៅក្នុងតំរឿង 002/01 អង្គជំរះសម្រាប់រួមបញ្ចូលគ្នាលើការប្រន្ទទោសទាំងពីរទៅជាការប្រន្ទទោសដាក់ពន្ធនាគារអស់មួយជីវិតតែមួយ
សាធារណជនប្រមាណជាជាង 700 នាក់រួមមានតំណាងរាជរដ្ឋាភិបាលកម្ពុជាតំណាងអង្គការសហប្រជាជាតិនិងមន្ត្រីអង្គទូតអង្គការសង្គមស៊ីវិលនានារួមនឹងសាធារណជននិងអ្នកសារព័ត៌មានជាតិនិងអន្តរជាតិបានចូលរួមស្ដាប់ការប្រកាសសារក្រមជាប្រវត្តិសាស្ត្រនេះយើងខ្ញុំសូមរំលឹកសាធារណជនថានៅក្នុងដំណាក់កាលនេះបទចោទប្រឆាំងទៅនឹងនួនជានិងឃ្យូសំផននៅក្នុងសំណុំរឿង 002 វគ្គ 2 គ្រាន់តែជាការចោទប្រកាន់តែប៉ុណ្ណោះមិនទាន់មានការសម្រេចជាស្ថាពរនៅឡើយទេថាតើជនជាប់ចោទទាំងពីរមានទោសឬក៏គ្មានទោសជនជាប់ចោទទាំងពីរត្រូវបានសន្មត់ទុកជាមុនថាគ្មានទោសដរាបណាសាលដីកាស្ថាពរមិនទាន់ចូលជាធរមាននៅឡើយ អង្គជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាដែលគេស្គាល់ថាសាលាដីខ្មែរក្រហមត្រូវបានបង្កើតឡើងដើម្បីឆ្លើយតបទៅនឹងឧក្រិដ្ឋកម្មដែលបានប្រព្រឹត្តនៅចន្លោះថ្ងៃទី 17 ខែមេសាឆ្នាំ 1975 រហូតដល់ថ្ងៃទី 6 ខែមករាឆ្នាំ 1979 ជារយៈពេលដែលពលពតកាន់កាប់អំណាច ប្រជាជនយ៉ាងហោចណាស់ 1,700,000 នាក់ត្រូវបានជឿជាក់ថាត្រូវបានស្លាប់ដោយសារការធ្វើការងារហួសកម្លាំងការបង្អត់អាហារការធ្វើទារុណកម្មសម្លាប់និងលក្ខខណ្ឌរស់នៅដ៏អមនុស្សធម៌ដទៃទៀតសំណុំរឿង 002 វគ្គ 2 គឺជាការជំនុំជម្រះដីទី 2 ប្រឆាំងទៅនឹងអតីតប្រមុខរដ្ឋខៀវសំផននិងអតីតអនុលេខាបកកុម្មុយនីសកម្ពុជាលោកនួនជាជនជាប់ចោទទាំងពីរត្រូវបានបញ្ជូនទៅជំនុំជម្រះក្តីកាលពីខែកញ្ញាឆ្នាំ 2010 ដោយសារទំហំនិងភាពស្មុគស្មាញនៃបទចោទនាពេលរស់រានមានជីវិតរបស់ជនជាប់ចោទឬក្នុងពេលដែលជនជាប់ចោទនៅអាចជំនុំជម្រះក្តីបានដែលការបញ្ជូនរឿងទៅជំនុំជម្រះត្រូវបានបែងចែកជាការជំនុំជម្រះក្តីចំនួន 2 ដែលហៅថាសំណុំរឿង 002 វគ្គទី 1 និងសំណុំរឿង 002 វគ្គទី 2 ការជំនុំជម្រះក្តីដំណាក់កាលទី 1 ផ្ដោតសំខាន់ទៅលើបទចោទឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិដែលតាក់ទងទៅនឹងការជំនះដោយបង្ខំពីទីក្រុងភ្នំពេញកាលពីខែមេសាឆ្នាំ 1975 និងក្រោយមកគឺមានការជំនះពីតំបន់ដទៃទៀតក៏មានបទចោទតាក់ទងទៅនឹងការសម្លាប់អតីតទាហានសាធារណរដ្ឋខ្មែរនៅទួលពលជ្រៃនៅក្នុងស្រុកកណ្ដៀងខេត្តពោធិ៍សាត់អង្គជំនុំជម្រះសាលាដំបងនៃអង្គជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាហៅកាត់ថា អវតក បានរកឃើញនួនជានិងឃ្យូសំផនមានពិរុទ្ធពីបទឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិនិងបានសម្រេចផ្តន្ទាទោសពួកគាត់ដាក់ពន្ធនាគារអស់មួយជីវិតកាលពីថ្ងៃទី 7 ខែសីហាឆ្នាំ 2014
ទាំងការធ្វើមនុស្សភាពការធ្វើទុកបុកម្នេញ
សហព្រះរាជអាជ្ញាជនជាប់ចោទទាំងពីរបានប្តឹងសារទុកទៅកាន់អង្គជំនុំជម្រះតុលាការកំពូលហើយតុលាការកំពូលបានធ្វើសវនាការរួចហើយតាក់ទងទៅនឹងបណ្ដឹងសារទុកនៅក្នុងសំណុំរឿង 002/01 ព្រមទាំងបានស្ដាប់សក្ខីកម្មរបស់សាក្សី3រូបកាលពីថ្ងៃទី 2 ទី 3 និងទី 6 ខែកក្កដាឆ្នាំ 2015 នៅថ្ងៃទី 16, 17, 18 ខែកក្កដាឆ្នាំ 2016 អង្គជំនុំជម្រះតុលាការកំពូលបានធ្វើសវនាការស្ដាប់សារណាផ្ទាល់មាត់លើបញ្ហានានាដែលបានលើកឡើងនៅក្នុងបណ្ដឹងសារទុកនៅក្នុងសំណុំរឿង 002 វគ្គ 01 នៅថ្ងៃទី 23 ខែវិច្ឆិកាឆ្នាំ 2016 អង្គជំនុំជម្រះតុលាការកំពូលនៃអង្គជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាបានប្រកាសសាលដីការបស់ខ្លួនលើបណ្ដឹងសារទុកប្រឆាំងនឹងសាលក្រមនៅក្នុងសំណុំរឿង 002 វគ្គ 1 ដោយបានតម្កល់សាលក្រមរបស់អង្គជំនុំជម្រះសាលាដំបងផ្តន្ទាទោសនួនជានិងឃ្យូសំផនដាក់ពន្ធនាគារអស់មួយជីវិតសំណុំរឿង 002 វគ្គ 2 ដែលជាសំណុំរឿងបន្តពីសំណុំរឿង 002 វគ្គ 1 មានបទចោទជារួមគឺឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិ នឹងការរំលោភបំពានយ៉ាងធ្ងន់ធ្ងរទៅលើអនុសញ្ញាក្រុងហ្សឺណែវឆ្នាំ1949ព្រមទាំងឧក្រិដ្ឋកម្មប្រល័យពូជសាសន៍អង្គជំនុំជម្រះសាលាដំបងបានសម្រេចថាទីតាំងឧក្រិដ្ឋកម្មនិងបទចោទសំខាន់ដទៃទៀតខាងក្រោមនេះគឺជាមូលដ្ឋាននៃការជំនុំជម្រះក្តីសំណុំរឿង002 វគ្គ 2 អំពើប្រល័យពូជសាសន៍ទៅលើជនជាតិចាមនិងជនជាតិវៀតណាមការរៀបការដោយបង្ខំនិងការរំលោភសេពសន្តិវៈនៅទូទាំងប្រទេសការបោះសម្អាតផ្ទៃក្នុងឧក្រិដ្ឋកម្មដែលបានប្រព្រឹត្តនៅមន្ទីរសន្តិសុខចំនួន